What of sir? Audio is missing.
Vacating stay?
Vacating stay.
Then wait. Vacating, I'm asking something. Yes. Vacating stay, all the applications. Again, ಹೇಳಿ. Vacating stay, please give. Why all of you are waiting still? ಎಲ್ಲಾರ್ಗೂ 2:30 ಬೇಕಾ? ಜನರಲ್ ಅವಾರ್ಡ್ ಕೊಡಿ.
Not in this case.
What is that? No, tomorrow. CPC alva? Give it. Pending matter. It will come day after tomorrow according to this. Pressure pending, madam. So what? Why are you waiting then? Give the memo. Why? Correct. How is GMCPC maintainable then? 230 CRP ಆಗುತ್ತೆ. Let's see, give it. Why both of you are telling same matter, is it? Kodi. No, don't worry. Then she should not think what you have told is better. Give it. Yes. I 230. Kodi. Na tomorrow illa. Disbursement of memo for disposal. Kodi sir. No tomorrow. Sir. No tomorrow. Give it. Thank you. 2:30 ಗೆ ಆಗ್ತೀನಿ ವಿಡ್ರಾ ಮಾಡಂಗಿದ್ರೆ. Tomorrow illa. Withdraw ಮಾಡಂಗಿದ್ರೆ 2:30. Yes. Give. Why? Oh, here injunction is granted, is it, or in trial court? No problem. Give it. No 2:30. There is no urgency there. Give it. Yes.
My application has been partially allowed, and my client is age-old lady, really have witness.
No, give it, madam. Yes. No date. Give it. Yes. Kodi sir. Fresh matters alla ಕೊಟ್ಬಿಡಿ. I am not giving. Give it. Vacating interim order idru application. Give it. Yes. Why are you all waiting? Give the memos. 2:30 ಗೆ ಬೇಕಾ ಎಲ್ರಿಗೂ? 2:30 ಗೆ ಬೇಕಾ ಎಲ್ರಿಗೂ? ಕೊಡಿ. Tomorrow no ಇಲ್ಲ, 2:30 ಇಲ್ಲ ಕೊಡಿ. Designated days they'll come. Give it. No problem, madam. Give it. Yes. No, we'll give it. Which one? Tax matter. Tax matter will come on Thursday. Tax matters, please give the memos. Yes. Whatever it is. Give it. Give it. 2:30. 2:30 ಗೆ ಬೇಕಾ? Give it. Yes. Tomorrow ಇಲ್ಲ. Yes. Thank you. Give it, madam. Yes. It has become infructuous, is it? May become infructuous. No problem, madam. Give it. Yes. We'll see. Yes. ಈಗ ಕೊಡ್ತೀರಾ ಮೆಮೊ ಬೇಡವಾ? ಕೊಡಿ. Yes. We'll see. Give it, sir. Yes. Yes.
In this case, I'm for the plaintiff. Filed a suit for the declaration.
Fresh matter.
Please, declaration injunction. And my further evidence only for the limited purpose to mark the will and death certificate of my father was not permitted.
All
my
right.
application for recall and reopen was dismissed.
Correct.
Posted today.
Yes.
Posted
No
today
problem.
Posted today for main argument.
ಆಯ್ತು. 2:30 ಕೊಡಿ.
Please,
My lord, that's a matter pertaining to Bowring Institute.
Give it, sir.
It may be taken.
ಅದು ಬಂದಿಲ್ವಾ ಇವತ್ತು?
No, on Saturday, the court was on leave.
ಯಾಕೆ you did not move the other court?
The other court did not take.
ಆಯ್ತು. 2:30 ತೊಗೊಳ್ಳಿ ಮೇಡಮ್. Give it, madam. What has happened? Give it. We'll see. Yes. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಮೇಡಮ್. ಎಸ್.
My lord, suit for injunction, my lord. Trial court rejected my application.
Application for what?
Injunction, my lord.
Injunction, file an appeal.
My lord,
File an appeal, sir.
trial court, respondent trying to demolish compound wall.
File an appeal, sir. Give it, tax matters ಎಲ್ಲ ಕೊಡಿ.
Expert,
File an appeal.
expert order, my lord. Expert injunction, my lord.
ಕೊಡಿ.
Trying to demolish the compound wall, my lord.
Yeah, 230 ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Bank account has been attached. Kindly be posted on.
It will come, sir, tax matter.
My lord, 230.
Bank account attach ಆಗಿರೋದು ಯಾವಾಗ? When? Yesterday? Then give it.
My lord,
My lords,
So act as though everything has happened yesterday. Give it.
my lords, this is a tax matter directed to be listed on 7th of August. However, the bench was not.
It will come, sir. Give it.
My lords, the difficulty is that there
May
is
I
a
make one
control-
mention in this matter?
Ah,
May I make a mention in this matter which
You
my
want
learned
it today?
friend has mentioned? No, not today, my lord.
Then-
On Thursday,
fourth it will
for
come, give it.
directions, some directions have been given by.
ಅಲ್ಲ
this
fourth
honorable
ಗಿಂತ
court.
ಮುಂಚೆ ಬೇಕಾ?
ಇಲ್ಲ, fourth ಬೇಕು.
Fourth ಬರುತ್ತೆ ಕೊಡಿ.
My lords, if
But
I may
LAC
mention,
matter, final notification is not issued despite 26 years of issuance of
ಎಲ್ಲೇ
PL covered by
ನಾಳೆ
judgment.
ಕೊಡಿ. Yes.
my lords, I'm mentioning the CRP, there is an eye for vacating stay.
Vacating stay, give it.
The
Yes.
trial court in fact has been saying that they'll dismiss
Vacating
my.
stay, give it.
My lords, the CRP days.
Vacating stay, give it. Yes.
Plus 230 millets, 482 fresh matter millets.
Give it, give it.
Rowdy sheet.
Vacating stay.
Is being proposed millets.
Vacating
Tomorrow
stay.
is summoned to the police.
Yeah, summon to the police station. Go and come.
To give explanation as to why.
Madam, on CRP vacating stay.
No problem.
Madam, on CRP
Madam,
vacating stay.
ಶ್ರೀದೇವಿ ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಿ 2:30.
CRP vacating stay.
My lord,
ವಾಟ್ ಥ್ರೆಟ್ ಸರ್? ಅದಕ್ಕೆ ಥ್ರೆಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಏನ್ ಹಲ್ಲೆ ಮಾಡ್ತಿದ್ದಾರೆ? ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೇಳಿ. ಅದೇ ಬೇಡ, ಡೋಂಟ್. ಇಲ್ಲಿ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಡಿ, ಕೊಡಿ. ಅದೇ ಡೇ ಆಫ್ ಟುಮಾರೋ ತಗೊಳ್ಳಿ. ಗಿವ್ ದ ಮೆಮೋಸ್ ಸರ್.
my lord.
You please give the memos. 2:30 ಯಾವ್ದಿಲ್ಲ ಅಲ್ವಾ? Please give the memos. No date. No date in any matter. Please give the memos. Please give the memos, sir. Tax day ಬರುತ್ತೆ, CRP day ಬರುತ್ತೆ, ಕೊಡಿ.
My lord.
2:30 ಏನು? $2:30. ಏನು? ಯಾವ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಯಾವಾಗ ಸರ್? ಯಾವತ್ತು ಸರ್, ಯಾವತ್ತು?
2 weeks back, my lordship.
ಹಾ.
ಏನಂದ್ರೆ respondents ಬಂದು execution petition file ಮಾಡಿದ್ದಾರೆ. ನಾವು 3 days back memo ಮಾಡಿದ್ವಿ.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಏನು 2:30 ಏನಾಗಲ್ಲ ಕೊಡಿ ಸರ್.
My lord.
Sir, ನಾಳೆ ಇದೆ sir trial court.
So what sir? No problem sir. No problem sir. ಕೊಡಿ sir. Yes.
My lord.
Give it sir, day after tomorrow. Day after tomorrow. Yes.
My lord.
ಬೇಕಾದ್ರೆ ಅದು ಕೊಡಿ day after tomorrow. Why are you surprised? I'll post it after 2 weeks. All right? Wait.
My lord.
You want me to adjust to the trial court proceedings? Then wait. Yes. Sorry? Medical parole. ನೀವು ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Is he back to the goal? Then file a fresh parole petition. Then give it. Yes. Kudi, other review I am not taking. Don't move it. Yes. File challenge it before the SLP. Yes. If you argue the matter, we'll take it. All senior counsel ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಅಂದ್ರೆ ಆಗಲ್ಲ ಅದೆಲ್ಲ. ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅವರೇ ಅಪಿಯರ್ ಆಗ್ಬೇಕು. Yes, give it. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮ್ಯಾಟರ್ ಏನ್ ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ನಾ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಕರೆಕ್ಟ್. ಆ ಟೈಮಲ್ಲಿ ಹಾಕಿದ್ರೆ ರಿಜೆಕ್ಟೇ ಆಗೋದು. ಕೊಡಿ, ಏನಾಗಲ್ಲ. ಎಲ್ಲ ಸುಮ್ಮನೆ ರೂಲ್ಸ್ ಟು ಡ್ರ್ಯಾಗ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ಕೊಡಿ. ಎಸ್.
My lord.
Rejected. Petition rejected. You want to move it. Give it. Yes. It will come next week. Barli bidi. Wait. Just now. Other number iralla alli. ಯಾಕೆ? ಏನ್ 26/9? Suit for. ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ, ಬರುತ್ತೆ. ಯಾವ್ದು ಮೇಡಮ್ ಇದು? ಯಾವ್ದು ಮೇಡಮ್? ಓಕೆ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ 230 ಯಾರು ಮೂವ್ ಮಾಡಿ? PN ರಾಜೇಶ್ವರ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಇದು. ಇದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಬರಲ್ಲ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಿದ್ರು ಬರಲ್ಲ. ಎಸ್. ವೆಕೇಟಿಂಗ್ ಆದ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ. ಎಸ್. ಕೊಡಿ ಅದು ಮಿಕ್ಕಿದ್ ಕೊಡಿ. ಕೊಡಿ 5ನೇ ತಾರೀಕು ಹಾಕೋಣ. ಕೊಡಿ ಖಂಡಿತ 5ನೇ ತಾರೀಕು ಹಾಕೋಣ. Give it, vacating stay there, give it.
It's a tax matter on.
ಈಗ are you going to give all the memos or I'll start calling the cases? No mentioning, enough, give the memos now. 230 no other matter, please give it.
Covered by judgment.
Give the memo, sir.
Covered by judgment.
Give the memo. All of you give the memo.
My lord.
Give the memo, sir.
Covered by judgment.
Maybe, sir, give it.
Covered by judgment. My lord. The petitioner is.
Memo ಕೊಡಲ್ವಾ? ಕೊಡೋಂಗಿದ್ರೆ ಕೊಡಿ. Call the cases, madam.
Petitioner is a 90 years old, my lord.
Maybe, sir, give it.
Kindly, my lord. Covered by judgment.
300 cases are there. 11 o'clock ಅವ್ರಿಗೆ ಬರೀ ಮೆಮೋನೇ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಆಗತ್ತಾ? ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್.
230
ಎಲ್ಲ ಕೊಡಿ. 230 ಯಾವ್ದಿಲ್ಲ ಕೊಡಿ.
230 ಅರೆಸ್ಟ್ ವಾರೆಂಟ್.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇದ್ರೆ ಯಾವ್ದು ಕೊಡಿ ಅದು. ಎಸ್.
Covered by judgment.
ಈಗ ಕೊಡ್ತೀರಾ ಇಲ್ಲ ಮೆಮೋ? ಏನ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಕೊಡಿ ಪರವಾಗಿಲ್ಲ.
My lord.
ಆಯ್ತು ಕೊಡಿ 230.
Covered by judgment. The petitioner is a 90 years old, my lord.
No problem, sir. Yes.
I'm kindly have it on tomorrow.
No, sir. Yes.
I moved a memo, first matter, my lord. Trial court ಅಲ್ಲಿ 6-9 ಇದೆ.
ಪರವಾಗಿಲ್ಲ.
For party.
No.
My lord, the matter is posted for judgment on day after tomorrow.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
It is a miscellaneous petition filed before the trial court, my lord.
Ah.
I have filed an impleading, I being a earlier committee member, filed a impleading application. They have not made me as a party, my lord. That impleading application has been rejected.
ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಎಲ್ಲ ಸೇರ್ಸಿ ಅಪೀಲ್ ಹಾಕೊಡಿ.
My lord, even land
ಟೈಮ್ ಅಲ್ಲಿ ಲೈನ್ ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ.
my land which was not acquired, my lord, and no compensation which was paid, but the BDA was utilized my entire land, my lord. I am a 90 years old, my lord.
So what, sir? 90 years ಎಲ್ಲರೂ ಇದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ,
ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದನ್ನ ಪ್ರೊಜೆಕ್ಟ್ ಮಾಡ್ಲೇಬೇಡಿ ನೀವು. ಕೊಡಿ. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ. ಬರುತ್ತೆ ಬಿಡಿ.
Judgment also I am.
ಬರುತ್ತೆ ಬಿಡಿ. Yes.
Pending matter, my lord. 2 times I moved the memo, my lord. But
No problem. You move another 8 times, then you will get seniority.
Your
Yes.
lordship,
18
your lordship has
No problem.
also directed it to be listed last week.
No, sir, give it, give it.
But
Yes.
tomorrow,
No, sir. No.
tomorrow.
No, sir, give it.
With your lordships kindly, my lord, I may kindly request for this, for.
Yes, Nisha madam, ಏನು?
My lord, the orders have not been uploaded in that.
Which one?
Wherein the clarification application was filed, my lord. It's almost 2 months.
Let
My
me
lord,
see.
I
I'll check
place-
it, madam. I'll check it. Yes.
My lords,
You have any other request?
my lords,
No, my
one
lord.
request of my,
Yes,
Obliged.
madam. Yes,
Wait.
madam.
my lords, one request,
Maybe. So what? Give it.
my lords,
No, madam. Give it.
my lords, one request. I moved a tax writ petition. It's a fresh matter,
It
my
will
lords.
come only on 4th, sir.
Yes, my lords.
Then
Unfortunately,
please
sir.
move, sir.
Yes, sir.
Yes.
List number 277,
Ah.
petition has become infructuous.
Thank you, sir. ಕೊಡಿ. ಏನ್ 2197 ಏನು? ಏನ್ ಪರಲ್ಲ ಕೊಡಿ. ಇರ್ಲಿ ಬಿಡಿ. ಕೊಡಿ ಕೊಡಿ. No, sir. 230 ಕೊಡಿ. Yes. No, no, please. Sir. Yes, give it. Yes. Thank you. Vacating stay, give it, sir. Yes. Fresh matter ಇದ್ರೆ ಕೊಡಿ. Fresh matter ಇದ್ರೆ ಕೊಡಿ, sir. ಎಲ್ಲ ಮಂಡೇನೆ ಕೊಡಿ. ನೀವೇ 5th ಬೇಕು ಅಂದ್ರಲ್ಲ. 4th ವಿಲ್ ಸಿ. 4th ಬೇಕು ಅಂದ್ರೆ 3rd ಮೂವ್ ಮಾಡಿ. 3rd ಮೂವ್ ಮಾಡಿ. ಇವತ್ತೇ ಆದ್ರೆ ಮೆಮೊ ಕಳೆದೋಗ್ಬಿಡುತ್ತೆ. ಅಲ್ಲ 3rd ಮೂವ್ ಮಾಡಿ ಸರ್. I call the case.
One preliminary hearing, still number 1.
ಗಂಗಿರೆಡ್ಡಿ ಅವರೇ CRP ಹಾಕಿ. GMCPC ಬರಲ್ಲ. 711 ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿರೋದು. ಕ್ಲೈಂಟ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಫೈಲ್ CRP. ಫೈಲ್
Client reject
ಅಲ್ಲ.
This is an application filed on Order 7 Rule 11D.
ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
That application rejected, that is pending before the.
ಅಯ್ಯೋ ಕರೆಕ್ಟ್ ಸರ್. ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿ GMCPC ಬರಲ್ಲ. CRP ಹಾಕ್ಬೇಕು.
The last occasion it was overruled, the opposite objection.
ಓವರ್ರೂಲ್ಡ್ ಇಲ್ವೇ ಇಲ್ಲ. CRP ಹಾಕಕ್ ಯು ಕಾಂಟ್ ಫೈಲ್ GMCPC an application that is rejected. CRP ಬರುತ್ತೆ. Yes. The petitioner calls in question An order of the concerned court rejecting a commercial suit alla tane? An order of the concerned court rejecting an application under Order 7, Rule 11, D of the CPC. The order rejecting an application while rejecting an application under Order 7, Rule 11D is a revisable order. Therefore, the petitioner, petition convert ಮಾಡಿ ಇದನ್ನೇ. Therefore, the petitioner is permitted to convert the subject petition to that of a CRP in the event CRP list the matter next Thursday ಹಾಕಿರಿ ಮೇಡಮ್. Next ಅಲ್ಲ Friday in preliminary hearing, in admission for statistical purposes. Next.
Number 2.
I pay for the petitioner's counsel. I am permitted to withdraw the petition.
Thank you.
Matter become
38.5 ಆಗೋಗಿರುತ್ತೆ. Learned counsel for the petitioner seeks leave of this court to withdraw the petition disposed as withdrawn. Files a memo. Yes.
Still number 3.
Petitioner method. So order under challenge is a compromise,
The
method.
petitioner to serve on the serve the respondent plaintiff by way of hand summons. The rights created to the plaintiff or the parties, rights created to the parties in terms of the compromise compromise will not be disturbed merely because the subject petition is pending or notice is issued. Subject to the aforesaid, serve on the plaintiff note hand summons.
Date may be fixed, my lord.
No, sir. Put up immediately after service of notice. 22 compromise ivaga ಮತ್ತೆ date. Yes. Next.
P1 date launch.
P1.
Date launch. Petitioner.
Hey, Vidu. Yes, Chandranath. First petitioner is dead.
Legal representatives are
Already on record.
Yes, ma'am.
4.
Advocate for petitioner, my lordship.
Miscellaneous petition dismissed.
Yes, my lord.
Huh.
So, press time. At press time, my lordship.
Michael, I guess.
Press time, my lord. Petition.
1 week time beka.
Yeah.
Counsel for the petitioner seeks a week's adjournment. List the matter after 4 weeks. Next.
5.
Defendant's writ petition, my lords. An application under order 22 rule 5 was filed.
Correct.
My lords, the order under challenge, my lords, holds that the alleged LR is the legal representative on the basis of earlier orders. Now, my lords may kindly see that
Second
no
prayer
such-
will grant 1 year disposal. Otherwise, no other prayer. Serial number 5 alva?
How this one?
Yes, sir.
Allah, the difficulty is only this. There is no, the inquiry is held. There is no finding rendered.
Yes. Anything else?
My lords, if second prayer is granted, my lords, I am fine with it. For conducting an
ಅಲ್ಲ
inquiry. my
ಎಂಕ್ವೈರಿ
lords.
ಅಲ್ಲ ಇನ್ನೊಂದು ಡಿಸ್ಪೋಸಲ್ ಕೇಳಿದ್ರಲ್ಲ ಅದಲ್ಲ.
ಇಲ್ಲ, I have not sought for disposal.
Then we'll take issue notice.
Really,
Petitioner-
the difficulty is this, my lords. Annexure A, my lords, holds that he is the LR, but how on the basis of previous orders. However, my lords, there is no such order which holds the present alleged LR as the
Order
legal
is
representative.
18 months old.
My lords,
Order is 18 months old.
please, my lords, I had not moved the matter in view of the fact that there is a connected matter wherein a stay has been granted.
Number
9977.
ಬರ್ಕೊಡಿ. Tag this petition along with so and so.
May I kindly request a date, my lords?
No, sir. Next. ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ stay ಬಿಡಿ.
I may be permitted to serve the counsel appearing.
Current counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings. Next.
Lords, notice may be dispensed with insofar as 2 to 18.
Memo.
I will furnish.
Yes.
6.
Chikkathammaya. No representation on behalf of the petitioner. List after 2 weeks. Yes, next.
7.
Plaintiff's writ petition, my lord.
Will grant status quo here. Heard the learned counsel Madhusudan Rao appearing for the petitioner. There is no representation on behalf of the Kaiweta respondent. The objections, if any, be filed by the next date by the respondent. Till such time, parties to maintain status quo list the put up the matter immediately after filing of the objections. Yes, next.
8.
Amendment application has been filed.
Why in RA?
My lord, what happened? That sale deed was discovered during the pendency of the RA.
The petitioner shall serve on the counsel who represents the respondents in respondents before the first appellate court and file an acknowledgement of such service by the 15th of September. The Learned counsel appearing for the petitioner submits that the application, though was preferred at the appellate stage, it ought to have been allowed as it would cut at the root of the matter. The discovery of the said document happened only during the pendency of the appeal. Therefore, further proceedings before the first appellate court shall remain stayed. List on 22nd in preliminary hearing. Next. Well, 22nd Friday, Monday in Madam Madhu. Yes. Next.
9,
Appear for respond number 1, my lords. 9.
Petitioner. Acquisition under the land. Notice on. Yes. When are you appearing for the first respondent?
First respondent, my lords.
Who are the others? BDA?
State.
State, 4 Sudarshan Suresh, 2 and 3 HCGP, 1 is already on record. Objections, if any, by the respondents. List on 23rd.
Obliged, my lords.
Next.
10,
Petitioner. Petitioner here shown in Annexure D. Page
The
number.
petitioner is before this court calling in question an order which rejects an application filed by the petitioner seeking amendment of, seeking filing of the written statement. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that though there was delay in filing the in seeking to file the written statement, the delay was clearly explained, and the concerned court has, on technical reasons, rejected the said plea. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. List the matter on 22nd. Will impose 10,000 rupees costs and allow written statement. Yes. Petitioner to serve on the counsel who represents the respondent / contesting respondent before the concerned court and file an acknowledgement. Yes. Next.
11,
Lords, for the petitioners, my lord. Lords,
Ex parte order.
Ex parte order. My registration was cancelled way back in 2022.
Yes, Jyoti madam.
My lord, they are asking demand back, my lord, to take the contention, fresh contention.
Fresh
After-
contention. Ex parte order.
What happened? Registration cancel admele, we have the pending period, we have issued the notice to his portal, but he didn't attend. So he is claiming that because of cancellation of registration, I didn't.
I had
registration cancel admelu attend madidre.
ನಂಗೆ legal obligation ಇಲ್ಲ. Hence I did not file. And further there is barred by limitation also, my lords. Notification number
ನಾವು ಇಮೇಲ್
956.
ಕಳಿಸ್ತೀವಿ ಮತ್ತೆ ಪೋರ್ಟಲ್ ಅಲ್ಲೂ ಹಾಕ್ತೀವಿ ಆಸ್ ಯೂಶುವಲ್ ಆಗಿ. ಅದು
ಕರೆಕ್ಟ್ ಕ್ಯಾನ್ಸಲ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ರಿವೋಕ್ ಮಾಡಿ ಕಳಿಸಿದ್ರೆ ಸರಿ.
Admittedly, it's not revoked.
Revoked. I leave it to you.
I'm not seeking for revoke, my lords. Let it be remanded subject to the outcome of the Supreme Court with respect to SLP.
ಯಾವ್ದು?
Notification number 9, that is challenge, which extended the timeline.
Page ನೋಟಿಫಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
Notification. Copy.
ಈಗ ಅರ್ಜೆನ್ಸಿ ಇದೆ, 4th ತಗೊಳ್ಳ?
Hello?
4th ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ?
Sent back ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
Sent back ಅಷ್ಟೇ.
Sent back with all contentions kept open.
We'll say
Yes, ma'am.
yes. The petitioner is before this court seeking the following prayer. The petitioner is a contractor by profession and had a registration of had a GST registration. Owing to certain factors of the why was it cancelled?
My lords, it was cancelled.
The registration comes to be cancelled by an order dated 23/1/2024, after which a show cause notice comes to be issued imposing imposing penalty na idu?
They're saying
Comes to be issued demanding an amount of rupees 7,65,859, including interest and penalty on the non-payment of GST. By then the GST registration itself stood cancelled. Therefore, the petitioner did not appear before the concerned authority or file a reply to the show cause notice so issued on 30th January 2024. This led to passage of the impugned order dated 22/3/2024, which is admittedly an ex parte order, as the petitioner did not appear before did not file his reply to the show cause notice dated 30th January 2024 on account of the cancellation of GST. The learned counsel would now contend that If an opportunity is, if an opportunity is rendered, he would submit his reply to the show cause notice, and all the proceedings be subject to result of the apex court ಯಾವ್ದು? So, result of the apex court so and so, wherein
4240 of.
wherein the circular of circular LC clause CL ಇದೆ anyway, wherein the circular is under challenge. ಇದೊಂದು ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. So the learned counsel, learned HCGP, though would submit that the petitioners have not appeared before the petitioner has not appeared before the concerned authority or submitted a reply to the show cause notice, would admit the fact that the registration of the petitioner had stood cancelled on 23/1/2024. In that light, it becomes an admitted fact that the proceedings which has led the petitioner lay a challenge before this court are ex parte proceedings and are in violation of principles of natural justice. In that light, to afford an opportunity to the petitioner, the matter stands remitted back to the which one the respondent.
At the stage of show cause notice.
Reply to the.
One nimisha. Stands remitted back to the first respondent. Is it?
Number 1.
To the first respondent. First respondent, the petitioner shall now furnish remitted back to the first respondent from the stage of submission of reply to the show cause notice. The petitioner shall now submit the reply to the show cause notice, and the concerned authority, first respondent, shall take the issue to its logical conclusion, regulating its procedure, ordered accordingly.
All contentions to be kept.
All contentions except the one considered here and above shall remain open.
Obliged, my lord.
Yes.
12,
Is the suit dismissed?
Suit dismissed under one.
Suit is dismissed. my lord.
Dismissed on ground that there is no cause of action against defendant number 3. I had filed the suit for permanent injunctive actions, defendant number 1. Thereafter, during the pendency of the suit, defendant number 1 filed an application to.
Let him file his objections.
I'll file my.
The learned counsel, keep it hakidira. Learned counsel HS Suhas seeks 2 weeks time to file his statement of objections. Lest the matter.
Interference, until that I had sought for interference.
So and so. Suit dismiss agide adla entry ಮಾಡಿ. Next, yes. List the matter on 25th. Next.
13,
Sorry, 24th.
Petitioner. Petitioner has filed the suit for partition and the declaration before the court. The respondent number 4 has filed an application and order 7 to 11.
ಅದು court fee ಕೇಳಿದಾರೆ.
Court fee ಬಗ್ಗೆ ಅಷ್ಟೇನೆ. In a suit for partition, your lordship has held that as per the section 35 subsection 2 as to court fee has to be determined. Despite of the reason.
The petitioner shall serve on the counsel who represents the ಯಾರಿದ್ದಾರೆ respondents before the concerned court.
Maybe
ಒಬ್ರೇ ಅಲ್ವಾ?
Notice to the respondent 1 to 3 may be dispensed.
Contesting ಯಾರಿಲ್ವಾ?
A fourth defendant is the contesting man.
Memo ಕೊಡಿ.
Even we filed the.
The petitioner shall serve on the counsel who represents the fourth defendant who is said to be the only contesting respondent before the concerned court. List the matter on 22nd. Further proceedings before the concerned court shall remain stayed till the next date. Next.
I had seek for the stay of the further proceedings.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀಗ?
ಅಲ್ಲಿ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
ಈಗ ಕೊಟ್ಟಿದ್ದೇನು ಸ್ಟೇನೇ ತಾನೆ?
ಕೇಳಿಸ್ತಿಲ್ಲ ಸಾರಿ.
Yes, sir. 14.
14,
No representation on behalf of the petitioner. List after 4 weeks.
15,
Sir, FDP stay ಆಗಿದೆಯಾ?
stay ಆಗಿದೆ ಮೆಂಬರ್ಶಿಪ್.
Petitioner to serve on the counsel who represents the contesting ಯಾರು? ಎಲ್ಲರೂ?
ಎಲ್ಲರೂ.
Petitioner to serve on the counsel who represents the respondent plaintiff or the other defendants and file an acknowledgement of such service. List the matter on 22nd.
Further.
No, sir. Yes. FDP will not stay mad. Yes.
Petition is my lord.
Consent award.
Please, my lord.
Learned, alva.
Consent award.
Consent award alva.
Please. It's a consent award. My lords may kindly come to annexed.
Page 59 covered alva.
It's a consent award.
It's sorry. Anyway, learned HCGP is directed to accept notice for the respondent. 1, 2 and 3 Ajay Kumar. Sachin Haki. Learned counsel B.S. Sachin is directed to accept notice for respondents 2 and 3. Petitioner to serve set of papers upon the aforesaid counsel. List on 23rd.
Obliged.
Next.
17.
I am up here for the petitioner. I am filing memo for conversion, my lord. Because, my lord, I have challenged.
Conversion yavudakke?
My lord, for MFA, my lord, because I have to file a MFA.
Learned counsel for the petitioner files a memo seeking conversion of the subject petition to that of a miscellaneous first appeal, as what was necessary to be filed was a miscellaneous first appeal and not the subject petition. In that light, the petitioner is permitted to convert the same into a miscellaneous first appeal for the statistical purposes stands disposed. Next.
18.
Yes, I have a petitioner, Your Honor. The petitioner land has been acquired by the
Correct.
respondent, Your Honor.
The learned HCGP is directed, state, yaar appear aagtare? Learned counsel for the petitioner shall serve on any panel counsel representing the respondent and file an acknowledgement of such service with requisite set of papers and file an acknowledgement of such service. List the matter on 23rd. Next.
19.
I will undertake to file wakalat for
Learned counsel so and so
15.
undertakes to enter appearance for
Respondent 1 to 15.
respondents 1 to 15. The registry to print the name of so and so is appearing for respondents 1 to all the respondents.
Not 1 to 15.
1 to
15.
8 jana idare.
17 ಇದ್ದಾರೆ ಗೌರ್ಮೆಂಟ್ ಮತ್ತೆ KEDB.
17 ಎಲ್ಲಿದ್ದಾರೆ? ಯಾವ petition ಇದೆ?
Sorry,
19. ಅದು ನಿಮ್ 20 sir.
Sorry.
Yes. No representation by of the petitioner. List after 2 weeks. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
20.
My lords, defendant's petition, my lords. The application under 6 to 17 has been allowed. Now the thing is, my lords, a suit for declaration by way of easementary possession. But now during the pendency of the suit, with a notification of 2020, 20 and 21, the government road has been found, my lords. So if my lords agree to refer it to mediation, it can be settled. The whole suit itself can be put into an end, my lords.
ನೀವು ಯಾರಿಗೆ?
16.
KIDB. The registry to print the name of so and so appearing for the KIDB. Learned counsel
Jwala Kumar 1 to 15.
so and so accepts notice for respondents 1 to 15. The learned counsel for the petitioner submits that if the parties are referred to mediation, there could be chances of settlement and complete closure of the proceedings. In that light, the party shall appear before the mediation on at the so and so before the mediator on last week 12th September agbodu. On 12th September at 3 p.m. List the matter on 15th September.
Published.
Ajit, concurrent.
Lords, there are only, lords, I would only persuade my lords only on this count. There are 2 sale deeds in my favor. Schedule A. Schedule B, my lords, was granted under the Land Reforms Act. But, my lords were to indulge my lords status quo at least, my lords. Early disposal.
ಅದು ಮಾಡ್ಬೋದು. Suit 24 ಎಲ್ಲ disposal. As expeditiously ಹೇಳ್ಬೋದು. The petitioner is before this, petitioner is the plaintiff, is before this court calling in question twin orders. One, an order rejecting grant of an injunction by the trial court in answer to an application in Order 39 Rule 1 and 2. And the other, the order of the first appellate court, which affirms the order of the trial court which had refused to grant injunction answering the aforesaid application. A perusal at both the orders would indicate that they are on rendering cogent reasons. The injunction is rejected or the rejection of injunction is affirmed by the first appellate court. In that light, the petitioner is at liberty to urge all the contentions before the concerned court, and the concerned court shall endeavor, partition suit alla tane? Concerned court shall endeavor to conclude the proceedings with an outer limit, conclude the proceedings as expeditiously as possible, as the suit is only for injunction. Ordered without the aforesaid observations, without interfering with the orders, petition stands disposed. Next.
22.
Partial rejection of plaint.
Partial rejection.
Partial rejection.
The petitioner shall serve on the defendants.
Kolar ide, so emergent.
ಯಾರ್ಯಾರಿಗೆ?
1 to 17 ಸಾಕು.
1 to
17. ಅಲ್ಲ 1 to 17 ಮರು rest of that dispense ಮರು 22.
Memo ಕೊಡಿ. The petitioner shall serve on the counsel who represents
14 ಮರು.
defendants 1 to 17.
1 to 14. 1 to 14.
1 to 14 and file an acknowledgement of such service by the 8th of September. List the matter on 22nd, list the matter on 19th September. If there shall be an interim order of stay of further proceedings before the concerned court on this score, that the application filed by the petitioner is answered partially. The application was one for rejection of the plaint and Order 7 Rule 11 of the CPC, which could not be answered partially, and there cannot be a partial rejection of the suit. Yes, next.
15 to 22 dispensation.
Memo. Kotre matra dispensed.
Petition. The petitioner's land, only 2 acres of land has been utilized. Another 4 acres of 5 acres of land.
Alternate sites.
Incentive scheme.
Right.
Mudamar.
R2 GB Sharath Gowda is directed to accept notice for the second respondent, HCGP 1, petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 23rd.
ನಾವು ಅದರಲ್ಲಿ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂತ
ಇದಾರ. ಎಸ್, ಇದ್ರಲ್ಲೂ ಎಲ್ಲದರಲ್ಲೂ ಸ್ಟೇ ಕೇಳಬೇಕು ಅಂತ ರಿಚುವಲ್
ಸ್ಟೇಟಸ್
ಎಸ್ ಇದ್ರೆ petitioner in the event of need is at liberty to move the matter.
Please.
Yes.
24.
The date.
Liberty to move the matter 23rd ಆಗ್ಲೇ ಹೇಳಿದೀನಿ.
Fresh matter.
You ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ನಿಮ್ದು ಏನೇನ್ ಡಿಮಾಂಡ್ಸ್ ಇದೆ ಅಂತ. ಆಮೇಲೆ yes.
This matter I pay for the petitioners. Petitioner property is acquired in the year 2002.
Correct.
And now they have issued the endorsement. Priority allotment cannot be made on time.
1 AGA 2 and 3 Murugesh Charati, petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 16th.
25.
For petitioner in this matter, my lord.
39-4 rejected. ಯಾರು ನಿಮ್ದೆ ಕೇಳ್ತಾ ಇರೋದು ನಾನು.
Please, my lord. I and 39-1 is rejected. 39-4 is also rejected. Thereafter, has filed on another application.
Appeal, file appeal.
ಫೈಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಇದು ಯಾಕೆ ಸರ್ ಎರಡೆರಡು?
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ಅಲ್ಲಿ ಪೆಕ್ಯುನರಿ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಬರಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದನ್ನ? ಅಪೀಲ?
ಹೌದು.
ಅಪೀಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ.
ಹೌದು, ಅದು ಬರ್ದಿದ್ದಾರೆ ಸರ್. ಕೈಂಡ್ಲಿ ಐ ವುಡ್
ಕೊಡಿ.
ರೀಡ್ ಇಟ್ ಮೈ
ಇದು ಕೊಡಿ ಮೇಡಮ್.
ರಿಜೆಕ್ಟೆಡ್ ಅಪೀಲ್.
ಅಪೀಲ್ ಹಾಕಿದ್ರಾ?
ಹೌದು. MA ಫೈಲ್ಡ್.
MA ಇಸ್ ರಿಜೆಕ್ಟೆಡ್.
25 ಲಕ್ಷಕ್ಕೆ
ಆರ್ಡರ್ ತೋರಿಸಿ.
ತೋರಿಸಿ.
10 lakhs.
Page number 83.
One moment, sir.
83 and 84.
Petitioner to serve on the counsel who represents the respondent plaintiffs before the trial court and file an acknowledgement of such service. List the matter on 15th. Serve ಮಾಡ್ಬಿಡಿ, 15 dispose ಮಾಡಿ.
Much obliged.
Yes, next.
26.
List the matter on 18th. Interim order there. List the matter on 18th. Interim order subsisting will continue to the next date of hearing. Next.
27.
Appear for the petitioner, same my lord.
Same, yes, same order. 25 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ? ಎರಡು ಒಂದೇ ದಿನ ಹಾಕಿ. Yes, next.
28.
Much obliged.
Sir, transfer petition.
Correct. This, yes, sir. How can this be done?
But both are suits for partition. They can be tried together is what I'm saying.
No, there are 3 suits, Allah.
One suit is dismissed.
Dismissed.
Is 1029 is dismissed. 218 is dismissed.
We'll direct them to be heard together.
Yes, but that's all.
My lord, this was
What's the problem?
Case was arose before a civil miscellaneous petition, my lord. This writ is not maintainable.
Writ is not maintainable.
Yes, my lord. A receipt.
Section 24, my lord, was rejected.
Section
24
my
rejection
lord.
meleno.
It's a writ only, my lord. Nothing
Alam,
else.
my lord, it is section, any proceedings before filed under section 24 of CPC is treated as a separate proceeding itself. And not as an IA,
Yes, sir.
wherein
He appears
GMCPC
to-
It
wouldn't
says
be
it's a
coming.
case decided, therefore revision must be made.
It may be
It's all what
made
he
as a
says.
Revision.
Even then, writ can also be considered by this court.
Fine, convert this.
I'll convert it.
Yes. Conversion. Yes.
29.
As for the petitioner, matter register has shown a rank classification. Instead of GM res, it's shown a GM CPC.
GM res ಆಗ್ಬೇಕಾಯ್ತು. Learned counsel for the petitioner submits that the matter has to be posted before the appropriate court. Court having appropriate roster, the classification is wrong. It is GM res and not GM CPC. Yes. Registry is directed to post the matter before the appropriate court. Next.
It would appear for the petitioners. Petitioners are the plaintiffs before the.
711.
711, no? ಅದೇನಾಗಿದೆ 711 application reject ಮಾಡಿ, court has directed me to pay the court fee as if the property is an agricultural, non-agricultural property. But what has happened is this, the sale deed in favor of defendant number 1 is said to have been executed by defendant number 2 claiming to be the power of attorney holder of the mother of the petitioners after her death. And this power of attorney is seriously in dispute. Charge sheet has been filed. Now what had happened before the Tahsildar, they wanted to get the revenue entries changed. We filed objections. When the matter was pending before the Tahsildar, they don't participate before the Tahsildar. They file an appeal before the Assistant Commissioner, get an order in their favor. Then Deputy Commissioner, on the basis of, before the Deputy Commissioner, we had filed a revision petition. Matter was stayed. During the time when the matter was pending before the Deputy Commissioner, on the basis of the mutation effected by the Assistant Commissioner, they go to the Deputy Commissioner and get the land converted. And they say that the land is converted and I'm supposed to pay the court fee on that basis. This is what has happened.
Suit filed 23/10/2020. Land was converted, my lord, the 2/11/2019. Before 2 years back, my lord, land was converted. Suit filed on 23/10/2020
That will
based on 1819 RTC.
Remain subject to the result of the suit. If you want me to write whatever he has said, we'll write, no problem.
They are shown the court fee based on the 2018 and 19 the RTC.
No problems.
When filing the suit, my lord, the suit for the declaration, ownership and cancellation of our sale deed.
No, I will write, this will depend upon the outcome. Later we will see.
Lord, as on the date of filing the suit, they have to pay the court fee on the what the status of the property. My lord, on suit filed 23/10/2020, before 2 years back,
Correct,
land
sir.
was
ಅದು
converted.
conversion ಹೆಂಗಾಗಿದೆ ಅಂತ ಬರಿತೀನಿ.
In fact, I have produced the affidavit
I
filed
will
by
write
the
everything. Conversion ಹೆಂಗಾಗಿದೆ
Commissioner
ಅಂತ
ಮುಂದೆ
ತೊಂದ್ರೆ
ಹಾಕಿರೋ
ಇಲ್ಲ.
affidavit ಅಲ್ಲಿ we make a wrong statement that the no proceeding is pending before the revenue officials.
And revenue appeal they have moved, but the civil suit was filed on 23.
No problem, sir. You are right. Suit was filed in 2020, converted ಆಗಿತ್ತು ಅಷ್ಟೊತ್ತಿಗೆ ಅದರದ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೊಡಬೇಕು ಅಂತ. ಬಟ್ ಹೆಂಗ್ ಕನ್ವರ್ಟ್ ಆಯ್ತು ಅಂತ ಬರಿಬೋದಲ್ಲ ಸರ್.
Yes, that order was not challenged by them.
We'll see, sir. Yes.
And High Court finality in the writ petition in the revenue proceedings, subject to outcome of the suit.
2021 ಲೇ ಆಗಿದೆಯಾ ಅದು?
ಯಾವುದು?
You are not a party to all that?
No, what had happened was before the Assistant Commissioner, I was not a party. When they
ಇಲ್ಲಿ before the High Court.
before the High Court, I was the one who filed the writ petition.
Writ petition.
Challenging
ನೀವೇ
the order
ಹಾಕಿದ್ದಾ?
passed by the Deputy Commissioner.
That was set aside.
But the Deputy, this honorable court said that the anyway suit is already pending. The matter should be decided subject to the ultimate decision of the civil court and there should be an entry in the revenue records about the pendency of the suit. That is what has happened. But what has happened in this case is during the pendency of the proceeding before the Deputy Commissioner, where there was a stay granted by the Deputy Commissioner relating to the order passed by the Assistant Commissioner, suppressing that fact, they go before the Deputy Commissioner and get the land converted, making a false affidavit, saying that no proceeding is pending either before the revenue authorities or before the court. I have produced that affidavit.
Yes, Secretary.
My lord, the writ petition disposed of 3.
Correct, 3/3/2021.
21. My lord, all the facts narrated in the petition.
Correct, sir.
Before
ಅದನ್ನ ನೋಡೇ
the-
ಹೇಳ್ತಿರೋದು.
Yes, my lord. After the writ petition, my lord, before 1 year back filed the suit. And the suit, my lord, the subject to result of the revenue entries. My lord, they aware of that. The proceedings, my lord, the Deputy Commissioner proceedings of conversion was not challenged by any authority. It was not set aside by the authority. My lord, when filing the suit, Before that, the land was converted. We have filed the application as on the market value of the property when filing the suit, they had to have paid. That is my trial court has considered, and to my application dismissed and liberty to the plaintiff to pay the court fee within 30 days to file the fresh valuation slip.
We'll see, yes. List the matter on 24th in preliminary hearing. Objections, if any, by the respondent, by then further proceedings before the concerned court shall remain stayed till the next date.
Already stayed, my lord, last date of hearing.
ಎಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ?
Last time ಬಂದಿತ್ತು.
Last time
ಬಂದಿತ್ತ ಮತ್ತೆ?
ಬಂದಿತ್ತು.
24th, yes.
So I think stay ಆಗಿದೆ ಅಲ್ಲ?
ಸ್ಟೇ ಆಗಿದೆ ಇಲ್ವಲ್ಲ?
This time not.
Stay ಆಗಿದೆ.
Last
ಸ್ಟೇ
time what
ಆಗಿಲ್ಲ
happened?
last time.
Very last time, only office objection was overruled.
Overruled ಅಷ್ಟೇ.
Stay may kindly be.
Now it is granted. Yes. Not to precipitate ಆಗಿತ್ತು.
Not
Yes.
Collusive decree obtained from local Adalat is under challenge, my lord. At an actual event.
Collusive decree?
Please, my lord. They have not made me as a party to the proceedings. They have sold the property in my favor in the year 2014.
Suit for?
Suit for, my lord, partition.
Who are you?
I am the purchaser, my lord. They have not made me.
When did you purchase the property?
I purchased, my lord,
During the pendency of the suit?
Oh, my lord, earlier to that. Earlier to that.
Petitioner to serve on the respondents by way of hand summons and file an acknowledgement of such service. The
Service ಮಾಡಕ್ಕೆ ಅವರು already suit was disposed of and compromised, my lord.
hand summons ಇಲ್ವ ಪಾರ್ಟಿಗಳಿಗೆ? ಕೌನ್ಸಿಲ್ ಅಲ್ಲ.
They have refused to take, I think, my lord. Notice may be issued, emergent notice.
Emergent notice. The pendency of this petition will not alter the rights of the parties accrued pursuant to the compromise. Yes, next.
32.
Petitioner in this case. The petitioner filed a civil miscellaneous for
Petitioner to serve on the emergent notice to the respondent. Yes.
kindly stay the
2023 order. ಇವತ್ತು stay ಮಾಡಲ್ಲ ನಾನು.
execution.
6/6/2023 is the order.
Execution is
Yes,
running.
next.
33.
Petitioner in this case, my lord. My lord, the petitioner acquired the property by partition. This property, the question which is the property is an ancestor property, my lord. Now, after OS suit, the respondent hearing they filed appeal in which the rights of the respondent was
The
not
petitioner shall serve on the counsel who represents the
recognized. Stay may
respondent.
be granted, my
Serve ಆಗಿದೆಯಾ? Wait, madam. You want stay first or facts first? The petitioner shall serve on the counsel who represents the defendant in any of the proceedings, either before the trial court or the first appellate court. The respondent defendant is restrained from changing the nature of the property till the next date of hearing. List the matter on 24th. Yes.
34.
Learned AGA is directed to accept notice for the respondent.
79.
What 79 acquisition? Learned counsel M. Ajay Kumar is directed to accept notice for the second respondent. Shashidhar, Nimda? Sir, yes. Petitioner to serve set of papers upon the aforesaid counsel. ಯಾಕೆ ಇಷ್ಟು ಜಲ್ದಿ ಮಾಡಿದ್ದೀರಾ ಚಾಲೆಂಜ್? ಜಸ್ಟ್ 55 ವರ್ಷ ಆಗಿದೆ ಅಷ್ಟೇ.
Matter is held up before the deputy commissioner regarding.
Oh, that's why you are keeping quiet.
SC matter, my lord.
Correct, 55 ವರ್ಷ. Very good, sir. Yes. ಅದ್ರ ಮೇಲೆ ಹೋಗುತ್ತೆ.
Lordship says the.
ಅದಕ್ಕೆ ನೋಟಿಸ್ ಮಾಡೋದು ಮಾಡಿದ್ದೀರಾ?
Covers, my lord, division bench judgment.
Oh, we'll see. Yes.
35.
In this case, today I filed wakalat for respondent number 1. I seek 2 days time, lords. I have informed my senior counsel. 2 days time.
Informed.
Informed, sir.
Just now.
Information confirmed.
Information is always confirmed, Lord.
Today I have filed wakalat.
Lord, sir, if your lordships were to
Otherwise,
recollect, an order is passed without assigning any reasons. 2003, 2004, the sale transactions
2
takes
days.
place. Very well. 2 days, I think I should
2 days
not.
ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ.
No, should not.
Yes, 2 days ಆಗಲ್ಲ. ನೀವು 2 days ಅಂದ್ರೆ ಆಗಲ್ಲ. Next Monday. List the matter on 8th at the request of the counsel appearing for the respondent who seeks time to file statement of objections. ಏನ್ ತೊಂದರೆ ಆಗ್ತದೆ? ಸ್ಟೇಟಸ್ ಕೋ? ಬೇಡ.
ಏನು ಬೇಡ.
ಇಲ್ಲ.
Next.
46.
The petitioner defendant in this matter.
Suit is dismissed.
Look,
Why is suit dismissed?
Not, there's an injunction suit which comes to be decreed. I'm for the defendant. Against that decree, my lord, a review application is taken out under 114 CPC. That 114 CPC application is rejected, against which I'm before your lordship. Not the background is this. Not, there were two suits. First, there is a suit for bare injunction in which plaintiff seeks to protect his possession. Not in that I'm defendant number one. There is one item in that suit. Not subsequently, because I had disputed his title to that property, he files a partition suit. Not, that is OS 49 of 2018. In that note, there are 5 properties which are made subject of that particular partition suit. Item number 1 is common to both the suits, the injunction suit and the partition suit. Not in the partition suit, the court would go into deciding title. In the first suit, not the court would simply decide on whether the plaintiff is entitled to possession.
That's
Bare
injunction.
Not apprehending conflicting findings in both the suit, the defendant files an application under section 24. Not the order passed on that section 24, your lordship will find at 234. Your lordship will see that order. Not the section 24 court finds that there is a possibility of conflicting findings being given in both the suits. Therefore, an order is passed consolidating the injunction suit and the partition suit, which were so far being tried by the same court. Lord. Please see the observations, Lord, in that
Page
application.
235.
Page 235, Lord. May I read, Lord? Page 234, the reasons begin, Lord.
Is order to be withdrawn?
No, Lord. Your lordship may see the observations above. They were being tried by 2 different courts. The injunction suit was being
Have to be
by
tried by the same court is what is said.
Yes, Lord. Above that, Lord, your lordships will see. May I read, Lord? Your lordship will see. From the top, just the previous page will give your lordship's context. Petitioner number 2 is the mother of petitioner number 1 and respondents 1 to 3. So and so. Respondent number 1 has filed a suit against petitioners 1 and 2 in OS number 8136 of 2017, pending on the file of CH-17 for the relief of permanent injunction not to dispossess him without due process of law in respect of property bearing number so and so. In respect of the said property and other 5 properties, respondent 1 to 3 have filed a suit against petitioners 1 and 2 and respondents 4 to 7 in OS number 49 of 2018, pending on the file of CH-70 for the relief of partition and declaration. Item number 1, Lord, your lordship may see that from the middle of that 235, item number 1 of OS 49 of 2018 and OS 8136 are one and the same. The parties to both the suits are same. In order to avoid passing of conflicting judgments, it is necessary that both suits have to be tried by one and the same court. The petitioners have made out a case for the transfer of so and so to CCH-70, wherein OS 49 of 2018 is pending. Accordingly, I answer the following. The suits are then consolidated and combined. Lord, this order is passed on in 2023. Ever since then, till the decree is passed, every date, both the suits have come before the same court on the same date.
Now separate decree is passed?
Look, what has happened is both had to be decided in such a way where the partition suit, the outcome in the partition suit would necessarily decide the outcome in the injunction suit. Look, what has happened now is in the partition suit, the plaintiff's case is dismissed where he claimed that it was joint family property. I took a defense that it was my self-acquired property. So in the partition suit, I am held to be the owner of the property. My defense that it was my self-acquired property has been accepted. In the injunction suit, Lord, is decided prior to the partition suit. The injunction suit is decreed in which the plaintiff is held to be in possession, but in the partition suit, I am held to be the owner. So, Lord, there's a peculiar situation in which I am the title holder, but he is held to be in possession, Lord. The possession must follow title. Lord, in the final arguments, it was argued before the learned judge that whatever happens in the partition suit will decide the outcome in the injunction suit as well. But not.
All right, we'll pass the order. They heard the learned counsel Rangat Kamath appearing for the petitioner. The fulcrum of the list revolves around 2 suits. One, OS 8136 of 2017, filed for injunction, and the other, OS 49 of 2018, filed seeking partition and separate possession. Both the suits throughout were being tried together. It transpires that the suit for injunction is pre-decided the suit for partition. The injunction suit is decreed against the present petitioners, and the partition suit is the suit for partition. In the suit for partition, it is held that the property that was item number
1.
The property hyphen item number 1 is not a joint family property, but a self-acquired property of the present petitioners. Therefore, the suit in the suit for partition, it is declared that these petitioners are owners of the property. But in the suit for injunction, it goes against these petitioners. as contended by the learned counsel appearing for the petitioner, the suit for partition ought to have pre-decided the suit for injunction as it was a consequence for the suit for partition. The decision, the judgment and decree of the suit for injunction is now in direct conflict with the observations in the suit for partition. In that light, there shall be an interim order of stay as prayed for till the next date of hearing. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement.
So grateful.
Yes, next.
37.
ನಿಮ್ದೆ ಸನತ್
Today only I received one.
ಬಾರ್ಬ್ಡ್ ವೈರ್ ಹಾಕೊಂಡು ಕೂತ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲಿ ಕೇಸ್ ಬಾರ್ಬ್ಡ್ ವೈರ್ ಇದೆ ಅದಕ್ಕೆ.
ಹೌದು.
ಹಾ.
My lord,
After the matter was
I received
posted
today
for
only a
orders,
call.
my lord, they have put the barbed wire fence. I've been blocked from
Yes, sir.
entering my property.
My lord, I received today.
Who gave
morning.
you permission to put that?
No. Today only I received wakalat, my lord.
ನಾನು ಕೇಳಿದ ಕ್ವಶನ್ಗೆ ವಕಾಲತ್ ಹಾಕಿರೋದು ಆನ್ಸರ್.
ಈಗ ಹಾಕಿಲ್ಲ ಇನ್ನ. ಈಗ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, ಈಗ ಫೈಲ್ ಮಾಡಬೇಕು.
ನಿಮಗೆ ತಂತಿ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
ಓ ಸರ್, ತೊಂದರೆ ಇಲ್ಲ. ಇವರು ವಕಾಲತ್
ಈಗ ಆಗ್ತಾ ಇದೆ.
ಆಯ್ತು. ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ so and so.
ನಿನ್ನೆ ಸರ್ವ್ ಮಾಡಿದ್ರು ಲಾಯರ್ಗೆ.
ತೊಂದರೆ ಇಲ್ಲ. Learned counsel so and so undertakes to enter appearance for the respondent. The learned counsel for the petitioners are the petitioner is the plaintiff. Injunction ನಿಮ್ ಪರವಾಗಿದೆಯಾ?
ಅಲ್ಲ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಟಿದ್ರು ಇಬ್ಬರಿಗೂ.
The concerned court directs.
That was passed subsequently.
The
matter was heard on this application. It was reserved for orders. By that time they have put the barbed wire.
The
later on subsequent
plaintiff institutes the suit in OS 475 of 2024 seeking injunction la? Seeking declaration and injunction. Status quo was granted by the concerned court. The matter was heard. During the subsistence of the hearing of the matter, it transpires that a barbed wire fence is installed between the parties, which has between the properties, which has led the petitioner which has stopped the petitioner from entering his own property, is a submission of the learned counsel for the petitioner. Counsel for the respondent submits that he is not aware of any of the fact as he is wanting to file wakalat only today. In that light, the further proceedings before the concerned court. ನಿಮ್ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
Final hearing.
List objections, if any, by the next 2 weeks. List the matter on 24th in preliminary hearing. Next.
38.
We'll pass over, man. We'll pass in order later. What happened?
My lords, we're in the same situation.
No problem. I am also in the same situation.
My
We'll
lords,
pass it
kindly
over.
take it up at some other date if convenient to this honorable court.
Let's see. Next Monday.
Grateful.
Yes, 8th.
39.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 22nd in preliminary hearing. There shall be an interim order of stay of further proceedings before the concerned court solely on the score that the concerned court has now passed orders which run counter to the order passed by the coordinate bench. Yes. Next.
40.
Survive ಆಗಿದೆ 2023 order.
This is the matter, you also kindly
You
recollect.
ಮತ್ತೆ
This is a connected matter where the sign of the respondent number was forged. ಅದು ಲೋನ್ ಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ
ನಂಬರ್ ಕೊಡಿ ಅದ್ರ.
WP number 16237 of 24 years.
Tag this petition with
16237/24.
list next Monday.
Till then, Lord, further proceedings has to be stayed, Lord, because
Where?
Lord, the suit itself is not maintainable. Cooperative society, Lord, he has obtained a loan.
Yes, 8 ತೀರ್ಮಾನ ಮಾಡುವ.
ಅದರಲ್ಲಿ
Next date ಏನಲ್ಲಿ?
Next date,
8 ತೀರ್ಮಾನ. List on 8th, yes. ಆಯ್ತು.
41.
No representation, 2 weeks.
42.
before the respondent number 2, my lord. Responding, my lord.
For the petitioner, my lord. Hello, my written statement was taken as not filed.
My lord, we have no objections for
It has to be allowed. Petition has to be allowed.
Please, my lord. And may I request for a time frame, my lord, because it's been dragged since 2018.
Suit 2018.
My lord,
Suit for?
I for the
declare-
second.
Suit for
To declare the gift
Cancellation
deed
for
void.
50.
declaration,
Yes, my lord.
Declaration.
6 months.
Evidence gittu.
6 months.
Very well, my lord.
Yes.
My lord,
The
I've
pet-
come on,
Huh?
I've come on record in February. I'm an impleading applicant.
Allowed ಮಾಡ್ತಾರೆ.
They shouldn't be using my writ petition to seek a relief. If they necessary, then let them file their own
No,
writ. my lord.
court is giving that relief, not his thought. Impleading application has to be allowed.
It was allowed, my
Pleading
lord.
ಅಲ್ಲ ಇದು.
I
Allowed,
was,
allowed,
statement
written
ಹಾಕಿರೋದು.
statement ಮಾಡಕ್ಕೆ.
Allowed, my lord.
That had to be allowed.
yes, my lord. It was rejected.
Impleading ಆದ್ಮೇಲೆ written statement ಹಾಕ್ಬೇಕಲ್ಲ. ಯಾವ courting?
I have no objections for that.
The petitioner is before this court seeking the following prayer. The petitioner is defendant number?
1A.
Defendant number 1A.
Sorry, different number 1.
ಅಲ್ಲ, defendant number 1A.
here. Respond number 1 here, my lord.
Plaintiff is respondent
Petitioner,
number 1 here.
please. Petitioner is 1A.
I am one name, my lord.
Please.
The petitioner is defendant number 1A. In a suit instituted by the respondent plaintiff seeking declaration of
Cancellation of the gift.
declaration and cancellation of a gift deed in OS 1277 of 2018. In the said proceeding, the petitioner files an application seeking impleadment, which comes to be allowed. After the petitioner getting in as a defendant number,
I didn't file the impleading application. They filed it to implead.
impleading application was filed in the proceedings in which the petitioner gets into the suit as defendant number 1A. After getting into the suit, seeks leave to file the written statement as written statement. The said application ಹಾಕಿದ್ರಾ? Said application seeking for permission to file the written statement is rejected. The rejection on the face of it is erroneous. The learned counsel for the respondent would not dispute the position that the written statement ought to have been permitted to be filed before the by the present petitioner before the concerned court in the light of him getting into the proceedings on an application filed by the respondents. In that light, the petition deserves to succeed with the quashment of the impugned order. ಇಲ್ಲೇ ಒಂದು ಆಗ್ಲೇ ಒಂದು ಇದ್ದಂಗೆ ಇದೆಯಲ್ಲ. The learned counsel for the respondent now submits that the suit is languishing for the last 7 years and is suit for declaration. This court, he would request this court to infuse finality into the proceedings. In the light of the proceedings pending before the concerned court for 7 years, even otherwise, even without the submission of the counsel for the respondent, this court would deem it appropriate to infuse finality into the proceedings. The proceedings shall conclude in accordance with law with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
Okay, sir. One submission, there are two respondents.
Allowed cost ಅದೇ ಮಾಡ್ಬಿಡಿ ಅಲ್ಲಿ.
My lord, there are two respondents. One has filed wakalat, one hasn't filed wakalat yet.
I'm undertaking
It's all right.
for R1.
ಇಲ್ಲ ಇದಾರಲ್ಲ, learned counsel separate order sheet ಮಾಡಿ undertakes to enter appearance for the first respondent. Next.
Oh, bless me.
43.
Please.
You are not a party?
I was impleaded as a party. I got myself impleaded as a party in the FDP. The question is, the advocate has been appointed as the court commissioner in the final decree proceedings. There is one more connected matter, my lord. The lordships have stayed.
ಅದರಲ್ಲಿ stay ಆಗಿದೆ ಕೊಡಿ.
Correct. my lord.
Number?
21468.
Tag this petition along with so and so. In the light of the interim order subsisting in the said petition, an interim order in the subject petition would not be required.
Please.
List the matter on, list both these petitions after 4 weeks. Yes.
And lord, seeking dispensation for 3 to 46. my lord.
3 to 46. ಅದೇ
Please.
Chetan. Dispensation 3 to 46.
And 1 and 2, I may be permitted to serve the advocate.
Counsel for the petitioner to serve on the counsel who represents respondents 1 and 2 before the concerned court. Next.
Great. 214.
44.
I appear for the petitioner, my lord. Lord, I appear for the petitioner, my lord, in this
Correct,
case, my lord.
yes. The
My lord,
petitioner shall serve the respondents by way of hand summons. Pendency of this petition or issuance of notice will not alter the rights that is accrued to the parties in terms of a compromise entered into on 10/11/2021. Yes. Next.
45.
Application for amendment, my lords, is allowed for the sixth time.
Application for?
Amendment
Amendment.
of the plaint is allowed, my
But
lords.
what to do? De novo, to consider de novo is what the division bench directs and sends it back.
It sends it back.
De novo andreno.
ಅದಿರ್ಲಿ.
ಏನ್
But
ಬೇಕಾದ್ರೂ
what-
ಮಾಡ್ಬೋದು.
ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಲಿ. My lords, but what happens is, kindly see, my lords, annexure A.
Correct, madam. I have no qualm about the principles. OS is of the year 2008. Now amendment is filed.
Amendment is filed to seek, my lords,
You,
whatever admission is
what do you
made.
mean by de novo?
De novo is fresh.
Ah.
But fresh, kindly see the order of the division bench, my lords.
No, yes, Justice Somshekar avardalva.
Justice Somshekar. It is at page 172.
172.
Relevant portion
Yes.
at serial number 3. Both
Judgment
the
and decree set aside. So there is no judgment, no decree.
No decree.
De novo trial.
Both the respective parties to the proceeding shall be afforded an opportunity of hearing.
What do you mean opportunity?
Of hearing. They, my lords, here what had happened was the defendant number.
Proceeding illa.
By permitting the parties to lead fresh evidence. This was the only thing because defendant number 5 had not led evidence by himself. He had led evidence through a GP holder. That is why it was
ಈಗ
allowed.
admissions are sought to be deleted.
Admissions are sought to be deleted. And new facts regarding possession is sought to be included. Kindly see the cross-examination, my lords, of PW1 at annexure E.
Yes, sir.
Let the lordship may kindly see, even their objections, what they have filed to the amendment application. What they have stated is, the division bench has not granted permission to file an application. That is one of the ground they have raised in their objection. The second one is that the amendment what I sought in the application is mere repetition of facts. These are
So
the
why did
grounds
you
that
want that
what-
amendment at all?
Let,
Mere
now
repetition of facts ಆದ್ರೆ why did you want that amendment?
ಹೇಳಿರೋದು mere repetition of
ಅವ್ರು
facts.
ಹೇಳಿರೋದು.
ಅವ್ರು
In
ಹೇಳಿರೋದು,
effect
ನಾವ್
ಏನ್ ಹೇಳಿ?
ನಮ್ ಪ್ರಕಾರ ಲಕ್ಷ್ಮಿ
ನಿಮ್ ಪ್ರಕಾರ ಎಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್ ನ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಇಲ್ಲ ನಾವು ಎಲ್ಲೂ ಆತರ ಒಂದ್ ಶಬ್ದ ಹೇಳಿಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್ ಡಿಲೀಟ್ ಮಾಡಿ ಅಂತ.
ಶಬ್ದ ಬೇಕಾಗಿಲ್ಲ.
ತೋರಿಸ್ಲಾ?
ತೋರಿಸ್ಲಿ.
ಎರಡೇ ನಿಮಿಷ ತೋರಿಸ್ಲಾ?
ಏನು ಹಿಂಗಂತ?
Kindly see page 181, my lords, what objections
sir.
we have said. The government suggested in para 5E is an effort to neutralize the effect of cross-examination conducted by the fifth defendant to PW1 on 14.
Anything else, sir?
Findings, Lashmi kindly see the division bench, page 168, page
168 ಏನು?
168. But in that, in fact, Lashmi got it, Marad, in the.
In fact,
In fact, all the evidence indicates.
Where are you reading, sir?
ಅದೊಂದು bottom ಇಂದ ಒಂದು 10, 6, 7 lines.
In fact, yes, sir.
In fact, all evidence indicates the opposite, that the plaintiffs remained in possession until 2008. Therefore, the
Clock of limitation did not start ticking.
the year 1969. The limitation has stated
Once-
only from the year 2008 when the plaintiffs were dispossessed.
ನೀವು purchasers.
Page 172, serial number 5.
They are purchasing this property from somebody else.
Page
The owners
172.
are.
ಆಯ್ತಾಯ್ತು ಒಂದ್ ನಿಮಿಷ.
Serial number
170.
172, serial number 5. Any
Observe.
observation made in this order shall not influence the mind of the trial court while disposing the suit initiated by the plaintiffs against the defendants. So it was totally de novo. The trial court was not supposed to look into any observation made by the division bench.
Like,
The
dear, what-
admissions, my lords, are at page 74, annexure E, page 74. Third line, ಐದನೇ ಪ್ರತಿವಾದಿ ಸದರಿ 4 ಎಕರೆ 4 ಗುಂಟೆಯಿಂದ ಯಾವತ್ತಿನಿಂದ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Your lordships got 74?
Yes, ಅದನ್ನ ಈಗ ಡಿಲೀಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು, ಅದನ್ನ ಈಗ 2008 ಅಲ್ಲಿ ನಾವು ಹೋಗಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. Possession I lost in 2008 ಅಂತ ಹೇಳ್ತಾರೆ. ನಾವ್ ಯಾವಾಗಿಂದ ಕಳ್ಕೊಂಡಿದೀವಿ, ನಮ್ಮ ಕುಟುಂಬ ಯಾವಾಗ ಕಳ್ಕೋತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಮ್ ತಂದೆ ಹೇಳಿದ್ರು, ನಾನು 1978, 79ರಲ್ಲಿ ಕಳ್ಕೊಂತು ನಮ್ ಕುಟುಂಬ, ನಾನು ಹುಟ್ಟೋಕ್ ಮುಂಚೆ ಅಂತ ಹೇಳ್ತಾರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ. ಈಗ ಹೇಳ್ತಾರೆ 2008ರಲ್ಲಿ ನಾವು ಸ್ವಾಧೀನ ಕಳ್ಕೊಂಡ್ವಿ, ಕಳ್ಕೊಂಡ ತಕ್ಷಣ ನಾವು
Where is
suit
the
ಹಾಕಿದ್ವಿ.
earlier cross examination?
Annexure E, page 74.
And where did you read that now?
Third line, ಐದನೇ ಪ್ರತಿವಾದಿ ಸದರಿ 4 ಎಕರೆ 4 ಗುಂಟೆಯಿಂದ ಯಾವತ್ತಿನಿಂದ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. 5ನೇ ಪ್ರತಿವಾದಿಗೆ ಸದರಿ 4 ಎಕರೆ 4 ಗುಂಟೆ ಸ್ವಾಧೀನವನ್ನು ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸದರಿ 4 ಎಕರೆ 4 ಗುಂಟೆ ನಮ್ಮ ಕುಟುಂಬದ ಸ್ವಾಧೀನದಲ್ಲಿ.
Defendant number 5.
Yes, please.
You are in possession of the property.
ನಮ್ಮ ಕುಟುಂಬದ ಸ್ವಾಧೀನದಲ್ಲಿ.
Where is the cross examination now?
70.
What is sought to be deleted now?
Kindly see, inserted.
Yes.
Kindly see their application, my lords.
Page
5E at page 176. 175, last line, if if your lordships could kindly see. 5C, paragraph 5C, that is sought to be in last one line. The plaintiffs Venkategowda and Hanumma were illiterates, and as there was no disturbance for their possession and enjoyment of scheduled property, all the while
they want to insert this.
All the while they were under bona fide belief that the revenue entries continued in the name of their grandfather, it is submitted that the plaintiffs and their father were cultivating the suit scheduled land, and they were raising crops.
The whole problem is the division bench says nothing is existing.
Nothing is existing, but my lords, the division bench
Opportunity of hearing ashte.
hearing ashte kottirodu.
Yes, sir. We'll hear it. We'll hear it. The petitioner is before this court calling in question an order of the concerned court which allows an application seeking amendment of the plaint in an application filed under Order 6 Rule 17. The parties to the list were before the division bench in RFA. Who was the plaintiff? In RFA.
RFA, the plaintiff
for the suit had been dismissed. The division bench, in terms of its order dated 20th April 2025, sets aside the judgment and decree on the score that there has been violation of principles of natural justice in as much as evidence was not completely taken note of and the parties were not heard. The order passed by the division bench reads as follows. Page 171 to 173. The matter was remitted back to the hands of the concerned court to hear the parties and pass necessary orders. The plaintiff now comes up with an application Order 6 Rule 17 seeking amendment of the plaint, deleting certain evidence in
No such deletion.
inserting certain evidence that would run contrary to what was deposed in the cross examination earlier. The deposition of the plaintiff in the cross examination for illustration is as follows. Page 79. Now what is sought to be inserted in terms of the application, page 170?
176.
170 is as follows. They run completely contrary to each other. Therefore, virtually it is an admission that is now sought to be tinkered with the insertion. Therefore, it is the insertion. In that light, the order passed on the application under Order 6 Rule 17 shall remain stayed. It is made clear that the proceedings before the concerned court is not stayed. It is open to the concerned court to conclude to hear the parties pass necessary orders in accordance with law.
Great.
Till the next date, objections, if any, in the next 2 weeks. List the matter on 24th.
Much.
Yes. Next.
46.
ಇದರಲ್ಲಿ ಅವ್ರು ಹಾಕಿರೋದೇ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆ.
Yeah.
That may be connected with it.
ಅಲ್ಲ ಇದು
ನೀವು ಎರಡು
ಅದು ಬೇರೆ-
ಹಾಕಿದ್ದೀರಾ?
ಅದು ಬೇರೆ ಇದು ಬೇರೆ.
ಅಲ್ಲ,
ಇದು-
ಅದೆರಡು ಕನೆಕ್ಟ್
Connect ಅಲ್ಲ, ಇದು-
ಈಗ ನಿಮ್ಮ ಪ್ರಾಕ್ಟೀಸ್ ತೊಂದರೆ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಎಸ್
ಏನಾಯ್ತು?
ಅದಕ್ಕೆ ಕಂಟೆಂಪ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದೇನೆ. ಅವತ್ತು ಸೆಟ್ ಆರ್ಡರ್ ರೂಲ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದೆ. ಮೈನ್ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ, ಇದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಬಿಡ್ತಾರೆ.
ಎಸ್ ಮೇಡಮ್. ಇನ್ನೊಂದು ಯಾವ್ದು ನಂಬರ್ ಕೊಡಿ.
27151 of 24 madam.
Tag this petition along with 27.
ಅಲ್ಲ, ಅದು ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ ಬಗ್ಗೆ.
ಇಲೆಕ್ಟ್ರಿಸಿಟಿ ಮತ್ತು ವಾಟರ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ ಬಗ್ಗೆ ರೀಕನೆಕ್ಷನ್ ಗೆ ಅಂತ ಇಲ್ಲಿ ಬಂದದ್ದು.
ಅದು ಯಾವ್ದು GMCPC ನ ಏನದು?
CPC.
ಲಿಸ್ಟ್ ಆನ್
ಕೈಂಡ್ಲಿ ಅಟೆಂಡ್ ಟುಮಾರೋ ಮೈ ಲಾರ್ಡ್.
8 ಸರ್, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಈಗ?
ಅರ್ಜೆಂಟ್
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಬೇಕಾ ಸ್ಟೇ ಬೇಕಾ?
ಸ್ಟೇ ಅಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ 2 ಕೇಸಸ್ ಒಳ್ಳೆ
ಅಲ್ಲ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಸೂಟ್ ಅಲ್ಲ, ಈಗ ಅವ್ರು ಬಿಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ.
ಆಯ್ತು ಸರ್.
ಕೈಂಡ್ಲಿ ಅಟೆಂಡ್ ಟುಮಾರೋ ಮೈ ಲಾರ್ಡ್.
ಟುಮಾರೋ ಆಗಲ್ಲ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಎಸ್ ಮಚ್ ಅಪ್ರಿಷಿಯೇಟ್.
47.
Respondent number 1 in this case, I appear for the petitioner, my lord. Lord, 1990 suit for partition, my lord. Ultimately in 2005, my lord, the suit is partly decreed. I am given 1/4 share, my lord, in the 2 properties, my lord. Now thereafter, my lord, the father of the cavator, lord, he files, my lord, appeal, which is dismissed for default in 2010. 2015, he files, my lord, miscellaneous petition, which he has not at all prosecuted till today. Thereafter, my lord, in 2004, a final decree is passed based on court commissioner's reports, lord, for which he does not attend one of the meetings. And then, my lord, he files an appeal challenging the meeting and the court commissioner surveys. And then ultimately, now he has filed a suit appeal against the final decree, in which the final decree is stayed. After it has all given effect to our property.
ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರು?
ಯಾವುದು?
ಡಿಲೇ ಎಷ್ಟು ಅಂತ?
ಅಲ್ಲ ಡಿಲೇ ಇಲ್ಲ, there is no delay.
With regard to the present appeal,
but his appeal against the preliminary decree is dismissed. It is not in existence.
Final decree is challenged, is it?
Final decree he is challenging. And my lord, he has sold the entire property.
What happened to the dismissal of the preliminary
decree? It has filed in 2015 one miscellaneous, which he has not prosecuted.
That's pending still?
That's still pending. But he has sold the entire property. He does not have any right in the property today.
No, FDP stayed.
FDP, Lord, already the
FDP appeal alli FDP stayed.
FDP decree.
Tying of final decree has been stayed in the RM, Lord.
Decree is already finally drawn.
Yake sir.
Lord, what happened, Lord? My father was the rendering the service as a Mutwalli of the Babaya Makan. Lord, kindly see page 22. That property, my father has filed an application for grant of this immovable properties, that is survey number 13 and 20. Then on 3/5/1981, the tribunal has 82, tribunal has passed an order.
1982.
Yes, Lord. 5/5/1982.
All right.
The tribunal has passed an order. Pursuant to that order, the revenue records have been changed in the name of this respondent father, that is Syed Khalil Shah. Thereafter, the other persons have been challenged before this High Court. Then the matter has been remitted back to this tribunal. On 31/8/1988, the tribunal has passed an order holding that all the 3 or 4 sons of that Uthman Sahib are having a share this right over this property. That order was challenged by this respondent father in a land reforms appeal, that 78 of 1988. 1988, there was an interim order on 21/11/1988. Then in the meantime, this respondents.
You pursue the miscellaneous appeal.
Pursue agide. Already filed. Already filed because for this respondent.
Already filed ಅಂದ್ರೆ 10 ವರ್ಷದಿಂದ filed.
File ಮಾಡಿ notice ಇವ್ರು ತಗೊಳ್ತಾ ಇಲ್ಲ.
ಯಾರು ತಗೊಂತಾ ಇಲ್ಲ?
Respondent, petitioner before this court.
Will direct the court to hear the miscellaneous appeal.
ಒಂದು ಎರಡನೇದು Lord, kindly for a moment, kindly see page 82 in my statement of objection. First of all, this petitioner before this court has no locus standi to challenge this order.
Oh, why? He's not a party. He's not a party to the proceeding.
During the lifetime of this father of this petitioner, he's compromised this property, compromised his share, and already has taken his share from the. And also, in fact, he filed a kindly see page 88. That is the sale deed which has been executed by on 23.
Anyway, you pursue the miscellaneous appeal.
ಅಲ್ಲ ಅತ್ರಲ್ಲ ಇದ್ರಲ್ಲಿ separate ಆಗಿ appeal ಬರುತ್ತೆ. 97 of that CPC is very clear. 97 of CPC. Lord, kindly see. Next, Lord, kindly see. Come to that. Page 94, Lord, that 94, 100, Lord, kindly see 100, page number 100, Lord. Respondent, that is the party to the proceedings, they filed the compromise petition before the execution. This first in appeal, that 235 is against the preliminary decree which has been filed before this challenging the preliminary decree, that has been challenged in RA number 235 of 2005. Page 110, Lord, kindly see annexure R12.
Now, what is under challenge? One moment.
Please, order of
state. I will come to that.
Wait, sir.
Page 416.
Kindly see.
Wait, sir. One ನಿಮಿಷ.
Page 468.
Wait.
Page 468.
Page 468.
Oh, I'm so sorry. This is the final decree. This is the final decree, Lord.
ನನ್ನ ಇದ್ರಲ್ಲಿ 279 ಇದೆ that order. ನನ್ನ statement of objection which has been challenged before this court.
Lord, at page 121, Lord. At page 121 is the order staying the final decree. And the reasoning for this is recorded at page 117.
It's a detailed order, sir.
Yes.
No, it is detailed, but kindly see the reasoning at page 117, para 12. Upon a detailed and thorough examination of the appeal memo, the specific objection raised by the appellants and various documents and material placed on record, this court is of the considered view that the final decree passed in FDP number so and so is not merely a procedural formality, but is in fact an
Where is the order
executable
in
and
the
enforceable
order in the preliminary decree?
preliminary for I just showed it
That
here,
I
Lord.
approach that not kindly
460
see. In my the subjection Lord that
460.
document
Wait,
number.
sir. ಯಾರ್ದೋ ಒಬ್ಬರದು ಒಂದೇ ತಾನೇ ಇರೋದು.
Annexure R7 page 47.
ಒಂದೇ ತಾನೇ ಇರೋದು.
Yes, sir.
Preliminary decree ಒಂದೇ ಅಲ್ವಾ ಇರೋದು?
469.
Yes.
Scheme of partition submitted, so sorry.
469.
9.
Ah.
Scheme of partition.
Why he was
submitted-
not heard in the matter?
No, look, the order itself records that at every time notice were issued, he remained absent.
Where is that
Yes,
observation?
Lord. Kindly see, first at Milord page 461, para 12. First objection raised by the respondent number 3J, that interest and rights of the parties has not been considered by the commissioner. On perusal of the commissioner, it is noticed that the respondent 3J was absent during the inspection, even after service of notice. Then your lordship will come to the second objection at para 13.
2007. When did he, this was order dated?
This is 2024, Milord.
24. When did he file the miscellaneous application?
Miscellaneous is 2015.
This is FDP, sir. I'm asking
FDP.
where is the preliminary decree?
Preliminary decree.
In my that is court annexure R7 page 47 Lord. In my objection statement Lord.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಫಯಾಜ್ ಇಲ್ಲಿ ಅದಕ್ಕೆ ವೇಟ್
ಹಾಕಿದ್ದೀನಿ ಸುಮ್ಮನೆ.
ನೀವು ಹಾಕಿದಿರ ಇಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲ.
ಮೆನ್ಷನ್ ಮಾಡಿ ಹಾಕಿದ್ದೀನಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Lord, Lord, it is 173. 173. Lord, your lordship will get the decree at 199. Type copy, 199. Lord, in the middle of that Kannada paragraph, Lord, ಅಂದರೆ ದಾವಾ item number 1 ಮತ್ತು 4 ಹೊರತು.
Further decreed so and so.
Yes.
This
So
is,
I got 1/4 share only in item number 2 and 3, Milord.
this is 2005.
2000, yes, Milord.
Miscellaneous filed in
2015,
10 years.
10 years ago.
Why miscellaneous?
Because this, the appeal filed by the father was dismissed in 2010. Dismissed for default in 2010.
So MA is still pending.
That miscellaneous is still pending.
Yes, sir.
Lord. This property belongs to my grandfather, father. That property has been granted in favor of my father. Thereafter, the revenue records have been changed. Then, Lord, this order was challenged before the Land Reform Appellate Authority. Then the stay was granted. In the meantime, this petitioner father and other persons have filed a suit for partition. That is OS number 42 of 1990. Then the trial court has passed an order. That was challenged in area number 235 of 2005. The preliminary decree was passed on 31/1/2005. 31/1/2005. That was challenged before the appellate authority in area number 235 of 2005.
Appellate court.
Sorry, appellate court, Lord. Then, Lord, during pendency of this appeal, the father of this petitioner before this honorable court, that is respondent number 1 in that RA, and the respondent number 3, who is also the brother of this petitioner father, they filed the compromise petition in RA. That is page number 100 in my statement of objection. Shall I read more? That is the what they have filed.
Which page?
Our file madilla adana. Our file madilla. They have not produced that.
Kodil.
Or kindly see.
Objections bandila madam.
They filed this compromise petition claiming that they requested the first appellate court to dismissed their claim in respect of R1 and R3. They are received that they are under affidavit, they have stated that they have received their share of compensation in the form of money. They don't have any, and also in the order sheet, they have personally appeared in the matter, and also they affix the signature in the order sheet 235. Ide. So thereafter again, they are claiming that they are the owners. In similarly, that another writ petition is pending in respect of that. In that writ petition, there is an interim order on 12/9/2024. And in this RA 235 of 2024, even though there is an interim order, the petitioner before this honorable court has been executed the agreement of sale to sell this property to some third person, Uma Devi. Though there is an interim order granted by this court as well as the first appellate court are still in force, they enter the agreement of sale
Is that writ
to agreeing
petition?
to
Which is the writ petition?
that 25,283 of writ petition, 25,283 of 24, and 12/9/2020
ಬರ್ಕೊಡಿ
and 12/9/2020
ಬರ್ಕೊಡಿ ಅದು.
and 12/9/2024 this
It is
court has
produced.
granted the interim order
Tag this petition along with. so
and also one submission.
That is
And
disposed.
also the
Disposed
first- ಇಲ್ಲ pending ಇದೆ notice ತಗೊಂಡಿಲ್ಲ, still that case is pending.
What
And
is the
also my lord, the first appellate court has granted the interim order on 28/11/2024. In spite of that interim order is in force, this petitioners enter the agreement of sale, registered agreement of sale to sell the property to some other person.
Yes.
Even
But
though there is
what-
an interim order.
May I just make one submission, my lord?
I am not
Lord,
going to
he
say
has
this.
sold the property.
It is correctly stated.
Lord,
Yes.
he has already sold the property. He doesn't have any
We'll see,
subsisting right.
we'll hear it. Tag this petition along with so and so. Everything,
But those
everything has
compromise
figured.
what he's talking
Yes,
about,
everything
Lord,
has
that RA
come
is
out.
dismissed. There is no compromise decree.
Just the matter on 24th along with so and so. Yes.
25,283 of 24.
ಬರ್ಕೊಟ್ರಾ ಇಲ್ವಾ?
ಬರ್ಕೊಡ್ತೀನಿ sir ಈಗಲೇ.
ಕೊಡಿ. Yes.
ನಮ್ಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
ಅದಿದೆ, ಅದು ನಿಮ್ಮ
ಅವ್ರು ಬರ್ಕೊಡೋದ್ ಕಾಪಿ ಬೇಕಾ ನಿಮ್ಗೆ?
ಅಲ್ಲ,
already appeared in the matter.
Petition copy.
ನಾನು ಅವ್ರು ಬರ್ಕೊಡಿ ಅಂದ್ರೆ ಅದೊಂದು ಕಾಪಿ ಕೊಡಿ ಅಂದ್ರೆ ಬರ್ಕೊಡೋದನ್ನ ಕಾಪಿ ಯಾಕೆ?
48.
Petitioner being the defendant before the commercial court filed an application at Annexure C, my lord, page 36.
Documents at what stage, sir? Not at the end.
ಇಲ್ಲ, ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಅಂತ ಹೋದಾಗ
ಅದು ಕರೆಕ್ಟ್, ಅವಾಗ್ಲೇ ಮಾಡಂಗಿಲ್ಲ. You can't go on filing documents.
seeking permission.
Odd 11 rule 1 does not permit that. Commercial wise.
ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೇಳಿದೆ ಸ್ವಾಮಿ. ಅವರು ಮೇ ಬಿ ಅಲೌಡ್ ಅಂತ ಹೇಳಿದ್ರು previous occasion.
Last date, I have no, as a matter of fact, 4 of the documents. have already been- Four of the documents have already been marked. So I didn't actually make a difference, but
He
even
accepts, no problem. Otherwise 11-1 will not permit.
That was in the custody of my head office, my lord. 7.5-year-old document, my lord. Therefore,
It can't be. You are aware of it. What is this?
I know it shouldn't ideally be allowed, but if it make it easier for my.
At the stage of evidence, you go on producing documents in a commercial law, it's not defeats the provision itself.
Because ideally, that was my position before the court, my lord. And also those documents on their custody, just to make it easier, it said it may be allowed, but the thing is, only problem was they're preparing the proposal form and they had produced.
but that is the basis for issuance of the policy, my lord. That's it.
Like, they are producing the documents, not me.
Let the proceedings go on. We'll stay this.
My lord.
We'll stay the order, let the
ಅಲ್ಲ,
proceedings go on.
they are producing the documents, ನಾನಲ್ಲ.
Application ಹಾಕಿದ್ಯಾರು?
ಅವ್ರ application different ಹಾಕ್ತಾ ಇರೋದು, ನಾನಲ್ಲ.
Order, that is rejected.
That is rejected.
ಅದಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ
Correctly rejected.
ನಮ್ಮ ಇದರಲ್ಲಿ ಇತ್ತು ಸ್ವಾಮಿ ಅದಕ್ಕೋಸ್ಕರ. That is the basis, my lord.
No, no, sir. ಆ ತರ ಜಡ್ಜ್ಮೆಂಟ್ ಟೈಮಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ ಬಿಟ್ರೆ?
ಇಲ್ಲ ಇಲ್ಲ ಹಂಗಲ್ಲ.
No, sir.
Along with written statement.
No, 11-1 does not permit.
Then I will be losing that opportunity.
No, no, sir.
That is the basic document ಅದಕ್ಕೋಸ್ಕರ.
You should have produced it. ಅದೇ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತಾ ಅದು?
ಇಲ್ಲ, ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಆದ ತಕ್ಷಣ ನಮ್ಮ ಎವಿಡೆನ್ಸ್.
ಅರೆ ಆಯ್ತು, ಅವಾಗ ಗೊತ್ತಾಯ್ತಾ ನಿಮ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಅಂತ? ಡಾಕ್ಯುಮೆಂಟ್ ಆಫ್ 7 years. You should have produced it.
was in the custody of my head office. Previous occasion ಅವರು ಅಲೋ ಮಾಡಿಬಿಟ್ಟು ಅವ್ರಿಗೊಂದು
ಅಲ್ಲ, ಈಗಲೂ ಒಪ್ಕೊಂಡ್ರೆ ತೊಂದರೆ ಇಲ್ಲ.
My only position is, my lord, there is a proposal form, it is not signed by me, may be allowed, but it will be, let me be permitted to lead rebuttal evidence and for, and amend my pleadings.
The petitioner is before this court calling in question an order dated 22/7/2025 which rejects an application IA3 or filed under Order 11 Rule 1 of the CPC seeking production of documents at the stage when at the stage of cross-examination of at the stage of defendant's evidence. The concerned court, in terms of its order dated 22nd July 2025, rejects the said application. The learned counsel appearing for the petitioner submits that those documents were necessary to be produced at it was the basis of the claim, a basis of the claim of the defendant. The learned counsel of the plaintiff submits that the application may be permitted to be allowed, but the petitioner should have the liberty of rebuttal evidence and
To
amendment.
amend my pleadings.
Allah, wholesale illegality.
ಅಲ್ಲ ತೊಂದ್ರೆ ಏನಂದ್ರೆ ಪ್ರಪೋಸಲ್ ಫಾರ್ಮ್ ಅನ್ನೇ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಇವಾಗ ಅಂಡ್ ಸರ್ವೆ ರಿಪೋರ್ಟ್
And would seek liberty to file amendment of the pleadings in the event the documents are, no, that will be an illegal order. Won't be.
No problem. Then, my lord, I cannot allow I cannot consent for the documents to be allowed because the proposal form, it is signed by the agent. ಅದನ್ನ ಇವತ್ತಿನವರೆಗೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಪ್ಲಸ್ ಸರ್ವೆ ರಿಪೋರ್ಟ್.
Oh, no, sir. Then we will not pass out as contrary to the statute. ನೀವು ಕನ್ಸೆಷನ್ ಕೊಟ್ರೆ ಏನ್ ಬಿಟ್ಟು ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
I cannot consent for that, my lord. Let him not.
No.
ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೀನಿ ಅದು.
ಇನ್ಶೂರೆನ್ಸ್ ನೀವು
ಹೌದು ಸರ್.
ಮತ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ.
ತಮ್ಮ ಗಮನಕ್ಕೆ ಕೊಡ್ತೀನಿ. ರೆಸ್ಟ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಇದೊಂದು ಡಾಕ್ಯುಮೆಂಟ್.
No, then he will say, he is saying he wants amendment of the pleading.
If necessary.
Where is if necessary? Where is the question of permitting it? Let's say we'll pass orders tomorrow if possible. List tomorrow. The petitioner is before this court calling in question an order of the First Appellate Court in MA 4 of 2023 dated 1/4/2025 by which the order of the trial court is set aside 3 years after its grant. In that light, the order of the First Appellate Court shall remain state till the next date emergent notice to the respondent.
Grateful.
Next.
Lord's petitioner, kindly have it on Thursday, my lord.
Both of you are there.
Arguing.
Let it go before the trial court back. Both of you are represented. 39(1) and 2 is not granted. You are here.
Yes, my lord. Kindly have it on Thursday, my lord.
No Thursday, sir. In 3 weeks, I will direct the court to consider after hearing the parties.
This court can't be relegated to
No,
a
no,
trial
sir.
court.
The petitioner is before this court seeking the following prayer. Heard the learned counsel appearing for the petitioner, the learned senior counsel J.L. Vishwanath representing the respondent. The petitioner is the plaintiff institutes a suit in OS suit for
Declaration and injunction.
Suit in OS 25648 of 2025 seeking declaration and injunction. The concerned court does not answer the application 39(1) and 2, keeps it pending and issues emergent notice to the respondents. It is therefore the petitioner is before this court seeking an injunction which was not considered by the concerned court. The learned, since the parties are now represented, I deem it appropriate to dispose the subject petition, directing the concerned court to consider the application under Order 39 Rule 1 and 2 with an outer limit of 3 weeks after hearing the parties and in accordance with law.
But 3 weeks may be difficult because there are other defendants also. I am only appearing for 2 defendants. I am responsible.
6 weeks.
6 weeks. There is section 10 or your lordship may say 4 weeks after service of notice on all the defendants. Because he has not yet taken out notice to the defendants.
So, yes. Hele.
One more submission, my lords. I appear for respondent number 7. Section 10 application is pending before trial court filed by respondent number 4.
Adalla alle maadi. Let's not get into all that here. Yes.
Notice is not complete.
Within 6 weeks from the date of receipt of the copy of the order, if not earlier. Yes. Next, ordered according. All contentions remain open. Next.
Appear for the caveator respondent, my lord.
For the petition.
Additional issue.
Additional
So
issue.
what?
I had actually mentioned that in the written statement as well in the first place. Since it was not framed, I filed an application and that came to be rejected. This is a Canadian national.
Canadian national?
Canadian national
What
was the
happened?
petitioner here. And my contention is that she has not been, she was not in India at the time of filing the suit. And this goes to the root of it because she has sworn in the affidavit.
What
that
are
she
the
was in
issues
India.
framed now?
Issues framed are
Turnover would find at page 78, my lord.
Page?
Whether the plaintiff
78.
proved that she's in possession of
Page
such, so
78
suit schedule
along
B and C.
These are incidental factors which can be decided.
But the root of the issue is that, she was not in India is something that I have contended in the written statement in the very first place itself. And that is basically what I had contended, saying that, and following the rejection of, the not framing of this issue, I had filed an application as well, saying that, this has to be framed, and that came to be rejected. That is why I'm here before this honorable court, because, if it was a Indian national.
What
yes,
happens if that is there?
I just responded to last, my lord. The respondent, the plaintiff, is a 70-year-old lady suffering from Parkinson's.
That is.
She had come.
Wait, sir.
She has come down to India in January of 2024. She has a property and he's my neighbor itself. On 7th of March, when she was very much over here, they have blatantly gone ahead and put a painting on my gate saying that, just telling what the facts is, that this property belongs to me, Anta. So on 28th March, I filed a suit for injunction, bare injunction. The issues has been framed by the lower court with regards to I prove my possession, but there's been interference and what order degree. That's the crux of the matter, my lord. After granting of injunction, for 1 year, they don't go ahead and file WS. 1 year later, they file WS. That's the merit of the matter, which is allowed itself. Each and every time, such applications are filed only to protract and prolong. Previously, they filed another application. There was a contempt of which is pending over here. Now, my lord, when they filed application for recasting of issues, I have filed my objections that your honor would find at page number 77.
Yes.
I've clearly explained what my suit is for, what the issues are framed, what is the whole aspect, and how this is only an endeavor to expand the scope. And kindly see para 11, my lord. The plaintiff submits that for avoidance of any doubt and for the sake of progress in the case, the plaintiff here, Bafum Chachi, was very much in Bangalore at the time of institution of the present suit. The plaintiff submits she came along with the husband and so and so.
You can
date.
contend all that.
And
He is the
along with
plaintiff.
that,
All I'm saying is.
It is his headache to prove injunction. Why are you worried?
I just also filed. This was filed in the lower court. He's not produced it. I filed the flight tickets, my immigration, all of it, my lord.
That is
Which
not
goes
the
on to
evidence
say,
that can be.
and
Anything else, sir? Dismissed.
Grateful.
Next.
Please, your lordship. Now, the petitioners who are the purchasers of the sites, after conversion of the land, my lord.
He heard the learned senior counsel Vignesh Shastri appearing for the petitioner. The petitioner shall serve on the counsels representing the respondents slash contesting respondents, comma, in contesting 13,
30.
Obrena.
Respondents 1 to 6 months.
Mikkorge memo kodi bedandre, so and so. He lists the matter on 22nd. Status quo, the property be maintained till the next date of hearing.
Appear on behalf of the petitioner. Pray for a week's time.
Why? You've not seen the papers?
No, senior
The
is in a different court.
Petitioner is before this court calling in question an order dated 3/7/2025 which allows an application in Order 7 Rule 10 of the CPC. Order 1 Rule 10 of the CPC seeking permitting a stranger to implead into these proceedings. The application ought not to have been answered, albeit prima facie. In that light, further proceedings before the concerned court shall remain stayed. The petitioner shall serve on the counsel who represents the respondent plaintiff before the concerned court and file an acknowledgement. List the matter on 24th.
Please.
Next, yes.
Petitioner's counsel. What had happened is that.
Which order is that?
First of all, the non-grant of order. Thereafter, we tried to advance the case. On 1st August, we tried to advance the case.
Which is this court's order? Yavadu, sir?
In the writ petition.
Ah.
Yes, that your lordship should get at page 162. I'm sorry, I stand correct. That is the 201. I'm sorry, annexure Q. That is the writ petition. But this they've carried on appeal in a writ appeal. But here there was, my lord, he had some interim order of protection. Now the difficulty is, I have an agreement of sale.
Why did the advancement application? Why is the advancement application rejected?
It is not taken, my lord, at all. There is an affidavit to that effect that has been filed. Your lordship may please see page 252.
Writ appeal stage, yeah.
Writ appeal, there is an order not to precipitate. But that is quay DC, not my lord me. That is quay the DC. That is quay, because he is my lord running a petrol pump there. The difficulty is this. Nothing prevents him from creating third party rights and defeating my agreement. I paid him 2 crores out of the 3 crores.
ಅದೆಲ್ಲ
He's
ಆಯ್ತು.
avoiding service of notice.
No problem.
Yes.
But if there is an order by the division bench not to precipitate.
But that is against the DC. I'm sorry, it's an undertaking. No, my lord, I'm sorry.
Parties are the same.
Illa, my lord, they're not. I must tell your lordships that there, what he challenges, that's why I placed the writ petition also. The challenge in that writ petition
Sir,
is that
this is the respondent is the petitioner in writ
in
petition.
the writ petition,
Correct.
before my lord Danrod bench. Yes,
All right.
that's correct.
Who has filed the writ appeal?
It's filed by him, the respondent before your lordship, the original
Filed the writ
petition.
appeal.
That's correct.
In that writ appeal, there is an order not to precipitate.
Against the DC, my lord.
Correct.
Insofar as
Who are you?
I am, my lord, and a person who has agreed to purchase the property from him. I have a registered agreement from him. In that writ petition, his right to continue the petrol pump or not to continue is in question. I'm just placing that, my lord, for full order. Here, I have an agreement. Your lordship, please see, I have a registered agreement to sell. Please see page
No, ಅದೆಲ್ಲ
44.
ಆಯ್ತು. But
I am seeking protection in respect of that. Notices 4 times, my lord, since April, he's been avoiding service.
No problem about that. No qualm.
And
I
I'm
will
seeking hand summons
I will
that-
direct consideration of the application, but that should not run counter to the pending.
It is not running counter.
No,
It would not. In fact, your lordship would please see the original prayer before the writ petition. I'll just point that out to your lordship. Please be kind enough to take page 169. He asks that the endorsement or the letter issued by the DC asking Indian Oil to stop supply of petrol to him should be stayed. That is what was, my lord, challenged by him. It has nothing to do with the private rights. In fact, learned single judge while dismissing would say private
When-
rights be worked out in separate proceedings like arbitration and suit. In fact, he files a suit, no interim order against me.
We'll hear him.
But the difficulty is I'm not able to serve him. If your lordship's orders notice on him, it is as good as, my lord, him avoiding. Because in the section 9 petition,
No, he is running a petrol pump.
he is running a petrol pump, but since April,
Petrol pump is not available, is it?
my lord, because illinda we even asked for hand summons.
ಧಾರವಾಡದಲ್ಲ.
Idu Belgaum.
ಬೆಳಗಾಂ.
The petrol pump is in Belgaum, seat is Bangalore, Saundatti. It's in Saundatti in Belgaum district. Now the difficulty is this, he avoids notice, service of notice. He receives arbitration notice which was issued even prior to this. That, my lord, he replies to. Section 9 notice he is avoiding.
With the division bench problem.
No, my lord, your lordship may make it clear insofar as
No,
without.
I can't make something clear for the division.
There is no order, my lord. It is an undertaking given by the DC saying he would not precipitate matters till the next date. That is an undertaking insofar as not to, my lord, insofar as the supply of
Not to
petrol.
disturb him.
Yes, that's correct.
From the petrol pump.
No, my lord, here is the difficulty I am facing. And this is, please see the interim prayer that I have sought and that I am seeking from your lordship's hands. What I am seeking is only to say that he should not alienate or create third party rights. That's all I am seeking. That is the limited prayer that I am seeking. Please be kind enough to see page 30. And I have a registered agreement where I paid 2
Heard
crores.
the learned senior counsel, C.K. Nandakumar, appearing for the petitioner. Emergent notice to the respondent petitioner. Shall, counsel ಯಾರಿರ್ಲಿಲ್ವಾ?
Illa. Because nobody is appeared. He's avoided service in the section.
Petitioner,
That is the difficulty.
hand summons?
My lord, we sought hand summons from, my lord, the trial court. That was not granted.
No, now he'll come. Right. The respondent shall be served by any modes of service, hand summons or otherwise. The respondent, there shall be the petitioner seeks the following interim order. There shall be an interim order as aforesought till the next date of hearing. Now he'll come.
Great. So great.
ಅದು ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಇತ್ತಲ್ಲ ಕೊಡಿ.
ಹೌದು 6 ಕೇಸು
ಎಲ್ಲ ಕೇಸಸ್ ಒಂದೇ ದಿನ ಹಾಕೋಣ.
ಒಂದೇ ದಿನ. Let the process be completed, my lord, for first R1.
ಅಲ್ಲ ಪ್ರೋಸೆಸ್ ಎಲ್ಲ ಫಸ್ಟ್ ಮೇಂಟೈನಬಲ್ ಆಮೇಲೆ.
ಇಲ್ಲ entertainable ಅಂತ Supreme Court has held.
ಅದೇ that is one judgment.
Between entertainability and maintainability.
No, that I know, sir. Godrej Saral, Supreme Court has said what is entertainable, what is
And then in
maintainable.
the similar matter.
Every writ petition is maintainable,
my lord,
whether it
in-
is entertainable.
My lord, in similar nature, the coordinate benches have allowed the writ petitions. So I will place all the.
Section 34 ಹೋಗ್ದೇನೆ ಇಲ್ಲಿ ಬಂದು.
ಹೌದೌದು 34 ಹೋಗ್ದದೆ ಇಲ್ಲಿ ಬಂದು ದಿಸ್ ಆರ್ ಎಂಟರ್ಟೈನಬಲ್ ಅಂತ ಹೇಳಿ ಇಟ್ಸ್ ಓನ್ಲಿ ಟೆಕ್ನಿಕಲ್ ಎರರ್ ಅಂತ ಹೇಳಿ ಇಟ್ ಹಾಸ್ ಮೌಲ್ಡ್ ಇಟ್.
ಅದು ನಂಬರ್ಸ್ ಕೊಡಿ ಎಲ್ಲ.
ಇದು ಕೊಟ್ಟಿದ್ದೀನಿ ಮೆಮೊ ಕೊಟ್ಟೆ ಈಗ.
ಯಾರ್ಯಾರು ಇದಾರೆ ಅದರಲ್ಲೆಲ್ಲ? Tag these petitions along with so and so.
ಇವತ್ತೇ 5 ಬಂದವೆ.
ಇವತ್ತಿಂದೇನ ಇದೆಲ್ಲ?
ಅಲ್ಲ ಒಂದು ಬಂದಿಲ್ಲ.
ಅದು ಬಂದಿಲ್ದೇ ಇರೋ ನಂಬರ್ ಕೊಡಿ, ಅದು ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಡ.
ಅಲ್ಲ ಈಗ ಎಲ್ಲ
The learned
55 57.
ಒಂದು ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ Shanti Bhushan,
ಇಲ್ಲ KS ಭೀಮಯ್ಯ ಬೇರೆದ್ರಾಗೆಲ್ಲ ವಕಾಲತ್ ಹಾಕ್ಬಿಟ್ಟು
Bhimaya ಹಾಕಿದಾರ?
ಹಾಕಿದ್ದಾರೆ.
KS Bhimaya 1, 2, 3 ಯಾರು?
ಸುದರ್ಶನ್ ಸುರೇಶ್
Sudarshan Suresh, 4 HCGP.
ಗೌರ್ಮೆಂಟ್
ಈ 5 petition ಅಲ್ಲೂ same.
ಆರು ಇದೆ.
6ರಲ್ಲೂ same order. Petitioner to serve set of papers upon the aforesaid counsel,
ಎಲ್ಲ
if not
ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀವಿ.
already served.
ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ ಎಲ್ಲ.
If not already served, yes. List on 22nd.
ಅವ್ರು ನ್ಯಾಷನಲ್
Yes, next. 22ಕ್ಕೆ ತೀರ್ಮಾನ ಮಾಡುವ.
55, 57
ಅಲ್ಲಿ ಹೇಳಿದಿರ ಕೊಟ್ಟಿದಿರಲ್ಲ ಈಗ. ನಂಬರ್ ಸೇವ್ ಬಿಡಿ, ಅದು ನಂಬರ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಅದೇ 55, 57 ಅಂಡ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 35.
ಮೂರೇನಾ?
ಅಲ್ಲ 35 ನಲ್ಲಿ ಎರಡಿದೆ, 35, 35.1, 55, 55.1, 57 ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಆಯ್ತು. Yes. Tenant.
No, lots. Lots of siblings, lots, partition suit. Lots, the court commissioner, lots has done, lots, the Mazar, lot that is in dispute, lots. Lots, I may be permitted, lots, to file execution first appeal, lots, before this court, lots. It is already disposed of, lots.
Which one?
Execution is disposed of.
Disposed?
Yes.
Learned counsel to the petitioner submits in the pendency of this petition, the execution case in execution number 25031/2025 is already disposed. Therefore, the petition stands disposed, leaving open the remedy available to the petitioner. Yes. Leaving open the petitioner to avail of the remedy available. Next. Ordered accordingly.
For the petitioner, my lords. This is an ex parte order, my lords.
ಇದು ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ?
Vapas, my lords.
Tirumalesh.
He's appearing on BC.
Yes, Tirumalesh sir.
Yes, my lord. Yes, my lord.
Go back, huh?
Yes, yes. Go back to the stage of 142(1), Annexure B, my lords.
The petition stands allowed. In part, the matter is remitted back to the hands of Yariga.
Respondent 1.
The first respondent.
Back to
From the stage of
142(1), reply to.
For stage of submission of reply to a notice issued under section 142(1)
Annexure
of the act.
My lords, Annexure A, A1, A2, A3. It needs
ಇಲ್ಲಿ
to be set
prayer
aside.
ಕೇಳಿರೋದೆಲ್ಲ quash ಮಾಡಿ. Quash, the matter is remitted back to the so and so, ಆಮೇಲೆ ಬರೀರಿ, ಬರೆದ್ಬಿಟ್ಟು. To petitioner is at liberty to furnish, submit his reply to the said notice, and the first respondent shall take the proceedings to its logical conclusion in accordance with.
Grateful, my lords. Obliged.
My lord.
ಇದು ex parte, madam.
Please, my lord.
Oh, simple GST matter.
Please, my lord.
Yes, M. Kumar. 2 notices issue ಮಾಡಿದೀರಾ?
ಆಡಿಟರ್ಗೂ ಅವ್ರಿಗೂ ಏನೋ.
My lord,
Oh,
this is.
correct.
My
Pass
lord.
the buck on the
My lord,
CA.
Put case on merits, my lord. These are all pre-GST contracts that are entered into and offered to tax under the VAT regime, my lord. If his books are reconciled, the entire demand will go away. There's 100% penalty imposed.
So we'll
as
not
well.
send it back just like that and decide it here.
My lord, he's an electrical works contractor for rural areas, my lord. He is not well aware of what is undergone here, my lord. His duly appointed representative has not represented him properly. All we're asking for, my lord, is a simple remand.
That we will grant.
Please.
Yes. Yes, M. Kumar. Costa.
My lord, consider this matter.
Their own mistake.
I'm at the mercy of this court. My lord.
Yes. ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕಾಸ್ಟ್ ತೆಗೆದ್ಬಿಟ್ವಲ್ಲ ಆಮೇಲೆ ಇಂಪೋಸ್ ಮಾಡಿ. Yes. The we'll send it back to whom? First respondent, second respondent.
Respondent, my lord.
Which is the notice? So we'll send it back to the stage of
Annexure E, my lord, at
73(1),
page 30.
Annexure E.
Page 34. F1, F2G, H1 and H2 will have to be quashed. my
That's
lord.
correct. Which is the notice issued to you for you
Annexure
to
E,
appear
my lord.
now?
Annexure E is the show cause notice, page
That is
34.
clause 4 of the prayer
Please, my lord.
at page 18, correct? The petition stands allowed in part. The allowed so and so. The matter is remitted back to the hands of the second respondent to the stage of reply to the show cause notice so issued on 27/4/2023. In the light of the fact that the proceedings drawn against the petitioner is ex parte, notwithstanding the fact that the two notices were issued and the petitioner has not appeared in terms of what the learned learned AGA would submit. Nonetheless, the proceedings proceedings being ex parte, the order passed in a proceeding which is ex parte, and all the consequential orders would necessarily to be obliterated and matter remitted back to the hands of the second respondent to direct the petition to furnish a reply and take the proceedings to its logical conclusion in accordance with law.
Grateful, my lord.
Yes. Data appearance.
File the reply to the show cause notice.
You will not file at all. 4 weeks.
Please, my lord.
The petitioner shall file the reply to the show cause notice as directed within 4 weeks from the date of receipt of the copy of the order. In the event no reply would be filed within 4 weeks, the orders, it is open to the second respondent to pass necessary orders in accordance with law.
Grateful, my lord. 60.
Petition. What's this a matter?
Avat same
Please, notes.
Avat dispose madadalla adena
Idalla. Ada ITC block. This is a matter.
rectification tane idu.
Rectification. This was not disposed.
We issued an endorsement asking them to come and appear for personal hearing.
With annexures.
Inadvertently, my lords, we had to summon certain documents. That was not uploaded on the go-ahead because there was no provision to do it. Let them appear on a particular day, my lords. We'll, with all the documents, we'll redo.
List they have to give.
Ashta.
The application for rectification may be restored.
Both 61 adena.
Please.
The petitioner is before this court seeking the following prayer. The petitioner, the respondent institutes certain adjudicatory proceedings under section 73 of the GST Act 2017. In the proceedings, the petitioner files an application seeking rectification. The rectification application, in reply to the rectification application, certain documents were sought, is the submission of the learned counsel, learned AGA. But what was sought was not uploaded on the portal, which the petitioner was not aware of, and therefore further proceedings are taken up. In the light of the said submission of the learned AGA, I deem it appropriate to restore the rectification application that was pending at the time when the documents were sought to the stage of rectification application and the documents that were sought for the petitioner to comply with the so sought documents and the respondent to take the proceedings to its logical conclusion. In the light of the aforesaid reasons and the submissions, the impugned order shall stand quashed. All contentions of both the parties shall remain open before the concerned court. Yes.
They have to give me a list, please, my lords.
Upload ಮಾಡ್ತಾರೆ ಈಗ. Oh, sir. The ಮೇಲೆ ಒಂದು ಪ್ಯಾರಾ ಹಾಕೊಳ್ಳಿ. The learned counsel, learned AGA submits that the documents that are necessary for considering the application for rectification cannot be uploaded, and therefore, if the petitioner would appear before which respondent?
Only respondent.
Before the respondent, the necessary list of necessary documents will be furnished to him. In that light, the petitioner shall appear before the respondent on the 11th of September at 2:30 p.m. At which 2:30 p.m. the respondent shall take the proceedings to its logical conclusion, bearing in mind the observations made herein above.
13th, 11th is second Saturday.
11th second Saturday na?
Sorry.
July ನೋಡ್ತಾ ಇದ್ದೀರಾ?
Sorry, 15th.
July ಬಿಟ್ಬಿಡಿ ಸರ್.
ಇಲ್ಲ 15th.
11th September ಹೇಳಿದ್ನ.
It may be had on 15th, please.
Monday. Yes. Clubbing order rejected.
Clubbing order.
It had to be allowed.
3 schools.
Yes. 3 schools. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 24th. Further proceedings before the concerned court. Which proceeding have you sought?
The stay of further proceedings.
Further proceedings in OS 387 of 2012 shall remain stayed till the next date.
63 is also the same.
Same. Barkondidu same. Yes.
On 24th, not if it could be listed with another connected matter.
Kodi.
I'll tell.
Yes, Puneet. 1817.
Please, my lord.
Hmm.
Lord, 1981, 27/4/1981, please, my lord.
ಎಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
Sir, ಮಾಡಿದೀನಿ. I filed the acknowledgement also.
ಹ್ಮ್.
Lord, 27/4/1981, my synopsis for a moment. My lord, father of the petitioner, my lord, purchased, my lord, from the husband of the plaintiff. In the year 2014, please, my lord, without arraying me as a party to the
ಆಯ್ತು,
proceeding.
one opportunity we will grant.
Please.
ಅಷ್ಟೇ.
Application ಅಲ್ಲೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ ನಾನು. I am ready to cross examine on the date of filing of the application itself ಅಂತ.
Will let the council come. What the next date?
My lord, date is on 19th
September.
September.
We'll take it on Monday, by then if they come. Yes. They heard the learned counsel appearing for the petitioner. The averments in the petition, the submission so made by the council would prima facie indicate that one opportunity should be granted to the petitioner to cross-examine PW1,
PW1.
Cross-examine PW1. The concerned court has rejected the said application. Awaiting the appearance of the counsel for the respondent, list the matter on 8th.
Please, respondent number 1, my lord.
Respondent 1, plaintiff.
Respondent number 2 is my mother. She
No,
will
right.
not.
Respondent number 1, plaintiff.
Please. Not in preliminary hearing.
Preliminary hearing only.
Please.
No, why I recorded that is he would know what would be the order.
Please.
This number 2.
2, yes.
Preliminary hearing, still number 1.
ಕೊಡಿ. No representation, list after 2 weeks, next.
Still number 2.
Objections ಹಾಕಿದ್ರಾ?
My lord, seen counsel ಗೆ ಹುಷಾರಿಲ್ಲ ಸರ್.
ಹುಷಾರಿಲ್ವಾ?
2 ದಿನ ಅರ್ಜೆಂಟ್.
Objections ಹಾಕಿದಿರಲ್ಲ?
I'm appearing for respondent 2.
Learned counsel appearing for the respondent, representing the respondent, learned counsel representing the second respondent submits that the arguing counsel is indisposed. Therefore, as a last chance, list this matter on 10th September. In B group.
I'm for the petition.
In B group.
Number 3.
This matter was heard by your lordship. The
My lord, I
compromise
took
was.
time, my lord, telling that if there is any.
Yes, sir.
My lord, producing the document, my lord.
ಈಗ I'll restore the petition there.
No, my lord.
Why, sir?
For this reason, they have already filed one more execution petition. They have suppressed that. In that execution petition, he has clearly told that there was a joint memo entered between the parties. In the joint memo, it was.
ಯಾವುದು ಬೇಡ, adjacent land ಗೆ ನೀವು ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, my lord, may I submit? It is there, my lord. Yes, for the adjacent land, we have given 105 rupees. We have given, my lord. My lord, after entering into the joint memo, before going for appeal, they have entered into joint memo. After entering into the joint memo, now they have filed suppressing these things, my lord, telling that we have entered into the joint memo. Other things suppressing those, my lord, they have approached this honorable. Their only prayer is, my lord, they have not signed the joint memo, my lord. That is the only prayer before.
That is enough,
my lord. But they themselves agree, my lord. They were well aware of the joint memo.
What sort of justice
My lord,
is
I
this?
am not.
Listen, 45 rupees ಪಕ್ಕದ ಇವ್ರಿಗೆ ಪಕ್ಕದಲ್ಲಿ 105 rupees. Adjacent land.
ಅಲ್ಲಲ್ಲ.
Who will compromise? Who will enter into a compromise like this?
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಆಗಿಲ್ಲ ಸರ್.
ಸರಿ.
ಇಲ್ಲ ಅದ್ ಆದ್ಮೇಲೆ ಆಗಿರೋದು ಅದು. ಕಾಂಪ್ರಮೈಸ್ ಮುಂಚೆನೆ ಆಗೋಗಿತ್ತು.
ಎಷ್ಟು ದಿನ? ಎಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ ಆಗಿರೋದು?
My lord, it is in the year 2015. ಇದಾಗಿರೋದು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು.
105 ಕೊಟ್ಟರದು ಯಾವಾಗ?
2020.
ಎನ್ಹಾನ್ಸ್ ಆಗಿರೋದಾ ಅಥವಾ ನೀವೇ?
ಎನ್ಹಾನ್ಸ್ ಆಗಿ ನಾವು ಕೊಟ್ಟಿಲ್ಲ. ಎನ್ಹಾನ್ಸ್ ಆಗಿದೆ by this honorable court, my lord. It was enhanced. We went to Supreme Court. Supreme Court upheld that. That is the thing, my lord. We did not enhance.
Compromise ಹೆಂಗೋ ಜಾಯಿಂಟ್ ಮೆಮೊ ಸೈನ್ ಮಾಡಿಲ್ಲ ಅವರು. That's enough.
My lord, ಅಲ್ಲ compromise.
That's enough.
My lord, ಆದ್ರೆ they agree in the.
No, I am not determining anything. I will only restore the LAC. I will only restore that. Let it be fought. All contentions will remain open there.
Please, my lord. I agree.
Correct.
My lord, may I submit one thing, my lord. My lord, they have suppressed, before coming to this honorable court, my lord, they have suppressed these things. We are bringing to the notice of the court, telling that they have entered, they were well aware of the joint memo. He himself, my lord, he has
ಲಾಸ್ಟ್
failed.
ವೀಕ್ ಹೇಳಿದ್ದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀರಾ
Illa, with the document, my lord.
ಏನದು ಕೊಡಿ.
My lord, this is the execution, one more execution which is pending. They did not bring to the notice of this honorable court, my lord.
ಯಾವಾಗ ಹಾಕಿದ್ದು?
ಅದು 2018 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಇದೇನಾಯ್ತು?
ಇದು ಇನ್ನೂ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಇದ್ರಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಳ್ಳಿ.
Please, my lord.
What has happened is, in the earlier execution, I was entitled for 1,33 lakhs. My advocate.
Are you aware of this?
I have stated that in my petition.
No, my lord.
Second execution.
ಹೇಳಿದ್ದೀನಿ.
ಹೇಳಿಲ್ಲ.
Page number 8, paragraph number 10.
Please, my lord. Case number ಹೇಳಿಲ್ಲ, ಏನು
Will
ಹೇಳಿಲ್ಲ.
restore it.
Case number ಹೇಳಿಲ್ಲ, but I have stated that I have filed a fresh execution.
Will restore it and.
ಅಲ್ಲ, ಇದು ಇನ್ನೂ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. Let them decide before this honorable court. ಅಲ್ಲ.
Our enhancement ಗೆ let is right for enhancement will be.
ಇದೆಲ್ಲ
Sir, as simple as this, sir. ಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಗೆ ನೀವು ಒಂದು 105 rupees ಕೊಟ್ಟು ಇವ್ರಿಗೆ 45 rupees ಕೊಟ್ರೆ ಯಾರಿಗೆ ಸುಮ್ಮನೆ?
ನಾವು ಇವ್ರಿಗೂ 100, ನಾವು ಅಂದ್ರೆ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗ್ರಾಂಟೆಡ್ my lord 100 rupees. ಅದರಲ್ಲಿ ಡೆವಲಪ್ಮೆಂಟ್ ಚಾರ್ಜಸ್ ಅಂತ, ಆಸ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಕನ್ವರ್ಟೆಡ್, ಅದರಲ್ಲಿ ಡೆವಲಪ್ಮೆಂಟ್ ಚಾರ್ಜಸ್ ಅಂತ 53 rupees ಡಿಡಕ್ಟ್ ಮಾಡಿ 47 rupees ಕೊಟ್ರು. ಪಕ್ಕದಲ್ಲಿ ಅದು 150 ಆಗಿ 150 ಲಿ 45
150 ಆಗಿ
ಅದು 2020 ಲಿ
ಪರವಾಗಿಲ್ಲ.
my lord, ಆಯ್ತು ಅದು
enough of hearing it.
ಅಲ್ಲ, only one submission. They would have brought this, telling that before the MFA only, which they have filed. ಅಲ್ಲೇ ತರಬಹುದಾಯ್ತು ಇದನ್ನೆಲ್ಲ, ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ನೆಲ್ಲ ಅಲ್ಲೇ ತರಬಹುದು. They did not mention anything. They withdraw the MFA without bringing these facts to the court, my lord. They withdraw.
Justice Alokara ದೇವರ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Please, my lord. My lord, kindly come to page number 51, my lord, of their petition. Without liberty, my lord.
Where is the memo you filed? ಬರೀ ಇದು ಅಷ್ಟೇ.
Seeking permission to withdraw.
ಮತ್ತೆ
Only on that day, my lord, I came to know that there is a compromise. Earlier I was not aware of
my lord,
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ MFA ರೆಸ್ಟೋರೇಷನ್ ಕೇಳಿ ಅಲ್ಲಿ.
That's what, my lord. That is my this one.
Seek restoration of the MFA, then do it. Because division bench, no liberty is sought. Definitely you have a case for restoration, but in the teeth of this division bench order.
Lord, I have sought two prayers in this petition. One is to set aside the compromise. Second is to reserve liberty to file appeal seeking enhancement.
Correct. ಅದು ಇಲ್ಲಿ ಆಗೋಗಿದೆಯಲ್ಲ.
The compromise set aside.
They are intertwined, sir.
Pardon me.
They are intertwined. You have to seek leave of the court to restore this MFA.
My request.
ಅದರಲ್ಲೇ ಹಾಕೊಳ್ಳಿ, ತೊಂದರೆನೇ. ಆವಾಗ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಗೆ ವಾಪಸ್ ಬರುತ್ತೆ ಎಲ್ಲ.
Yes. Compromise may be set aside.
ಈಗ ಕಾಂಪ್ರಮೈಸ್ is before the order 13 January 2020 ಒಳಗೆ.
ಅಲ್ಲ, that is true.
ಇದು ರೆಸ್ಟೋರ್ ಮಾಡಿ ಬೈ ಡೀಟೇಲ್ಡ್ ಇದು.
ಅಲ್ಲಿ ಬರುದಿಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಅವ್ರು ಏನಂತಾರೆ, there is a compromise ಅಂತ ಹೇಳ್ತಾರೆ. Before the division.
Whatever they are submitting here, they can submit there. We will do our this one.
You will do your best to dismiss it.
No, my lord, not like that, my lord. Kindly come to page number 4. They agree in the second execution petition that telling that I was aware of the compromise petition.
First seek restoration of this and
compromise may be set aside.
First you seek restoration of this and come back.
Not until and unless compromise is set aside. Not they
first
will come
you
and
seek
say,
restoration of this, then we will consider compromise. Yes, what do you do?
I leave it to your lordship.
Leave it and I'll dismiss it straight away.
Dismiss.
Yes. ಇಲ್ಲ ಇದನ್ನ restoration ಕೇಳಿ.
I will file necessary application for the division. I will file necessary application for division.
While the petitioner submits that a necessary application will be preferred in MFA 5625 of 2016, which had closed the proceedings on the submission of the appellant that he had sought to withdraw the appeal. The issue in the list relates to acquisition of land. Insofar as the adjacent land of the petitioner, the division bench in terms of the order dated 18th January 2021 enhanced the compensation and capped it at 105 rupees after all the deductions. The land of the petitioner is adjacent. Brother Dadu?
Yes, ma'am.
And adjacent and that of the brother of the petitioner. The comparative table is placed before this court. It reads as follows, page 18, flag. A perusal of the comparative table would clearly indicate that the petitioners, the appeal as aforesaid is withdrawn, and by the same bench, an amount of rupees 105 is awarded. The withdrawal of the appeal comes about on the score that the parties to the list have entered into a compromise. The compromise, the joint memo so filed for compromise in 59 of in execution 59 of 2011 is as follows. It is not signed by the petitioner. Therefore, a joint memo which did not contain the signature of the petitioner froze all rights of the petitioner to seek enhancement. On the basis of the joint memo, it transpires that the petitioners sought withdrawal of the appeal on certain obfuscation. In the light of the withdrawal of the appeal pending appeal before the division bench, it is the learned counsel now submits that he would file an application, necessary application before the division bench, bringing it to the notice of the division bench, all these factors. In that light, list the matter on 25th September.
Please.
Yes. The order produced ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಏನು.
Please.
Next. But ಈ ತರ ಅನ್ಯಾಯ ಮಾಡಬಾರ್ದು.
My lord, sorry, my lord. He is entitled for that, my lord. He has suppressed. ಅವ್ರಿಗೆ ಆ ಮಾತು ಹೇಳ್ಬೇಕಾಗತ್ತೆ ಅಂತ. ಏನಕ್ಕೆ ಅಂದ್ರೆ ಅಲ್ಲಲ್ಲ, he has suppressed, my lord. He has suppressed all the material.
ಅಂತಾರೆ.
My lord, ಹಂಗಲ್ಲ. My lord, he has suppressed. I am bringing to the notice of the court, telling that
division bench.
I am not telling they are not entitled, my lord. But they have to come with the clean hands before this honorable court. ಅಷ್ಟೇ ನಂದು ಅದು ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ.
ಆಯ್ತು.
ಎಲ್ಲರೂ ಬಂದು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಂತಲ್ಲ. ಇದೊಂದು ಕೇಸಲ್ಲಿ ಆತರ ಆಗಿದೆ.
ಇವ್ರಿಗೆ ತೊಂದರೆ ಆಗಲ್ವಾ?
ತೊಂದರೆ ಅಲ್ಲ.
ನೆಕ್ಸ್ಟ್
ಪ್ಲೀಸ್.
Amended petition with annexures. It has been accepted, my lord.
Amended petition ಇದೆ ಇಲ್ಲಿ.
It is. Again,
ಏನಿದು?
office insists, my lord, to
covered by Justice Devadas for order.
ಅದಲ್ಲ. Different issues. They are supposed to file a report, my lord.
It's not report, my lord. Draft award.
Draft
We have
award,
sought
yes.
for an
draft award.
Yes,
draft award.
that is the directions.
Sometime
ನಾಳೆ
we'll file.
9th. List on 9th September in plenary hearing at the request of the council appearing for the respondent.
Please, please.
Next.
5.
Withdrawn. All withdrawn. ಉಳಿದಿರೋದು ಅಷ್ಟೇ. List the matter on 16th. Yes.
6.
Appearing for response 1 minute.
Yes, Ajay Prabhu.
My lord, the government has to give instructions, my lord, whether last occasion government has submitted that minister has hold a meeting and directed the
AGA. There are some deliberations going on ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Ministry of Surface. ಏನಾಗಿದೆ?
Survey has gone, my lord, it is pending.
Learned HCGP seeks 2 weeks' time in terms of the order, as the matter is pending before the state, which was the said submission was captured in the order dated 11/7/2025. The position today remains the same. Therefore, the interim order subsisting will continue till the next date of hearing. The learned HCGP or the petitioner are at liberty to move the matter if the decision is taken by the state. Yes. ನೀವು ಮೂವ್ ಮಾಡಿ, ಯಾರು ಮೂವ್ ಮಾಡಿ, ಸ್ಟೇಟ್ ಏನಾಗುತ್ತೆ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಅಯ್ಯೋ ಯಾಕೆ ಮೇಡಮ್ ಕೂತ್ಕೊಳ್ಳಿ. ವಾಟ್ ಹ್ಯಾಪೆಂಡ್? ಸಿಟ್ ಡೌನ್ ಮೇಡಮ್. 5 ಆಗೋಗಿದೆ. ವೇಟ್. ಎಸ್ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಮಧ್ಯಾಹ್ನ ತಗೋಣ.
ದಿಸ್ ಮ್ಯಾಟರ್ my lords.
ಕೂತ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
Serial number 7, my lords.
7, yes.
Resolution, my lords, they have decided to place it before the committee again, my lords, for the decision. Lords may kindly grant me a week's time, my lords. I shall place
Learned
that on
counsel
record.
for the respondent BDA submits that this court on 5/8/2025 had passed the following order. 4 weeks time was granted to place the resolution before, for 4 weeks time was granted. The, sorry. 2 weeks time was finally granted to comply with the order dated 13/2/2025. The learned counsel for the BDA today sings the same swan song of seeking an adjournment.
That's the resolution, my lord.
Finally, time is granted up to 9th. In the event nothing comes about, appropriate orders would be passed. Yes.
My lord, in serial 6.
Interim order, continue ಮಾಡಿ.
I request after 9th, my lord.
Huh?
After 9th, my lord, because 9th is the day on which the committee.
ಆಯ್ತು 11th.
Please.
Yes, next.
8, my lord, I appear for the petitioner. This is, my lord, an application was filed, my lord, for impleading as one of the defendants that has been rejected, my lord, by the court, my lord. Though the plaintiff
Suit for
had
partition.
suit for partition. And,
Who are you?
I am the joint family member. And
Why are you left
on
out?
the last occasion, my lord, they stated that there was already a partition. And I said, my lord, there was no partition at that, as per the Palupatti. And they have now given a list of properties wherein, my lord, they are standing in the name of my petitioner. In fact, my lord, I have given the details, my lord. Kindly see, they are all standing in the name of, even till today, they are standing in the name of the grandfather, not in the name of the petitioner, madam.
Why is it rejected?
Rejected, not, it is rejected because
Para 5 and 6 of the order.
yes, I will. Page number 45, my lord. 55, I'm sorry. Well, I'll just read it, my lord, param number 4, 53. Palupatti, to prove their contention, the defendant number 1 to 5 as counsel.
Will date in? Will date?
Page.
Will. You are claiming on the strength of the will? Yes.
Will, no, I am not claiming on the
He
strength
is
of
not
the will.
claiming on the strength of the will. My lord, his application now has been rejected on the ground that, my lord, see, he belongs to a separate branch altogether. Added to that, my lord, he himself has admitted that earlier there was partition in the family. And you last kindly see page 47. Vamsha Ruksha. Blood, you see, in Vamsha Ruksha, blood, you last may kindly see right side of the blood, the document.
Now partition ಆಗ್ತಿರೋದು ಯಾವ branch?
ಪಾರ್ಟಿಷನ್ ಈಗ ಕೇಳ್ತಾ ಇರೋದು ತೊಳಸಮ್ಮ ಅಂದ್ರೆ ಸಣ್ಣ ಚಿಕ್ಕಪ್ಪಗೆ ಇಬ್ರು ಹೆಂಡತಿಯರಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ವೈಫ್ ಏನಿದ್ದಾರೆ ತೊಳಸಮ್ಮನ ಮಕ್ಕಳಿಗೆ ಪಾರ್ಟಿಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ರೈಟ್ ಸೈಡ್ ಯುವರ್ ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ. But here the plaintiff is Ganganna, just the last line below that branch. Ganganna, blood, is the plaintiff.
Yes.
Blood, he has filed suit against Putta Bhairaya, Krishnamurthy and their children. Blood, so far as the applicant now
impleading applicant yaru?
Now sought to be impleaded is Puttalingaya. You last me kindly come to left side. Puttalingaya, he is the son of Tumbi Ramakka's grandson. That branch is nothing to do with this. And added to that, blood, this Puttalingapaya who sought to implead blood say in the suit, blood, he himself has admitted, that's what the reasoning given by the trial court, blood, saying that he has admitted the earlier partition in their favor. Despite the same, blood, now he is again filing this writ petition saying that say he is a necessary party. He is not a necessary party at all. Blood, see.
But they rely, my lord, that on the basis that, my lord, there was a Palupatti. In fact, my lord, they themselves, my lord, disputes regarding the that is Palupatti, they are not accepting. Therefore, my lord, I have filed one more suit, my lord, at 4, 3,
only on his admission.
431, my lord, has been.
Your Lordship, kindly.
What happened to that suit for what?
Still pending, my lord. They both
Suit for what?
Suit for partition.
Again.
Very same my lord, properties have been included there.
His intention is
If
to
the-
see that the
Lord-
proceedings are, say, prolonged for long time.
No,
This suit
there is
is
no
filed.
intention.
One second. This suit is filed in
He
year
comes in, what is the problem?
No, 2012, now he comes and files after the, say, lapse of so many years, an application for impleading. And he himself admitted. in the
Innೊಂದು
other
suit ಯಾವ್ದು?
My brother,
ಇನ್ನೊಂದು suit ಯಾವ್ದು?
441, I have given the documents.
431 of?
431 of 2016. 2016, my lord, if both suits are clubbed together, my lord, I have no objection at all.
No. Why? See, you have admitted there is a partition in your favor.
What
and
is-
you does
what-
not belong to this branch at
What is
all.
what is that you have challenged here in the 431?
Partition has been.
Again partition?
Yes, same.
Of what
respect to the
properties?
Same properties.
No, what is the admission that your partition ಆಗಿದೆ ಅಂತಿದ್ದು ಯಾವುದು?
ಆಗಿಲ್ಲ ಅಂತಾನೆ ಹೇಳಿದ್ದೀನಿ.
431 ಅಲ್ಲಿ.
There is no admission.
See, the court has
431, I have given the copy of the plaint, my lord, along with my additional documents.
431 ಅಲ್ಲಿ they are the
They are
defendants?
defendant number 6, Krishnamurthy is.
ಅಲ್ಲಿ you are the defendant in 431?
Yes.
No. See,
No.
ಇದಾರಲ್ಲ.
ಎಲ್ಲಿ ತೋರಿಸಿ 431 ಎಲ್ಲಿ?
431, my lord, page number 14 of my additional documents.
14 of your
And
additional
filed on
document.
13 July,
Written statement of the authority.
31 July,
Page?
page 14. Krishnamurthy is the defendant number, respond number 6 here.
YC Krishnamurthy.
And Putlingaya, my lord, the petitioner, my lord, is defendant number 4. Chikkanda, my lord.
Let
is
him
the-
be in, sir.
Yes.
Lord, here, your Lordship, kindly
Or we'll
see.
direct both the suits to be
Yes, my lord.
taken up together.
See, Lord, here,
Allah will allow this application or direct the concerned court to take both the suits together.
Lord, the impleading application can be allowed, Lord, only on the ground. Let's see the reason. Unless and until he is a party, issues involved in the case cannot be decided at all. But here is a case, your Lordship, kindly say, we have produced him, let us see objections, annexure R2, my lord, at page 13. Objections to this writ petition, your Lordship, kindly say, we have produced that also. At page 13, it is clearly admitted by him saying that there was a partition on 10/4/1998. so
Why
far
should
as-
he file another partition suit?
No, that is left to him. So far as his branch is concerned, he
He
can
says
file.
there is no partition at all.
His branch is concerned, he can file any number of suits. We are not concerned with it. But so far as see,
Let both the suits be taken up together.
The family tree shows, my lord, he does not belong to this branch at all.
I am not saying that they would be clubbed. They'll be taken up together.
Lord, see, when he has admitted that, my lord, there was a partition year 10/4/1998, is it necessary for him to come here, my lord, after the lapse of, see, 20 years comes and file an
ಆಯ್ತು
application?
ಇದು ಬೇಡ, both the suits ಒಟ್ಟಿಗೆ ಆಗ್ಲಿ.
Now, my lord, what will happen with this, my lord, if his application is now allowed, my lord, now he will take time to file written statement.
My
But
brother has
everything
been
will be
included.
similar
No,
upset.
I will direct the court to conclude the proceedings.
My brother has been included, my lord, impleaded as.
After
defendant
so
number
many years.
6.
12, my lord, 2012 suit, my
ಅಯ್ಯೋ
suit is-
ಪಾರ್ಟಿಷನ್ 20 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇದೆ sir. ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, 2012 ನಲ್ಲಿ what prevented him to file an application earlier to this if he was really interested? My lord, here what has
No,
happened?
we will not permit him to drag it.
No,
If your
no.
apprehension is that 6 months I will direct.
Kindly appreciate, my lord, unless, see, justifiable reasons to, my lord, to come on record, my lord, he is not a necessary party at all.
ಬೇರೆ ಸೂಟ್ ಆದ್ರು ಪಾರ್ಟಿಷನ್ ಸೂಟ್.
Well, a partition suit, sorry, but he has admitted the partition.
Let everything be decided. If you, why are you so apprehensive of his entry into the thing? ಬಂದ ತಕ್ಷಣ ಪಾರ್ಟಿಷನ್ ಆಗೋಗ್ಬಿಡುತ್ತಾ?
ಅಲ್ಲಲ್ಲ, ಇವ್ರ ಪಾರ್ಟಿಷನ್ ತಗೊಂಡು ಹೋದಾಗ see, ಇಲ್ಲಿ ಬಂದು ಪ್ರೊಲಾಂಗ್ ಮಾಡ್ತಕ್ಕಂತ ಉದ್ದೇಶ ಅಷ್ಟೇ.
ಪ್ರೊಲಾಂಗ್ ಅಷ್ಟೇ ಅಲ್ವಾ? ಪ್ರೊಲಾಂಗ್
No, prolong ಅಲ್ಲ,
we will plug that prolong.
See, I can understand, well, if he has not admitted, if there was no party, your last may kindly similar, page 13 may kindly be seen.
No, we'll answer, no problem. Yes.
Hello, wherein he has admitted, saying that there was a partition. at
Page 13 of the
10/4/1998.
order.
Huh?
Order da. Admission ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ಅಡ್ಮಿಷನ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೂ ಇದೆ, ಇಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದೆ. Your last may kindly see, annexure R2.
ಅದನ್ನ ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
Yes, sir.
ವೇರ್ ಸರ್
ಹೇಳಿಲ್ಲ.
ಹೌದ್ರಿ.
Where?
431 ಅಲ್ಲಿ ಆಗಿಲ್ಲ ಅಂತಾನೆ ಹೇಳಿದ.
ಎಲ್ಲಿ ಹೇಳಿದಿಲ್ಲ
ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲಿ ಇಲ್ಲಿ ಹೇಳ್ತಾ ಇದಾರ ನಿಮಿಷ ತಾಳಿ.
See here, blood joint family
Wait, sir.
properties, though the Palupatti plaintiff, say, Vibhaga Patra on 10/4/1998 dated not on 6/6/98. He admits on 10/4/98 there was a partition in their
ಆಯ್ತು
favor.
ಒಂದ್ ನಿಮಿಷ
Para 16 in my OS number 431 ಅಲ್ಲಿ.
ಅದರದೇ
Para
ಹೇಳಿ.
number 3.
Where is that?
Para number 3. ಇದು ಚಿಕ್ಕ ನೋಡಿ ಕುರಿ ಚಿಕ್ಕಣ್ಣ ಅಂತ ಫೈಲ್ ಇದರಲ್ಲಿ ನೋಡಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೃಷ್ಣಮೂರ್ತಿ ಇಸ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 3 and myself is defend number 4 in that suit.
ಅಲ್ಲ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ಹೇಳಿ ಸರ್.
It is filed by
ನಾನು ತೋರಿಸ್ಬಿಟ್ಟು
ಚಿಕ್ಕಣ್ಣ.
ಆಯ್ತು ಪ್ಯಾರಾಗ್ರಾಫ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಎಲ್ಲಿ.
ನಮ್ದಲ್ಲ ಇದು ಸೂಟ್. It is filed by it is not filed by me.
Then where have you disputed? You show me any document where you have disputed partition.
But it is
document ತೋರಿಸಿ.
not the
document ತೋರಿಸಿ. Where have you disputed partition?
My written statement
ಈ ತೋರಿಸಿದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇನ್ನು ಹಾಕಿಲ್ಲ.
ನಿಮಿಷ ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
but I am
ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದಿರಾ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್?
kindly one
431 ಅಲ್ಲಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದೀವಿ ಇದರಲ್ಲಿ. I will get I have not produced it. The suit property in
no problem. You produce one document where you have disputed the earlier partition because the senior counsel is relying on admitted statement of yours that there was a partition. Basic sir, ಅದು ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು.
I will get it. I will yes tomorrow your lordship.
ಆಯ್ತು
ಆಗ್ಬೋದು. ಅಲ್ಲ ಅಡ್ಮಿಷನ್ ನಾವು ಮಾಡೇ ಇಲ್ಲ ಇಲ್ಲಿನೂ. ಅವರು ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇ ಡಿಸ್ಪ್ಯೂಟ್ ದಿ ಅರ್ಲಿಯರ್ ಪಾರ್ಟಿಷನ್.
ಪ್ಯಾರಾ 5 and 6 ಅಲ್ಲಿ ಅದ್ರ ಮೇಲೆ ಬರ್ದಿರೋದು. ಎಸ್
ಹೇಳ್ತೀನಿ
tomorrow ಮೇಲೆ
ಪ್ಲಸ್ tomorrow. ನೆಕ್ಸ್ಟ್
Number 9.
Petitioner, Impleading Application rejected.
suit for
I am for the petitioner.
suit for
there is a counterclaim. Plaintiffs injunction ಹಾಕಿದ್ದಾರೆ. The defendant one has filed application for.
Who are you?
I am the defendant number 1.
You filed impleading application in what?
Not in the same suit, my lord.
Counter claim ಹಾಕಿದಿರಲ್ಲ
ಹೌದು,
ಮತ್ತೆ
ನಾವು
ಯಾಕೆ?
counter claim ಹಾಕಿದೀವಿ. But defendant plaintiff's mother, she executed the defendant number 2, the impleading defendant has executed a will in favor of the plaintiffs. ಆ ಎರಡನ್ನು cancellation ಕೇಳಿದ್ವಿ. Because of that, she is a necessary and proper party.
Counter claim ಅಲ್ಲ.
Counter claim.
Gift deed cancellation is it?
ಹೌದು, ಎರಡು gift deed cancellation ಕೇಳಿದ್ವಿ. She suppressed the fact that she is the daughter ಅಂತೇಳಿ ಮಾಡ್ಕೊಂಡಿದ್ರೆ. She is not at all the daughter of Vellige.
Who is the you are the plaintiff?
I am the defendant number 1.
Suit is for injunction.
Injunction, yeah.
It's not declaration.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ನಾವು ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದ್ವಿ ನಾವು.
Counter claim ಅಲ್ಲಿ declaration ಕೇಳಿದ್ವಿ. Where is your counter claim?
Counter claim, just a minute. At page 32, my lord. Page 34 and onwards. Ink page 40, my lord, to declare the gift deed dated 5/5/19 and
A petitioner shall serve on the counsel who represents the.
My lord, one submission. With regard to that, I have already served a copy. And
ಯಾರಿಗೆ?
ಅಲ್ಲ, ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಇದೆ. ಪಿಟಿಷನರ್ ಅವ್ರ
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಯಾರು?
Plaintiff counsel
ಯಾರು?
M. Madan Gopal.
Learned counsel submits that M. Madan Gopal has entered appearance for the respondent plaintiffs 1 and 2. Registry to print the name of so and so. List the matter day after tomorrow.
Much.
10.
My lords, appear for petitioner in this case. We have served a copy of the petition to the council on record before the lower court. Acknowledgement was filed today in the morning, my lords. They have not come on record. In
The learned counsel for the petitioner submits. The papers have been served upon the counsel representing the respondent in the trial proceedings. Awaiting his appearance list day after tomorrow.
Much so.
Next.
7.
Case of paper petitioner. I have served the for R3. I am taking undertaking to file wakalat, please.
Learned counsel so and so undertakes to enter appearance for the third respondent. Registry to print the name of so and so is appearing for the third respondent. List on 10th. Next. No representation. List after 2 weeks.
13.
I have filed an application to come on record as
Respondent counsel 5 and 6, Miller.
second petition.
Proposed respondent, petitioner.
Petition number 2.
How are you impleading as petitioner, sir? File a separate petition.
My lord, he was the vendor of the first
Maybe.
petition, my lord.
Yes.
I may be permitted to place the objection.
Housing board.
Yeah,
Inland
in fact,
petition,
my lord-
you can't come in as petitioner.
To indemnify the first petition, we are not claiming independent right, my lord. To indemnify the first petitioner. So we will file.
Subsequent purchaser and also inordinate.
Alla, subsequent purchase,
Also-
subsequent to
Yes.
preliminary notification.
Illa, illa.
ಮತ್ತೆ?
The applicant was the owner of the property during that time. He was not notified in the acquisition proceedings. So second, first petition is the purchaser. Lord, the landowner has.
When
not
did you
been-
purchase, sir?
Lord, in the year 2024.
Final notification?
Final notification was in the year
1993. Anything else, sir?
Landowner, my lord, landowner was not notified.
No, no.
Sir,
Anything.
landowner.
My lord,
New landowner.
I am a purchaser. Second applicant is
Anything
the
else, sir?
second applicant is the landowner at that time, my lord. My lord, I will file the petition and I will club with my lord. Second, my lord, second applicant was second. The
No,
present
sir, it's
applicant.
covered by what I have written recently. What, sir?
My lord, that's why, my
No,
lord,
sir.
to indemnify the first petitioner, second
No,
applicant has
no,
filed in the
no
application.
indemnification.
My lord, landowner.
It is
was
for the landowner to say all that. He,
That's what-
after
that's what
selling
my
the
lord-
property, nothing doing.
my lord,
You can't speak for him, sir.
Short accommodation, my lord, I will
No,
file and I
sir.
will club it,
Hey,
my
make
lord,
a submission.
along with the first petitioner. My lord, the second
ನನ್ ಜಡ್ಮೆಂಟ್ ಅವ್ರು ಫಾಲೋ ಮಾಡ್ಬೇಕು ಬೇಡ
ಮಾಡಬೇಕು ಅದಕ್ಕೇನೆ
Exactly.
ಅದಕ್ಕೇನೆ to come out of the technicality, my lord,
ನೋ 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 ಸರ್
landowner will also. So I will file-
ಇಂಡೆಮ್ನಿಫಿಕೇಶನ್ ಎಲ್ಲ ಆಗಲ್ಲ ಸರ್
So we will club with the both the cases, my lord. So that otherwise,
ಅದರ್ವೈಸ್ ಇಲ್ಲ ಏನು
so 2 weeks, my lord, I will file the joint petitions.
ಏನ್ ಸ್ಟೇ ಇದೆಯಾ ಅಲ್ಲಿ
Stay.
ವಿಲ್ ವಿಕೆಟ್
ಅಲ್ಲ,
ನೋ ಸರ್
status quo ಇದೆ.
No,
stay ಇಲ್ಲ.
nothing doing.
ಇಲ್ಲ, ತಾವೇ modify ಮಾಡೋದು status quo ಮಾಡಿದಿರಿ.
No, no, your
So,
lordship kindly
my lord,
vacate
I
the-
will
you have no Siddaramaiah,
It is a
you
clear
have no
abuse
right.
process
What is
of the
this?
court.
My lord, as far as the landowner is concerned, my lord, he was not notified during the acquisition.
That is
proceedings.
for the landowner to say,
So that's why, my
not
lord,
today.
Yes, sir.
ಅವಾಗ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. Purchaser, subsequent purchaser will not come and say all that.
My lord, land was converted, residential layout was formed, that was not considered. And even, my lord, the respondent 4 and 5 claiming as allotted, they have not constructed the building, even after several years of
Oh,
allotment
no,
by the
sir.
KHP.
Judgment ಕೊಡಿ ನಾನು.
So,
May I request,
No,
my lord,
no,
my
not it is-
objection may be kindly be seen. Now, in fact, your lordship kindly appreciate the point see,
my lord, I am a
page
bona
10,
fide- I am a
the
bona
first
fide
document, your lordship.
I am a bona fide purchaser, my lord, conversion
The
has been entered.
the same part.
My lord, otherwise my
ಏನ್
right,
ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ, my right also needs.
Can't
to-
help, sir.
ಅಲ್ಲ, it is for the authority, my lord.
No, no, sir.
The well-developed layout property has been acquired. My lord, I am a bona fide purchaser.
What's your name? Manjunath K.
Manjunath K.
If your lordship
Second
kindly see,
petitioner is Manohar. My lord, in the notification, Manohar was
writ
not
petition
notified.
copy is produced before your, my lord. Page 10 may be kindly be seen. Page 10, serial number 6. KR Manohar is according to me is the vendor.
Oh, you had already challenged it.
Yes, yes, that is already challenged.
That was dismissed for non-prosecution.
One ನಿಮಿಷ sir.
The detailed reasoned order passed by dishonorable court may request my lord page 23 may be kindly.
ಅದಕ್ಕೆ ನನ್ನ my lord, my
ಅಲ್ಲ ಎಲ್ಲ ನಿಮ್ಗೆ ಗೊತ್ತು ಅದು.
ಹೇಳ್ತೀನಿ. My responsive submission is, let the IA be allowed, my lord.
Oh, no, sir. Nothing.
Page 28,
I got a point, my lord.
page 28 may be kindly be seen. All this issue has been considered
Then
by the.
I will allow the IA.
Yes.
Dismiss the petition with exemplary costs.
ಅದು
ಅಲ್ಲ exemplary costs.
ಹಂಗಾಗ
5 ಲಕ್ಷ 10 ಲಕ್ಷ.
ಹಂಗಾಗಲ್ಲ.
ಮತ್ ಇವೆಲ್ಲ ಆತರ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೀವು ಓನರ್ನ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು ಈಗ ಹೇಳ್ಕೊಂಡು ಎಲ್ಲ ಸೇಲ್ ಆದ್ಮೇಲೆ nothing. One who was already before this court suffered an order, you want to bring him again? No.
May I request my lord page 28 may be.
All these years, I was
course.
bedridden, I was producing medical records. Say, he paralyzed you.
Para
ತುಂಬಾ ಕಷ್ಟಪಟ್ಟು
para 14 may be kindly be seen, my lord. Order of dishonorable court.
ಅದಕ್ಕೆ
ನೋಡ್ಬಿಡ್ಲಾ ಇದು?
All this issue has been considered. by the-
ಒಂದೇ ಒಂದು ವಿಚಾರ.
One ನಿಮಿಷ. I am not permitting that IA at all. I am dismissing it. Now I am, wait, let me see.
ಅದಕ್ಕೆ ನಂದು ಒಂದೇ ಒಂದು
I will vacate the interim order, we'll take it next year, no problem.
ಅದಕ್ಕೆ ಒಂದೇ ಒಂದು submission.
Nothing, yes.
Let the authority accommodate the petitioner also alternative sites, because
Let him educate in all this issue.
so well developed layout plan has been acquired. And I am a bona fide purchaser, my lord. Kata was also stands in the name of Manohar.
May
The authority has not constructed
One
the building.
ನಿಮಿಷ sir, one ನಿಮಿಷ.
The
ಅಲ್ಲ authorities
ಈಗ
initiate.
ಓದಕ್ ಬಿಡ್ತೀರಾ ಇಲ್ವಾ?
ಅಲ್ಲ
ಸೀರಿಯಸ್ ಸ್ವಲ್ಪ.
may I request my lord to kindly for a minute, document number 2, page 13. That is the order of dishonorable court on 27th May 2003. Paragraph 14 may be kindly be seen. All this issue has been considered. Internal page 28 may be kindly be seen. Paragraph 14, my lord. What's up? Paragraph 14. The aforesaid facts make it clear that the petitioner challenged the very same notification earlier by preferring a writ petition. That is 19697 of 710 of 89. The said writ petition came to be dismissed for non-prosecution. For the non-production of the original 41 and 61 notification, instead of seeking setting aside the order and prosecuting the aforesaid writ petition by producing the document which was ordered to be produced, the petitioner have chosen to file the present writ petition. Though this is a proceeding under the 220, the Constitution of India, and also the para 15 is relevant. Order 9 rule 9 categorically provision that when a suit is dismissed with a order.
Who was the petitioner there?
ಅದ್ರಲ್ಲಿ ನಾವಿಲ್ಲ party.
In fact, same issue.
Manohar is not a party.
Same, Lakshmi kindly.
ಅದ್ರಲ್ಲಿ
All the petitioner earlier.
ಬೇರೆ ಎಲ್ಲ petitioner
ಆಯ್ತು, ಆಯ್ತು.
Petition is produced.
All right, wait. ಆಮೇಲೆ.
Document number 1 ನಲ್ಲಿ ಇರೋರೇ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು.
Vendors.
ಎಲ್ಲರೂ ಇದ್ದಾರೆ.
Sir, wait sir.
Clarify ಮಾಡಿ.
ಈ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಷ್ಟೊಂದೆಲ್ಲ ಮಾಡ ಬರ್ಬೇಕಾ? Wait sir. Yes.
Document number 1 ನೋಡ್ಬೋದು ಸ್ವಾಮಿ. Lakshmi kindly.
ನೀವು ಓದ್ತಾ ಇದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಸರ್. ಆಮೇಲೆ ಹೋಗೋಣ.
Yes, your Lakshmi kindly. Paragraph 15. The order 9 rule 9 categorically provide that when a suit is dismissed under rule 8, the plaintiff shall.
ಆಯ್ತು, ಇದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ?
ಹೌದು.
Accordingly petitions are dismissed.
ಹೌದು.
ಆಮೇಲೆ what is this third, the page 33?
Thereafter, writ appeal is filed.
Writ appeal is filed and finality is reached.
Where is the writ appeal order?
Writ appeal order is at your lordship may request my lord to.
That is page 40?
At page 40, my lord. That is document number 4. It attains finality.
ಆಯ್ತು, ಇವರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು ಯಾವಾಗ ಆಯ್ತು?
That is in the
2024.
On
24 ಅಲ್ಲ?
2/8/2024, my lord.
ಅಲ್ಲ
2/8/2024.
ಎರಡು ಆರ್ಡರ್ ಅಲ್ಲಿ ಮನೋಹರ್ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ. My vendor was not a party.
Anything else?
My vendor was not a party.
Petition ಕೊಡಿ ಮೇಡಮ್.
Party to my lord, the proceedings, my lord.
The petitioner.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಂದು ಒಂದು submission.
Not a minute, I will adjourn the matters.
Clear abuse process.
ಇಲ್ಲ site
Not a minute, sir.
ಅಲ್ಲ ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿದ ಮೇಲೆ authorities has looked that the building should be constructed.
Yes,
within 5 years construction ಮಾಡಿದ ನಾವು ತಾಳ್ತಾನೆ ಇರಲಿಲ್ಲ.
The
So authorities have neglected.
petitioner, anyway, don't worry about it. The petitioner.
ನಮಗೊಂದು ಕೂಡ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಕೊಡ್ಲಿ ಅಂತ.
ಅದೇ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಕೊಳ್ಳಿ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಒಂದು accommodations
ಅಕಾಮಿಡೇಷನ್ ವಿಡ್ರಾ ಮಾಡಿ ಈಗ.
ಅಲ್ಲ
The petitioner, no sir, I will vacate the interim order and give you accommodation. Nothing doing. This is not correct. The petitioner is before this court calling in question, seeking the following prayer.
ಅದನ್ನ ಬೇಕಾದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು. Let they give an alternative site ಮೇಲೆ that cake.
No sir, let give ಅವೆಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ.
ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ರೆ ನಮಗೆ ಸಮಸ್ಯೆನೇ ಬರ್ತಿರ್ಲಿಲ್ಲ. ಸರ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟದೇ ಇದ್ದಿದ್ದು.
ನೀವು ಯಾರು claim damages with your vendor?
ನಮ್ಮ ವೆಂಡರ್ ಅಲ್ಲ, ನಮ್ಮ ವೆಂಡರ್ ಹೆಸರನ್ನು ತೋರಿಸಿಲ್ಲ ಅಲ್ಲಿ.
ಅದು ಏನಾರ ಅವ್ರು ಕೇಳ್ಕೊಳ್ಳಿ, ಯಾಕೆ ಸೇಲ್ ಮಾಡಿದ್ರು ಈಗ?
Self is a party.
ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಮಾಡದೆ ತಗೊಂಡ್ರೆ ಏನಾಗುತ್ತೆ? ಎಸ್, The petitioner is before this court seeking the following prayer. The petitioner is said to be the purchaser of the property which is the subject matter of acquisition by the Karnataka Housing Board. The Karnataka Housing Board issues a notification first dates ಹೇಳಿ Pradeep Kumar.
Preliminary on 30/12/1991,
30/12/1991, my lord, document number 1.
The Karnataka Housing Board issues a preliminary notification on 30th
December 1991.
30th December 1991 and a final notification thereon
14th October 1993.
14th October
1993.
1993. The acquisition proceedings is said to have become final in accordance with law. The petitioner, the vendor of the petitioner, initially calls the acquisition process in question being petitioner number 6 in writ petition 19697-710 of 1999. 1999, correct. 1999. The said writ petition comes to be dismissed for its non-prosecution on 16th June 2000. The petitioner does not seek recall of the said order. Others, along with the other petitioners, file another writ petition before this court in writ petition 3434-42 of 2002. The said writ petition comes to be dismissed on 27th May 2003. The petitioners in writ petition 3434 and 42 of 2002 challenge the order passed by the learned single judge in the said writ petition before the division bench in writ appeal 1571 of 2007. The writ appeal comes to be dismissed. The dismissal of the writ appeal is said to have become final. Thus ended the challenge of the parties to the landowners against the acquisition in the aforesaid dates. The petitioner was nowhere in the picture. The petitioner comes into the picture when his vendor sells the property to the petitioner in the year 2024,
2/8/2024.
i.e. on 2/8/2024, which is 24, which is 31 years after the acquisition, on the score that the petitioner is still in possession of the property. The learned counsel for the petitioner submits that the respondent housing board, after having acquired the property, had not developed the property. Therefore, the submission developed the property, and therefore the petitioner had reason to believe that the vendor was in possession of the property and had to purchase the property. The learned
Kata stands in the name
I
of
no
the
problem, sir.
vendor.
And would further submit that Kata still stands in the name of the vendor of the petitioner,
Then it
all
was
of which are disputed by the counsel KL Pradeep Kumar appearing for HL Pradeep Kumar appearing for the Karnataka Housing Board. He would contend that possession
16/2 notification was issued, my lord, in the year 1996, 23/9/1996.
A notification under section 16(2) was issued on
23/9/1996.
23/9/1996 and possession thereon has been taken by the housing board. Therefore, land did not vest with the landowner. The landowner was very well aware that the land did not vest with him, as he had raised a challenge to the acquisition in the year 1999, and the challenge is tacitly given up by not seeking recalling of an order. Others who had sought recalling of the order have suffered orders, and the order is confirmed by the division bench. The petitioner springs into action as observed herein above 31 years after the notification and 25 years after the 24 years after the rights of his vendor stood frozen in the light of the dismissal of the petition for its non-prosecution. It is settled law that a subsequent purchaser of the property subsequent to preliminary notification or even the final notification would have no right to call in question the acquisition proceedings which are now sought to be called in question by the petitioner. The law, so and so. This court Judgment ಕೊಡಿ.
2019 10 AC.
ಅದಲ್ಲಪ್ಪ, ನಾನೇ ಬರ್ದೇನೆ.
ಇವ್ರದ್ದಿದೆ ಕೊಡಿ.
Sorry.
This court in so and so, while considering the judgment of the apex court, has held as follows. Para 9 in the end. The learned counsel for the petitioner now seeks to contend that he has filed an application seeking impleadment of the owner into these proceedings, not for anything but to indemnify that the owner had bona fidely sold the property to the petitioner. The application bringing in the petitioner as petitioner number 2 is of no avail, as the law in this regard is clear, and the vendor himself was before this court long ago and suffered orders. Therefore, finding no merit in this petition, the petition stands rejected.
Opportunity to approach the cage.
The learned counsel for the petitioner, learned counsel for the petitioner at this juncture submits that that he be permitted to submit a representation venting out his grievance to the respondent. The petitioner is at liberty to do so in accordance with.
Allotment of order.
No.
ಅದಕ್ಕೇನೆ ಬೇಕು.
ಏನಕ್ಕಾರು ಕೊಡಿ ನೀವು.
ಅಲ್ಲಿ ಸೈಟ್ ಬಿಡದೆ ಮನೆ ಕಟ್ಸಿದ್ರೆ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡ್ತೀವಿ.
ನೀವು ಅಲ್ಲಿ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ವೆಂಡರ್ ಮೇಲೆ ಹೋಗಿ ಸರ್.
5 ವರ್ಷದೊಳಗಡೆ
ಫೈಲ್ seek damages from the vendor sir.
5 ವರ್ಷದೊಳಗೆ ಮನೆ ಕಟ್ಟಬೇಕು ಅಂತ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್
ಅದು ವೆಂಡರ್ ಅದು ಬಂದು ಹೇಳಿ ಅವರು.
ಅಲ್ಲಲ್ಲ ಅಥಾರಿಟಿನವರು
ಅವ್ರು ಬಂದು ಹೇಳಿ
ಮಾಡಿಸ್ಬೇಕಾಯ್ತು. ಹಂಗಾಗಿ ನಮ್ಗೆ they have made me to suffer a lot.
Your vendor is hoodwinked you sir, straight away.
ಅದೊಂದು
ಖಾತಾ ತೋರಿಸ್ಬಿಟ್ಟು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ.
ಇಲ್ಲ, ಅದು ವೆಲ್ ಡೆವಲಪ್ಡ್ ಲೇಔಟ್, ಕನ್ವರ್ಷನ್ ಆಗಿತ್ತು, ಲೇಔಟ್ ಡೆವಲಪ್ ಆಗಿತ್ತು, ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿರೋದೇ ತಪ್ಪು. ಅರ್ಲಿಯರ್ ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಅಂದ್ರೆ ಅನಾಥರೈಸ್ ಲೇಔಟ್ ಅಂತ ರಾಂಗ್
ಏನ್ ಮಾಡಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ರೀಕಾಲ್ ಆಗಿಲ್ಲ.
ಅವಾಗ್ಲೇನೆ ಆಥರೈಸ್ ಲೇಔಟ್ ಅಂತ
ಈ ತರ ರಿಸರೆಕ್ಟ್ ಮಾಡ್ತಾ ಹೋದ್ರೆ there will be no finality to proceedings. Yes,
ಇದೊಂದು ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಗೆ ಅಲಾಟ್ಮೆಂಟ್.
ಅದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಿ ಅವರು.
ಅದಕ್ಕೆ ಆಲ್ಟರ್ನೇಟಿವ್
ಏನಕ್ಕೆ ಅಂತ ನಾನು ಹೇಳಲ್ಲ. ಎಸ್, ಆಮೇಲೆ ಅದನ್ನ ತೋರಿಸಿ ಹೇಳಿದ್ದಾರೆ ಕೋರ್ಟ್ ಅಂತ. ಎಸ್ ಸರ್,
ಪ್ಲೇಸ್ಮೆಂಟ್.
Sorry, my lord, serial number 12.
12 is over, wait. How can you barge in?
Sorry.
Yes.
Suit for specific performance. At the time of marking the document, the agreement of sale was objected on the ground that it is insufficient stamp. An argument was addressed. Trial courts giving a ruling that it is sufficiently stamped, it is admissible in evidence. That was challenged in a review petition filed by the respondent. In review petition 31 of 23, that was reviewed. But while reviewing the order, there is an observation made that will hamper my content. I cannot argue before the trial court to say that.
No problem. That is that application. We will say the observations made therein will not come in the way. Ashte.
My
merits ಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡಕ ಅದಕ್ಕೆ application.
Merits ಮೇಲೆ ಅಲ್ಲ. Objection ಏನು ನೋಡಿ. It has to go before subsequent prior to the stage of annexure E. Annexure E is that.
That I will not say, sir. You are aggrieved by certain observations.
ಇದೇನ ಸಫಿಶಿಯಂಟ್ ಸ್ಟಾಂಪ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಐ ಹ್ಯಾವ್ ನೋ ಆಪರ್ಚುನಿಟಿ ಟು ಅಡ್ರೆಸ್ ದಟ್ ಇಟ್ ಇಸ್ ಸಫಿಶಿಯಂಟ್ಲಿ ಸ್ಟಾಂಪ್ ಇವಾಗ.
Yes sir.
77 page number
68, my lord, the reasons given by the learned judge. He says, my lord, in view of the amendment that is admitted fact, Karnataka Stamp Act was amended in 2011 itself. As per the provisions report, Amendment Act, it is also
deficit stamp duty penalty
paid. Now he has got to have paid that amount before admitting the document in evidence. But the learned judge, considering that aspect and following the judgment of the apex court also in Bashir Ahmed case, then held that this is the earlier order passed, holding that it is sufficiently stamped is incorrect. Hence, if he pays, kindly see the operative portion of the order.
So you are not heard while reviewing the order?
Yes, sir. He was heard.
Our review petition argument, it is independent proceedings.
He was heard.
It is not filing on the same source. It is independent proceeding. Separate order sheet was filed. Separate notice was issued.
So petition was
in that petition, it was.
Wait, ibru heladre henge.
Sir.
Only the you last make page number 77. The order is reviewed. To that extent, I have no grievance. Now I cannot go before the trial court say that it is sufficiently stamped. I have not been. The sale agreement dated so will be admitted in evidence only if the duty is so and so paid.
Agreement definitely it had to be stamped, adequately stamped.
I have not addressed my argument. It is sufficiently. I can earlier page number 56 you last make it earlier.
That's why I asked. The order is reviewed without hearing you.
proceed.
Review petition not maintainable ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಮಾತ್ರ ಹೇಳಿದ್ರೆ
ಅದ್ರ ಮೇಲೆ ಈ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. Yes, let it be heard.
He was heard, my lord. It's
ಅಲ್ಲ,
not that he was not.
he was heard on on maintainability here ಮಾಡ್ಬಿಟ್ಟು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರ್ತಾರೆ.
Hearing ಆಗಿಲ್ಲ. ಮೇನ್ ಮೇಲೆ hearing ಆಗಿರೋದು. ಮೇನ್ ಮೇಲೆ hearing ಇದೆ. You last kindly call for the records also, it can be seen, my lord. He was heard in the one main. Entire petition was heard.
Where is order sheet ಅಲ್ಲಿ?
Your lordship, page number 77 is the.
Where is the order sheets?
Order sheet I have not.
Registry is directed to secure the trial court records in OS in review petition 31 of 2023 by telephonic instruction, list on 8th.
Third ಗೆ dismiss
Parallel 8th, yes.
ಅಲ್ಲ third ಗೆ dismiss ಮಾಡ್ತೀನಿ ಅಂತ ಕೂತು. Your lordship.
ಏನು dismiss ಮಾಡಿದ್ರು?
Suit and dismiss ಮಾಡ್ತೀನಿ ಅಂತ.
Evidence taken. It is not.
Order sheet ಅಲ್ಲಿ it has been mentioned that it will.
List on 8th. The concerned court shall defer its proceedings till the next date. Yes.
My lord, appear for respondent number 1 and 2, my lord. Kindly pardon, my lord.
Petitioners, your lordship.
Yes, sir.
My lord, we have complied with the orders of the court of last hearing, my lord, wherein we have taken
Sir,
down
one request to all councils. All of you say I don't permit appearance on VC. No problem. Appear from the office, car, park. Illindella appear I will not permit.
My apology, my lord. My colleague is
I'll tell you one thing, sir.
I was in to take
I'll tell you one thing. Majesty of the court cannot be taken for a ride by appearing from the car, in the park, in some movie hall, and proxy councils. I'm a proxy council appearing on VC. ಇದೆಲ್ಲ permit ಮಾಡ್ಬೇಕಾ ಹೇಳಿ?
I beg your pardon.
I don't permit VC.
I beg your pardon, my lord.
Exactly what official appear agi, there is no problem at all. And if you are old enough, you can't come to the court, no problem. But if you appear from the car, ಕೂತ್ appear ಆಗ್ತಾ ಇದೀರಾ.
Sorry, I was on.
Should this be permitted? Tell me, sir.
I beg your pardon, my lord. I beg your pardon.
Precisely why I say appear before the court. If you are appearing from the car, it's not correct.
Sorry, I beg your pardon, my lord. Apologies, my lord. This wouldn't be repeated.
Get down from your car and come.
Please.
Yes.
I'm appearing for the petitioner, my lord. Yes, today I am filing a rejoinder to the statement of objection, my lord.
ಯಾವ್ದಕ್ಕೆ sir?
Statement of objection filed by the NHAI, my lord.
Serial number?
16, my lord.
Yes. Yes, madam.
I'm filing the rejoinder, my lords, today. It will be taken.
Rejoinder ಇವತ್ತು ಕೊಟ್ರ ಅವರಿಗೆ?
Just now I have submitted.
Learned counsel for the petitioner submits rejoinder to the statement of objection so filed is served upon the respondent just now. The respondent seeks time to go through the same and make her submissions.
But even they have not filed yet.
I have to file today. Ninth.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಏನು?
Gauri copies are made. Ninth, my lords, I'll.
List on 9th, yes.
Much.
17.
70, your lordships, I appear for the petitioner.
Yes, sir.
I appear for the petitioner. It is to be heard by both the sides. Other side, ಇಲ್ಲ ಅಂತ ಹೇಳಿ, other side ಇದ್ ಮಾಡಿದ್ರು ಅಂತ. So it will be short date may be fixed.
You are for the petitioner. Who is he?
I am for the petitioner, yes.
There is no representation on behalf of the respondent. Place the matter after 2 weeks.
Interim order.
Interim order subsisting will continue to the next date of hearing.
Appear for the petitioner. My lord, the suit for partition. In the suit for partition, an application was filed against the respondent hearing not to put up construction. My lord, that application came to be rejected and a miscellaneous appeal is filed. My lord, in the miscellaneous appeal, the respondent files a memo that appeal may be dismissed.
It is dismissed.
It is dismissed.
The petitioner is the defendant, huh? The petitioner is the plaintiff.
Plaintiff.
institutes a suit in OS 85 of 2024 for partition.
For partition.
For partition, in which seeks an injunction by filing through an application or order 39 rule 1 and 2. The said application is answered against the petitioner. The petitioner prefers an appeal before the first appellate court. In the first appellate court, it transpires that the defendant comes and files a memo that the suit be dismissed. Where is the order?
My lord, page, ink page 58. In the meanwhile, page 58.
The first appellate court
Takes
passes the
memo on record.
following order, dismissing the appeal, all on the memo filed by the respondent defendant, without getting into the veracity of the appeal so filed by the plaintiff. Therefore, there shall be an injunction in favor of the present petitioner as was sought for before the trial court till the next date of hearing. List the matter on 24th. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Next.
19.
Petitioner in this case. Petitioner is the defendant number 3, my lord. My application for amendment of written statement has been dismissed.
Suit for
partition.
Suit of
Partition by the
of the year
2011.
application filed.
Written statement filed in the 2011 and amendment of application filed in the 2022.
Amendment of written statement.
It's only elaboration of the written statement earlier filed.
Why do you want to elaborate? Don't elaborate. Sir.
So it's already there in the.
Don't idre yak matte.
Evidence has been recorded.
Alla elaboration yak bekage.
So facts is
No.
Stated in my original written statement.
Don't elaborate, sir. Elaborate in an argument.
It is admitted by the defendant. The plaintiff has not filed any objection to my amendment application. So only one.
But court has a duty, sir.
Only one of the defendant has filed the objection. So
Partition suit ella one plaintiff for defendant.
I have already stated the facts in my original written statement, and it's only an elaboration.
ಅದಕ್ಕೆ ಅದೇ elaborate ಆಗಿ argue ಮಾಡಿ. Application ಬೇಡ. Anything else, sir?
Original written statement, madam.
No.
So there is
2011 suit will not.
2017 is my return statement, madam. So after that, COVID is there. 2022 only I filed in my amendment application, madam. There is no.
ಎಲ್ಲ ಹೇಳಿದಿರಲ್ಲ elaboration ಯಾಕೆ?
No delay.
I will. The 5 years delay ಇದೆ ಪರವಾಗಿಲ್ಲ. At stage of evidence, no.
No, evidence only the plaintiff evidence has been completed and plaintiff has not filed any objection to my amendment application. It's admitted by the defendant. It's an.
You've already placed all those facts. I will permit you to elaborate in the argument.
No, madam. Can you see my original written statement, madam? Only 3 paras has been included by way of amendment, madam. This is the para page number 32 of my written statement.
An inclusions ಏನು ಹೇಳಿದಾರೆ sir?
Includes several items of the property.
Several?
Also sought for declaration to declare now partition in 1956 null and void not binding on him.
ಅದು ಗೊತ್ತಿರಲಿಲ್ವಾ ನಿಮ್ಗೆ ಮುಂಚೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ?
He himself admitted that there was severe partition, there is no joint family at all. Now he wanted to claim those properties that on
Yes,
the basis
sir.
of the case.
Anything else, sir?
Can you see the my original written statement?
Nothing. Yes.
Para number, page number 32, madam.
We'll continue to that.
Much.
My lord, today morning, I have moved one end of the list matter, my lord, and also my lord directed to give any vacating stay application memos. I have given, my lord, but end of the list memo, my lord, my court officer shows, I think that is vacating stay application. My lord, end of the list matter, my lord, because.
My lord, second.
Second list? All right. ಆಯ್ತು. ಅದು ಬರ್ಕೊಂಬಿಡಿ.
Serial number 74 and 77, my lords. I mean, permitted withdraw, my lords. Certified copies may be, my lord, directed to refund.
74 and 77.
74 and 77.
Learned counsel for the petitioner files a memo seeking to withdraw the petition. The originals appended to the petition may be registered, so be returned to the petitioner forthwith by the registry.
74 and 77.
ಎರಡಕ್ಕೂ ಅದೇ ಆರ್ಡರ್.
74 and 77.
Yes.
Make a mention, Lord, if you
Yes, sir.
Serial number 23 of list 2 as well as 116. Learned friend appears. The dispute is
23
between of list 2 and also 116. The dispute is between, my lord, neighboring owners of property over maintenance. I suggested to my learned friend, my lord, that we will refer to mediation, and he's immediately agreed.
Your lordship, I refer it earlier, Sri Raghavan senior advocate settled the matter. There were some differences. Again, I think it is back to.
I thought it is best to resolve it instead of, my lord,
23 and
116.
Of the same list?
Yes, both, they arise out of two separate suits, both between the parties.
23 and 116 tag ಮಾಡಿ. The learned counsel appearing for the petitioner, the learned senior counsel for the respondent would in unison submit that if the parties are referred to mediation, chances of settlement would loom large. In that light, I deem it appropriate to direct the parties to appear before the
It be before
mediator.
a private mediator, my lord, if your lordship's permit us will. Probably Mr. Prashant Chandra, we will, because it involves some aspects of
Alright, so-
construction.
Both the learned counsel for the parties would again submit that if counsel Shri S.N. Prasad Chandra,
Please.
S.N. Prashant Chandra is directed to mediate between the parties, it would be directed to mediate between the parties. In that light, the parties shall appear before. Where do you mediate?
Request, because it's a private mediation. I don't want to say that.
Mediation center, he's also.
Mediation
there.
central, he's also a mediator.
Hourly, he's
So-
there as mediator also.
But it not be correct for me to direct a particular
No,
mediator
direct,
to it.
we'll request, both of us
So-
would
We'll request the center.
The request be placed before, request for seeking mediation through S.N. Prashant Chandra be placed before the mediation center, who will take a decision in the matter and place the file for mediation on 9th September. 9th, ಬೇಡವಾ?
He has to
12th.
come from Nasik.
12th September.
12th or 13th.
30th September.
I won't be there. 13th September.
13th, all right, 13th September. 13th is Saturday,
No,
second
yeah,
Saturday, sir. 12th September, yes.
12th September.
Great.
Post the matter on 22nd, 19th September.
Like in second, there is interim order.
Interim
to be
order, if
extended.
any subsisting in any of these cases, shall continue till the next date of hearing.
Great.
Referent should seek adjournment tomorrow in the
We
case.
will, your lordship.
In the light of,
Joint submission would be made.
in the light of the matter being referred to mediation, both the parties would submit that they would not precipitate the matter before the concerned court.
Please.
Yes.
So grateful.
List 2, serial number 22, my lord, seeking for short accommodation.
List 222. All right. ಆಗೋ ಕರೆದು ಆಗಿದೆಯಾ ಅದು ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ 18 ವರ್ಷ.
ಇಂಟರ್ ಮಾಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ.
Yes.
List 2, serial number 20, my lord. Press time.
Press time.
Adjournment.
Petitioner.
Petitioner.
Inter ಮಾಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ.
2 weeks, yes. Placed after 2 weeks at the request of the counsel for the petitioner. Pronouncement.
Number 4, pronouncement.
Why is the learned ASG waiting? ಅಲ್ಲ ಬೇರೆ ಯಾವ್ದಾರು ಮ್ಯಾಟ್ರ್ ಕಾಯ್ತಾ ಇದೆ.
Number 1.
For the respondent, my lord.
The petition is allowed in part, the order dated so and so stands quashed. The matter is remitted back to the concerned court to answer the application afresh within an outer limit of 3 months from the date of receipt of the copy of the order, bearing in mind the observations made in the course of the order. All contentions of both the parties except the one considered in the case at hand shall remain open to be urged before the concerned court.
Number 2.
Dismissed.
Number 3.
Object appear for the petitioners, my lord. Respond number 4.
Rejected with some observations. Copy will release it tomorrow.
Please.
Number 4.
ಅದು ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಇತ್ತಲ್ಲ ನಿಮ್ದು, ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಲ್ಲ, ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು 482.
Both have been tagged, my lord, in your lordship. 482 it is not, it is separate.
ಅದು
Your
ಸಪರೇಟ್
lordship
ಅಲ್ಲ,
already-
ಅದನ್ನ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ದೆ. I'll post it this week. Writ petition 6227 of 2024 is disposed as withdrawn in view of the memo filed by the petitioner. Writ petition 5800 of 2024 stands disposed. The learned magistrate before whom the crime is pending in crime number 227 of 2023 or any other court, in cases if a lookout circular is subsisting, such court shall not consider or entertain any application challenging the lookout circular. Entertainment of the application seeking setting aside, removal or otherwise of the lookout circular will be without jurisdiction. The registry is directed to circulate this order to all the concerned courts to bear in mind the observations made in the course of the order if and when the litigants would question the lookout circular before those courts.
The claim, your lordship said it is already charged.
ಯಾವುದು ಅದು ಇನ್ನೊಂದ್ರಲ್ಲ, ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ. This is because the age is intervention, we had to pass this out.
Sister is also been
That
known
lookout
as-
circular administrative order.
True. Your lordship is.
Trial courts were quashing lookout circulars.
Oh, yes. Right.
That's what we said, yes.
No, true, Lord. But that is what, my lord, even that Supreme Court judgment as well as your lordship judgment of that.
ಅದು ಬೇಕಂತ ಮಿಸ್ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಲುಕ್ಔಟ್ ಸರ್ಕ್ಯುಲರ್ ಕ್ವಾಶ್ ಮಾಡ್ಕೊಂಡು
Sorry.
ಅವತ್ತು ರಾತ್ರಿನೇ ಹೊರಟ್ಬಿಟ್ಟಿದ್ದೀರಾ.
Sorry.
Yes, that's all right.
The petitioner, my lords.
I have drawn up 3 issues. One, whether the mandate of the act should follow or the plea of the commercial enterprise should follow. We have held the mandate of the act should follow. And the second one is with regard to carcinoma, they have projected some. I have directed those reports to be placed before the committee under section 4 for the ensuing policy.
Very well.
So let them look into it. If it is really carcinogenic or they have only projected it, let it pass an order. And with regard to another, that there is shortage of jute, that was only for a particular year. So not tenable. Yes. Policy will not be interfered with. Statutory policy.
Highly opposed.
Rejected. Yes.
6.
For the respondents in this case.
Petitioner is the state medical supplies corporation. The writ petition fails and is dismissed with costs of rupees 1 lakh. The petitioner shall deposit the said cost within 4 weeks from the date of receipt of the copy of this order with the advocates, the clerk's welfare fund. The executing court shall conclude the pending execution within 6 months. All deposit already made till date by the petitioner corporation shall be duly taken into account in the course of the execution and released in favor of the respondent.
Seven for petitioner, madam.
I am for the respondents 2 to 4, madam.
I have held it to be maintainable. The writ petition is entertainable if not maintainable. List this matters for further hearing on 3/9/2025 at 4 p.m.
Madam.
8.
From the above discussion, the following inexorable conclusions emerge. The second petition under section 482 or 528 of the BNSS is neither maintainable nor entertainable unless founded upon demonstrable change in circumstance. Grounds that were manifestly available at the time of the first petition cannot be exhumed later to prop up a second petition. In the light of the grave allegations, voluminous material, and triable questions of fact, this court cannot wield its extraordinary jurisdiction to stifle proceedings at their threshold. In the result, and for the reasons elaborated herein above, this court finds no scintilla of merit in the present petition. Law cannot bend to repeated challenges devoid of new substance, nor it can ignore the gravity of the allegations that undoubtedly wants an adjudication in a full-blown trial. Writ petition is allowed. The order dated 5/4/2025 passed by so-and-so stands quashed. All consequential proceedings, including the purported DNA examination and any report prepared thereto, are all declared null and void in the eyes of law. Registry is directed to circulate this order to the concerned courts to bear in mind the observations made in the course of the order while answering an application filed seeking DNA test.
Serial number 114.
Yeah.
That the cyber command.
New space.
Yes, ma'am.
One niche. I'll
Prepare the report, my lord, and we'll paste that.
What report is that?
Amicus report saying that how command should be functioning.
What do you place it? I'll see.
Yes.
Learned amicus, serial number 114 Barkoli. We'll go through it and post it again. The learned amicus has placed on record the report of what has transpired till date and as to how the cyber command center should function. List this matter on Thursday at 4:30 p.m. That's further hearing will bandila, madam. So in further hearing. Yes. Continue.
Number 2, till number 90.
Petitioner.
Yes, sir. Alle elaborate ಮಾಡ್ಬಿಡಿ.
Page number.
Pre-lunch, post-lunch ಏನು change ಇಲ್ಲ.
Page number 32 of my return statement. Original return statement. And what is the amendment sought, my lord?
Already ಹೇಳಿದಿರಲ್ಲ ಸಾಕು.
Very adderly. Only the documentation has been explained in the amendment.
No, sir.
So kindly see, my lord. Page number 32 of my return statement. Para 3, my lord. Item number 3 to 6 of the plain scheduled property are not joint family property of the or co-personal property are alleged by the plaintiff and other defendants. That is my earlier. The amendment is sought, my lord. This page number 51. This defendant grandfather late Chinnappa Reddy during his lifetime purchased the property so and so under registered sale deed.
You will permit you to urge all these contentions there. We will not ಮತ್ತೆ amendment ಅದೊಂದು ಇದು then another round of ಇದು.
Admitted by their
no sir.
Defendant.
You have elaborated it. I will permit you to urge all these contentions while submitting.
And prayer has been added by you.
No sir.
For not binding ಅಂತ ಒಂದು ಕೇಳಿದ್ವಿ.
That's the problem.
It's
no sir.
In view of the gift deed of 1951, I am seeing you for not binding.
No sir. The petitioner is before this court calling in question.
Supreme Court judgment.
Oh, what is sir? Yeah. If it does not change the nature, permit ಮಾಡಬೇಕು.
All the amendment application has to be allowed.
All the amendment application.
Para 11.2.
Yes, sir.
All the amendments are to be allowed, which is necessary for determining the real.
This is unnecessary. As simple as. The petitioner is before this court calling in question an order of the concerned court dated 7/4/2025, by which the application filed by the petitioner, petitioner defendant number 6, petitioner defendant number 3, comes to be, under Order 6 Rule 17 comes to be rejected. The petitioner heard so and so. A suit is instituted in OS 324 of 2011 by the plaintiff seeking partition and separate possession. The petitioner enters appearance, files his written statement in the year 2017. 5 years thereafter, seeks to file an application under Order 6 Rule 17 seeking amendment of the written statement. The amendment of the written statement, and would submit that the written statement. The concerned court, owing to the objections filed by the co-defendant, rejects the application on the score that the amendment so sought would be hit by proviso to Rule 17 of Order 6. The learned counsel for the petitioner submits that in the original written statement so filed, all these facts are already narrated. What the petitioner would wanted to do with the amendment is to elaborate those statements made in the written statement, as also certain other prayers to be sought. The learned counsel would submit that it would not change the nature of the written statement or would not cause prejudice to the plaintiff. The concerned court, by the order dated so and so, rejects the application. Page
number 19. Order sheet page number 18.
9.
Sub page number 15 in the starter order.
The concerned court, answering the application, has held as follows. Page 15 to 20. The learned counsel for the petitioner submits that the order would run foul of the judgment of the apex court in the case of Dinesh Goyal versus Suman Agarwal. The learned counsel submits that the apex court holds that all amendments should be permitted. There can be no qualm about the principle so laid down by the apex court. The issue is whether the amendment would be necessary or the amendment would take away the already concluded examination or cross-examination, as the case would be. The amendment so sought by the petitioner, even according to him, is only an elaboration of the earlier written statement. Therefore, there would be no warrant for the petitioner to elaborate it by seeking amendment. The petitioner is at liberty to urge all those contentions at the appropriate stage before the concerned court. The concerned court, finding no perversity in the order so passed by the concerned court, rejecting the application filed by the petitioner under Order 6 Rule 17, the petition stands rejected. Yes. Next.
For 20 adjourned, number 21.
Petitioner in this matter, Lordship.
I am respondent number 7, sir. I request
Respondent number 2, my Lordship.
to appoint a advocate I want sometimes. Respondent number 7.
The respondent has appeared in person, seeks 2 weeks' time to engage the services of a counsel. List the matter on 24th. Interim order subsisting would continue till the next date of hearing. Great. Yes, next.
22.
Adjournment 22. List after 2 weeks. At the request of the counsel appearing for the petitioner, list after 2 weeks.
23 adjourned. 24.
Respondent David. My lord, with regard to the demolition order, my lord, the execution petition, there was some problem, my lord, with regard to demolition of the entire building. I requested my learned friend, my lord, if some amount is ready to make payment because he is having adjacently vacant site. My client is also before the honorable court.
Settlement markoli. No problem.
I put a word to my client, my lord. He said that he wants that entire site with that.
Yes, sir. Come on, merits.
My lord.
Come on, merits.
Please. My lord, only one submission is, my lord. On merits, I may not be having much to submit. The reason is this. I can only say a quotation from Merchant of Venice, that's all. Problem is, my lord, 2005 ಅಲ್ಲಿ ಆಗಿದೆ ನನ್ನ ಕಡೆ
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ ನಾನು ತಪ್ಪಾಗಿದೆ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿಲ್ಲ. ನಂದು ಒಂದೇ ಪ್ರಾರ್ಥನೆ, ಪಕ್ಕದಲ್ಲಿ ಒಂದು ವೇಕೆಂಟ್ ಸೈಟ್ ಇದೆ, ಅಲ್ಲಿಗೆ ತಗೋಬಹುದು. ಆಮೇಲೆ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂನಲ್ಲಿ ನಾನು ಕಟ್ಟಿರ್ತಕ್ಕಂಥ 30 ಮೈ ಲಾರ್ಡ್ ಅನ್ಯಾಯವಾಗಿ ಡೆಮಾಲಿಷನ್ ಆಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ. ಇಷ್ಟೇ ನನ್ನ ಪ್ರಾರ್ಥನೆ. ತಪ್ಪಾಗಿದೆ ಸ್ವಾಮಿ, ನಾನು ಅದಕ್ಕೆ ನನ್ನ ಕ್ಷಮಾಪಣೆ
ಅವ್ರ
ಕೇಳ್ತೀನಿ.
ಸೈಟ್ ಅಲ್ಲಿ ನೀವು ಕಟ್ಬಿಟ್ಟಿದ್ದೀರಿ, ಏನ್ ಮಾಡಕ?
ಅದೇ ಅಲ್ಲ, ಅದಾಗಿದೆ ಅಲ್ಲಿ. ಅದು ಇಷ್ಟೇ ಪ್ರಾರ್ಥನೆ ಏನಂದ್ರೆ ಎಂಟೈರ್ ಬಿಲ್ಡಿಂಗ್ ಕೊಲಾಪ್ಸ್ ಆಗುತ್ತೆ. ನಮ್ ಸ್ನೇಹಿತರು ಒಂದು ಮಾತು ಹೇಳಿದ್ರೆ ಆಗುತ್ತೆ.
ಎಂಟೈರ್ ಬಿಲ್ಡಿಂಗ್ ಏನು ಎನ್ಕ್ರೋಚ್ ಪೋರ್ಷನ್ ಮಾತ್ರ ನಾವು
ಕರೆಕ್ಟ್, ಅರ್ಧ ಮನೆ
ಹೋಗುತ್ತೆ ಸರ್. ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಮೀಡಿಯೇಷನ್ ಮುಂದೆ ಏನಾದ್ರು ಬಂದ್ರು ಪ್ರಯತ್ನ ಮಾಡಬಹುದು.
ಮೀಡಿಯೇಷನ್ ಕಳ್ಸೋಣ.
ಪಾರ್ಟಿ ಇಸ್ ನಾಟ್ ಅಗ್ರಿಂಗ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ತಿದ್ರೆ
ಪಾರ್ಟಿ ಮೇ ಕಮ್ ಟು ಮೀಡಿಯೇಷನ್.
ನಮ್ಮವ್ರು ಇದಾರೆ.
He is also aged 85 years old.
ಅಲ್ಲ, my client is also
actually my party insists him to meet him, but
both of you sit
meeting.
across and do something,
please. That's why I submitted ballot. On merits I cannot say.
ultimately save the house already constructed.
ಅಲ್ಲ ಇದೇ
ಅಲ್ಲ, ಅದು wrongly constructed in your site.
ಇಲ್ಲಲ್ಲೂ ಏನು ಹೇಳಿಲ್ಲ, RSL ಇದ್ದಾಗ್ಲೂ ಏನು ಹೇಳಿಲ್ಲ. Now when execution is insisted, then he come with this plea.
ಈಗ ಮರ್ಸಿ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ನಾನು
ಇಂಥ ಟೈಮಲ್ಲೇ ಬರೋದು ಎಲ್ಲ ಆದ್ಮೇಲೆ.
ನಾನು ಹೇಳಿದೆ, ಅಡ್ವೈಸ್ ಮಾಡಿದೆ, ನೋಡಿ ಇವತ್ತಿನ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೊಡಂಗಿದೆ ನೋಡಿ, ಅವರು ಕೋರ್ಟ್ ಖರ್ಚು
ಅಲ್ಲಿ ಏನು
ಖರ್ಚು ಮಾಡಿದ್ರೆ
ಏನಿದೆ ಅದು ಕೊಡ್ತಾರೆ. SR ವ್ಯಾಲ್ಯೂ ಅಲ್ಲ ಸರ್, SR ವ್ಯಾಲ್ಯೂ ಯಾರು ಒಪ್ಪಲ್ಲ.
ಅದನ್ನು ಎನ್ಕ್ವೈರಿ ಮಾಡಿ.
ಎನ್ಕ್ವೈರಿ ಏನಿಲ್ಲ, SR ವ್ಯಾಲ್ಯೂ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ.
ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂನೇ ಆಗ್ಬೋದು.
The learned counsel appearing for the petitioner submits that the effort is to save the house that is wrongly constructed in the property, in the land belonging to the petitioner. The learned counsel belonging to the plaintiff. The learned counsel for the petitioner submits that if the respondent would agree for any kind of settlement, he is ready and willing to pay the market value obtaining today for the site or the constructed house thereon. The learned counsel appearing for the respondent seeks a week's time to secure instructions on this aspect and report back to the court. List the matter on next Friday. 12th.
15th, 16th.
ಆಯ್ತು, 15th Monday. List on 16th. List on 16th.
I'm sorry, my lord. I am 227 article, my lord. I know my limitations.
ಅಲ್ಲ, even I know my limitations. ಅದಕ್ಕೆ ಇಷ್ಟ ಹೇಳಿ.
My lord, interim order make it.
Interim order subsisting subject to the, in the light of the aforesaid, the interim order subsisting would continue till the next date of hearing.
25.
Yes, Ajay Kumar.
Now they have sought for amendment, my lords. My lords, earlier they had not brought to the notice of the court that there was a consent given. Consent award is passed. Well to notice is already issued. Now that we produce the same, my lords, now they want to seeking quashing of the said consent award itself.
Allah, my lord, they say
And consent given by the predecessor of the petitioners, my lords.
Predecessor and
subsequent
my father.
purchaser.
No. My father, my lord, has passed away long back, my lord. We did not know about the existence of that award.
You did not know of the passing away?
No. About the consent award which they are saying, my lord, it was never their case in the writ petition that there is a consent award. In the appeal also, my lord, that was not cited as, my lord, there existing a award of any nature. My lord, the direction, my lord, issued by the division bench, my lord, which my lord has recorded on the last occasion.
ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ.
ಹೌದು, ಅದರಲ್ಲಿ directions ಅಲ್ಲಿ as per that, my lord, annexure A.
As per that, we will grant you relief.
Yes, my lord, I'm only seeking as per that, my lord. I gave annexure A as representation. I wanted that to be considered. Without doing that, my lord, they wanted to demolish. That's the time, my lord, I have come before the honorable court.
They will consider and pass orders in terms of the division bench judgment.
They are bound to do that.
Ajay Kumar has no problem with that.
They are bound to do that, my lord.
Yes, because it's a direction. It's not a concession given.
Correct, my lord. There is a direction. Now, my lord, after, for the first time, they came with a plea.
ಅದೆಲ್ಲ ಅಲ್ಲೇ you urge all that representation ಕೊಡಕ್ಕೆ ಹೆಂಗು division bench ಹೇಳಿದ್ದಾರೆ, ಕೊಡ್ಬೇಕಾದ್ರೆ ಎಲ್ಲ ಹೇಳಿ ಅಷ್ಟೇ. I will fix a time limit within which the representation will be considered.
My only, my lord, apprehension was they will.
ಅಲ್ಲಿವರೆಗೂ JCB ಬರಲ್ಲ ನಿಮ್ಮ ಹತ್ರ.
ಹೌದು, ಅಲ್ಲ. My only apprehension was, my lord, that now that they are saying there is a consent award, that issue, my lord, because it has not.
They can take any defense of theirs, sir. How can?
No, that's why, my lord, I made a.
Your father has given the consent.
No money is paid all these years.
ಅದೆಲ್ಲ
They have given an endorsement that no money is paid.
Anyway, you will come back here.
12 to notice is once is issued, my lords. It is for the landowner
Adella,
to come.
all that reply you give there. We'll close this following Nada Prabhu.
Please.
ಯಾವ page ಅಲ್ಲಿ ಇದೆ ಶ್ರೀರಂಗ sir?
Lord, Annexure A is my representation.
Representation ಆಯ್ತು.
Directions,
Judgment.
my lord. Directions.
Directions
my
at
lord,
page 4 not ಇಲ್ಲಿದೆ ಬಿಡಿ.
Yes.
421.
Yes, 421. Internal page 305.
The petitioners are before this court seeking the following prayer. This court, owing to the submission so made on 19/8/2025, had passed the following order. The result of the said order is an application now sought to be preferred before this court seeking quashment of a consent given by the father of the petitioners. The learned counsel appearing for the respondent Ajay Kumar submits that what the petitioners are entitled to only the benefit granted by the division bench in all identical circumstances. The division bench,
Including the petition, they were parties in the previous.
More so in the light of the fact that these petitioners were petitioners, appellants, were appellants before the.
No.
Appellant was Bangalore Development Authority.
Sorry, were petitioners before the petitioners / respondents before the appeal proceedings. The division bench has disposed the appeals by the following order: 421 to 426. Quote full. The learned counsel appearing for the learned senior counsel for the petitioner now submits that the BDA be directed to consider the representation of the petitioners. The representation is dated 20th May 2024, which is appended to the petition. The judgment of the division bench, date another, is 22nd February 2024, which is earlier to the representation so submitted. Therefore, the BDA is obliged to consider the representation of all those persons who were parties to the writ appeal so disposed on 22nd February 2024. In that light, I deem it appropriate to dispose the subject petition, directing the BDA to consider the representation appended to the petition and pass necessary orders in accordance with law, bearing in mind the observations made by the division bench in an outer limit of
12 weeks.
In an outer limit of 12 weeks from the date of receipt of the copy of the order. All contentions of the petitioner and the defense of the respondent shall remain open. In the light of the direction of the division bench, till the representation of the petitioner is considered and appropriate orders passed in accordance with law, no coercive steps be taken by the BDA, the property of the petitioner, ordered accordingly.
I may be given liberty, my lord, to file a further representation because they have raised additional plea here, my lord, for the first
The
time.
petitioner is at liberty to the BDA shall consider, the petitioner is at liberty to submit a fresh representation if the need so arises. The BDA shall consider the same also in accordance with law in the event it is submitted by the petitioners.
Please, sir.
26.
IAS will not survive, my lord.
In the light of the said orders, applications pending will not survive for consideration.
This case appear for the petitioner, my lord. Notice
20?
already. 20.
Yes,
Notice
sir.
already served. Our challenging orders on Annexure K is order 21 rule 54 allowed by the trial court.
Separate appeal.
Appeal. Order 21 rule 54 for IA is allowed.
Judgment date or. Yes, sir.
So the earlier of the respondent file a claim petition before the trial court, my lord. The owner of the mother of the deceased, my
Owner
lord.
of the mother of the deceased. ಏನ್ ನೀವು ಹೇಳಿದ್ದು?
Earlier vehicle owner of the mother of the petitioner, my lord. So
owner of the mother of the deceased. Yes.
Climate, respondent climate is death of the accident, my lord. The respondent.
Death of the
accident. Is
died due to the accident.
ಹೌದು.
ಆಮೇಲೆ
So after he is owner of the petitioner mother, my lord, vehicle owner, my lord. Vehicle is there, my lord. There is no any attachment of the vehicle in the even till today's, my lord. This 4-acre land is my property, my lord. The trial court attachment is my property, my lord.
Oh.
That is one
You
of
are
the,
owner of the vehicle.
No, my mother is owner of the vehicle.
ಎಲ್ಲ ಒಂದೇ.
ಅಲ್ಲ ಇದು ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ಸೆಲ್ಫಕರ್ ಪ್ರಾಪರ್ಟಿ.
ಹೌದಾ?
ಹೌದು, ಬ್ರದರ್ ಇಂದ ನನಗೆ ಬಂದದ್ದು. ಸೊ ಈವನ್ ಟುಡೇ ಅರ್ಲಿಯರ್ ದಿಸ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರು. ದಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್
You are not a party.
ಅರ್ಲಿಯರ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ. ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ತಂದು ಎಲ್ಲರ ರಿಜೆಕ್ಟ್ ಆಯ್ತು. That order is challenging. Earlier 2154 is allowed by the trial court. That order it is challenging before this honorable court. A writ petition allowed set aside order. ಏಕೆಂದ್ರೆ ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಆಯ್ತು, ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ subsequently one more execution petition is filed, my lord. Straight way there is only attachment of property, my lord. That the
ಏನ್ ಕ್ಲೈಮೆಂಟ್ಸ್ ಎಷ್ಟು ಕ್ಲೈಮ್? ಡೆತ್ ಇಂಜುರಿಯಾ?
ಡೆತ್. ಈಗ 18 lakhs ಆಗಿದೆ. 4 acres land, very higher price, my lord. But your purpose ಅಲ್ಲಲ್ಲ, ಬಟ್ ವೆಹಿಕಲ್ ಇದೆ, ವೆಹಿಕಲ್ ಅರೇಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಯಾವ್ದು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಯಾವ ವೆಹಿಕಲ್ ಅದು?
ಟ್ರಾಕ್ಟರ್ ಅಂಡ್ ಟೈಲರ್. ಈವನ್ ಸ್ಟಿಲ್
2 ಲಕ್ಷಕ್ಕೆ ಹೋಗಲ್ಲ.
ಅಲ್ಲ, ಅವತ್ತೇ ಹರಾಜ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಇನ್ನೂ ಈಗ ಇದ್ರಲ್ಲಿ ಆಗೋದು. ಬಟ್
ಹರಾಜ್ ಮಾಡದೆ ಇವತ್ತು ಹರಾಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಅವ್ರು ಹರಾಜ್ ಮಾಡಿ ಈ ಜಮೀನೇ ಹೊಡಿಲ್ಬೇಕು ಅಂತ ಪರ್ಪಸ್ ಓನ್ಲಿ ಡೈರೆಕ್ಟ್ ಆಗಿ 2154 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕುದು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲೌ ದ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ
ಬರ್ಲಿ ಅವರು.
ಅಲ್ಲ, ಬಂದು ಕಾಪಿ ಸರ್ ಮಾಡಿ 4 ಟೈಮ್ ಆಯ್ತು, ಇಲ್ಲಿ ಬರ್ಲೇ ಇಲ್ವ?
4 ಟೈಮ್?
ಹೌದು, 4 times ಆಯ್ತು.
4 times.
ಈವನ್ ಟಿಲ್ ಟುಡೇ ಬರ್ಲೇ ಇಲ್ಲ. ಅಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ರೆ
ಅವರೇ ಬರ್ತಾರೆ.
ಅವರೇ ಬರ್ತಾರೆ.
ಗೊತ್ತಾಗಿದೆ ನಿಮ್ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲಲ್ಲ, ನಮ್ದೇನಿಲ್ಲ ಸ್ವಾಮಿ. ನಾವು ಅಪ್ಲಿಕೇಶನ್ ನಮ್ದ ಪ್ರಾಪರ್ಟಿ ಹೆಂಗ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡಿ ಬರುತ್ತೆ, ಕಾನೂನು ಪ್ರಕಾರ ಏನಿದೆ ಅದನ್ನ
ಅದ್ರಲ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ, ಕರ್ಸಕ್ಕೆ ಇದೊಂದು ಸ್ಟೇ ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ. List the matter on 22nd in preliminary hearing. The order impugned shall remain stayed till the next date. Further proceedings in execution so and so shall remain stayed till the next date. Next.
27.
Plaintiff suit for recovery of money. Section 8 application is allowed. Matter is referred to the arbitrator. Court fee is not refunded.
Court, idondu ivat bardidinalla. Today's judgment, I think I have held that.
Pardon me?
I have held that court fee should be on reference to arbitration. Now you take court fees act ತಗೊಳ್ಳಿ.
66 and
ನೀವು ಓದಿ ಓದಿ
where the
ಮೂರು ತಗೊಳ್ಳಿ. Section 16 of the Court Fees Act, Central, take that. Section 89 of the CPC,
89 of
take
the
that.
CPC.
Then come to 66A of.
So once it is referred,
ಅಲ್ಲಿ ಇದ್ಬಿಟ್ರೆ ಆ ತರ ತೋರಿಸಿ, once it's referred.
Where the court refers the parties to the suit to any one of the modes.
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ಈಗ? What are you reading?
66 I'm reading.
ಓದಿ.
Where the court refers the parties to suit to any one of the modes of settlement of dispute referred to in section 89 of the Code of Civil Procedure Code, and the dispute is settled.
Yes. And the dispute is settled. All right. That is the difference between or contradictory to the central enactment. If you see section 16 or if you see 89, now 89 CPC ಹೋಗಿ.
Where it appears the court
89 CPC straight away says the moment it is referred,
once it
they
is
are
referred,
entitled to.
yes.
Section 16 of the Central Act says the moment it is referred, they are entitled to. State Act says and settled.
And settled.
What to do?
Until the matter is now decided by the arbitrator, my money will be lying.
Correct. Now, once the arbitrator would decide the issue either in your favor or otherwise, what is the next step? What?
Yeah, my
34 application. You don't go before that court at all again.
Yes.
Howda?
Why I need not go before the court again.
That's exactly the point. So you should court fee should be refunded. I've passed an order. I'll take this tomorrow. We'll dispose this in terms of that order.
Please.
We'll release it tomorrow because the state should amend it. And settled antirado, it will create problems. Yes. Release these matters tomorrow.
Appear for petitioner. Suit for partition.
Application ಏನು?
Impleading application rejected in trial court, my lord.
Suit for partition filed when, madam?
2014, my lord.
Impleading first appeal ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಆಗ
ಆರ್ಯಲ್ಲಿ ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್.
Yes, please.
ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳಿದ್ದು. ಅಲ್ಲಿ ಯಾಕೆ ಹೋಗ್ಲಿಲ್ಲ ನೀವು?
ಅವಾಗ ಗೊತ್ತಿರ್ಲಿಲ್ಲ, my lord.
ಯಾರು? Who are you?
Petitioner husband ಡೆತ್ ಆದ ನಂತರ ಅವರು ಸಪರೇಟ್ ವಾಸ ಇದ್ರು, my lord. Petition.
ಈಗ ಅಕ್ವಿಸಿಷನ್ ಆಗ್ತಾ ಇದೆಯಾ ಪ್ರಾಪರ್ಟಿ?
Yes, my lord.
ಅದಕ್ಕೆ ಈಗ ಇಂಟ್ರೆಸ್ಟ್.
My lord, last date plaintiff ಗೆ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಕಾಪಿ ಸರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ಸ್ ಆಗಿತ್ತು.
ಬರ್ಲಿ ತಾಳಿ.
ಕಾಪಿ ಸರ್ ಮಾಡಿದೀನಿ.
ಬರಲ್ಲ ಮೇಡಮ್. Learned counsel submits that the order dated 11/8/2025 is complied with. Awaiting the representation of the respondent, list the matter on 8th in preliminary hearing.
Interim order. Please, my lord.
8th, yes.
The petitioner, Annexure E, commissioner of appointment of commissioner is questioned, my lord. The application filed by the defendant, even the defendant has not led any evidence. The subject
Application is allowed.
allowed, it came to be allowed, my lord. The subject matter
Suit
of
for?
the suit for permanent injunction filed by the plaintiff. The subject matter of the suit property is
So
definite.
it had to be allowed, correct agi. Yes.
My submission, kindly see the written
List the
statement.
matter on 24th, awaiting the representation of the respondent. Till such time, the order
Annexure
dated
E.
so and so, date and order shall remain state. Yes.
30.
Yes, Vivek.
Previous date of hearing, Lordships have permitted me to serve the copies to the counsel representing the respondent.
Suit for?
And it is arising out of an execution petition. Suit was formulated for.
Your JDR?
I am the decree holder.
Decree holder?
Please.
ಏನಾಗಿದೆ ಈಗ?
The suit was decreed in part directing return of the amount paid by the petitioner. They did not refund the amount despite the decree. We filed execution petition. Petition was filed in 2020. Every date of hearing, they are paying 10,000 rupees.
Petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is the decree holder. The respondent, the judgment debtor, suffers a decree in OS 222 of 2020 seeking specific performance. The amount was directed to be returned by the trial court while passing the decree. The amount was not returned and therefore the petitioner decree holder files an execution petition before the concerned court in execution
54 of 2023.
in execution 54 of 2023. The learned counsel for the petitioner submits that the concerned court has ad nauseam adjourned the matter for the asking, which runs counter to the judgment of the apex court in Rahul Shah versus so and so 2021 6 SCC page 418, where the apex court has laid down certain postulates of closure of the execution proceedings within a time frame. The time frame fixed by the apex court is within 6 months, particularly of money decree, which the present case is one. In that light, I deem it appropriate to direct the concerned court to dispose the execution proceedings with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier ordered accordingly.
Please.
31.
Petitioner the application for amendment of the plain lords, the suit for specific performance.
Amendment of the plaintiff in specific performance. Why sir?
In a suit for
ಇನ್ನ 3-4 ಪ್ರಾಪರ್ಟಿ ಆಡ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Suit is of the 2023.
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ?
No, not for the suit schedule property.
ಮತ್ತೆ ಏನು ಅಮೆಂಡ್ಮೆಂಟ್?
Only issue, my lord, as the trial court has framed the issue. Number one, that whether the plaintiffs have proved that they have paid the advance amount through check. But my lord,
ನೀವು ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
we have paid in cash. So that amendment we have started, my lords. The suit is for 23, my lord. Issues are framed on 19/8/24.
ನೀವು ಸೂಟ್ ಹಾಕಿ 23 ಅಲ್ಲಿ
23, but
ಪ್ಲೇನ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾಕೆ ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ದು ಹೇಳಲೇ ಇಲ್ಲ?
we have not, but oversight it has not.
Oversight?
Yes, my lord.
ಓವರ್ಸೈಟ್ ಅಲ್ಲ ಸರ್, ಫೋರ್ಸೈಟ್ ಇರ್ಬೇಕಾಗಿತ್ತು. ಮುಂದೆ ಈ ಅಬ್ಜೆಕ್ಷನ್ ಬರುತ್ತೆ.
They have not stated either in cash or
Oh,
check.
no.
They stated that amount has been paid. I'll kindly see the in cross examination that DW2 has been
ನಿಮಗೆ
admitted.
ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ ನೆನ್ಪಿದ್ರೆ ಅವತ್
Kindly
ಫಸ್ಟ್
see, my
ಗ್ರೌಂಡ್
lords.
ಅದೇನೆ.
No, not only
Plaint
when,
ಅಲ್ಲಿ.
only when the issues, we came to know that now that the issue has been
ಕೇಮ್ ಟು
framed.
ನೋ ಯಾಕೆ ದುಡ್ಡೇ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ, ಅದಕ್ಕೆ ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
No. Kindly see, the issue is framed on 19/8/24.
ಮೇ ಬಿ
We have not known that the issue has been framed, that check through check.
ಬೇರೆಯವ್ರದ್ದು ಬಿಡಿ ಸರ್, ನೀವು ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಥವಾ ಕ್ಯಾಶ್ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ.
Yes, my lord, but in plain, my lord, while drafting, they are not stated whether it is cash or check. But kindly see, the DW2 has been admitted the receipt of the amount.
Admit receipt of the amount, admission is
92, my lords. Page number 92. At 7th line, my lords. CP 2017 ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. They have admitted.
ಅಗ್ರಿಮೆಂಟ್ ಆಯ್ತು.
ಬಟ್ ನಾವು 6.5 ಲಕ್ಷ ಹಣ ಪಡೆದಿರುತ್ತೇವೆ. ಮುಂದುವರೆದು ಹಣ ವಾಪಸ್ ಮಾಡಿರುತ್ತೇವೆ. That has they have to prove, my lord. My opportunity has to be given, my lord, that has to be determined in the trial.
ಅಲ್ಲ 6.5 ಲಕ್ಷ ಹೆಂಗ್ ಕೊಟ್ರು?
ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಇಸ್ಕೊಂಡಿದೀವಿ ಅಂತ they are admitted.
ಕ್ಯಾಶ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಕ್ಯಾಶ್ ಅಂತ ಹೇಳಿಲ್ಲ, ಬಟ್ ರೆಸಿಪ್ಟ್ ಆಫ್ ಅಮೌಂಟ್ has been admitted by the
ಟೋಟಲ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ನಿಮ್ ಪ್ರಕಾರ?
6.5 ಕೊಟ್ಟಿದ್ದೀವಿ.
Only 6.5 lakhs.
Registered agreement, my lords. Is an agreement, registered agreement.
ಪ್ಲೇಂಟ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಹೇಳಿದ್ರಿ?
ಅಷ್ಟೇ ಹೇಳಿದ್ವಿ.
6.5 ಲಕ್ಷ. ಹೆಂಗೆ ಅಂತ ಹೇಳಿಲ್ವಾ?
ಹೆಂಗೆ ಅಂತ ಹೇಳಿಲ್ಲ. Kindly see the
petitioner to serve on the council or represents.
ಸರ್ವಾಗಿದೆ already 11th on 11/8 ಅಲ್ಲೇ ಸರ್ವ್ ಮಾಡಿದ್ವಿ. Even last occasion before the trial court, we have submitted the pendency of the court.
The learned counsel appearing for the petitioner submits the copies of the service of notice is effected upon the petitioner, upon the respondent before the concerned court. The submission is placed on record. The learned counsel submits that the application seeking amendment of the plaint comes to be rejected on the score that it will change the nature of the suit or nature of the proceedings. The observation of the concerned court appears to be erroneous, as the claim of the petitioner in a suit for specific performance is that he has paid 6.5 lakhs. 6.5 lakhs is admitted to have been received in evidence, received by the respondents in evidence. In that light, the amendment would not have changed the nature of the suit. Therefore, further proceedings before the concerned court shall remain stayed till the next date. List on 24th.
32.
I appear for the petitioner in this matter. Service has been completed, my lord. We have served the copies on the learned advocate for appearing in the trial court. Order 26, Rule 9, my lord. Suit for declaration and mandatory injunction for removal of encroachment. My lord, what has happened is suit was filed against defendant number 1 to 4. During the pendency, after the evidence, my lord.
Awaiting the representation of the respondent, last time I heard you. Awaiting the representation of the respondent, list the matter on 24th. Further proceedings before the concerned court till the next date shall remain stayed.
For the petitioner, my lord, we have served the copy on the opposite side on 22nd of August itself, my lord. It is suit for partition, my lord.
What's the problem now?
My lord, in the suit for partition, my 1/3 share was given to me, my lord. Subsequently, they filed.
Oh, redetermine the shares.
Yes, my lord, redetermining of
But
shares.
without hearing difficult, madam. We'll give another date. List the matter on 8th in plenary here.
Proceedings, they have filed application for selling of that particular property in 2/3 and 1/3 share, my lord. Kindly stay the proceedings.
Stay beda. The respondent shall not change the nature of the property, subject matter of the FDP. Yes, next. Indirect stay. Yes.
34.
I am appearing for petitioner. The petitioner is a defendant in lower court 2 to 8 defendants filed application order 8 rule 6A for counterclaim. Petitioner is claiming right to the property basing upon suit for declaration and delivery of possession basing upon a sale agreement executed by the 9th defendant in favor
Now
of
counterclaim is rejected.
Now my counterclaim is rejected.
On what ground?
They are saying that it is a delay of proceedings and barred by limitation.
9 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ?
Yes. For that reason, I do not know about the pendency of the suit. Moreover, after the.
When did you enter appearance?
By way of the commissioner visit, at the time of commissioner visit.
When did you filed an application?
Yes, I filed application.
Impleading application yavaga?
IA number 11.
Page, date.
What, sir?
Date and when was it allowed?
Page number 50.
Date ಹೇಳಿ sir, page number ಬೇಡ.
22/10/24 milad.
22/10?
24.
Impleading application is allowed.
Application is allowed.
When did you file it?
22/10/24 milad.
When did you file it?
I filed.
24 ಅಲ್ಲೇ ಹಾಕಿದ್ರಾ?
My lords, he filed it in
No,
24,
no.
25 ಅಲ್ಲಿ ಈ application ಹಾಕಿ it's come to be rejected now.
It should be allowed, sir.
My lords.
Anything else?
ಅದಲ್ಲ, he is defendant number 2 to 5, my lords.
Counter claim
He
ಹಾಕ್ಬಾರ್ದು
was-
ಅಂತಿದ್ಯಾ?
ಅಲ್ಲ. Since 2015, he was placed ex parte. He was not, he didn't
Sir,
come. since
whatever it
2015.
is, he is now impleaded into the suit in the year 2024.
Yes.
How can the court say after 9 years you are filing it?
My lords.
Impleaded your party idra?
Party idro.
I am the
Defendant number
party.
2 to 5 is.
I am the
For
party.
the party?
I am the party. Defendant number 2 to 8. I am the party. But no notice is served. Basing upon paper publication, I am ex parte to the proceedings.
Based on paper publication, you are ex parte.
Yes, yes. Basing upon paper publication, I am ex parte because no notice is served. After the visiting of the commissioner, I know that the suit is pending. For that, I filed IA number 11. IA number 11 is allowed on cost of rupees 8,000. 8,000 is all deposited on 22/10/2024. The court is given chance for filing written statement on 4/11/22.
Permission is granted for written
Permission is
statement?
granted. That is the reason why I am the right of the owner, the property to file a written statement as a counter claim, my lord.
My lords.
Anything else, sir?
Evidence both sides, it is complete as of
No,
now.
no.
No problem.
That
No,
being
no.
this, my lords.
No judgment, kodi sir.
No, evidence is not complete. It is.
Hey,
a
wait,
commi-
sir.
commi- Yes, please.
My lords.
ಗೊತ್ತು. hold ಮಾಡಲಿಲ್ಲ ಅಂತ. ಸಾಯಂಕಾಲ ಮಾಡ್ತೀನಿ. ಮಿಕ್ಕಿದ್ದೆರಡು ಮಾಡಕ್ಕೆ.
Notes. Supreme Court of India, my lords.
Supreme Court of India. ಆಮೇಲೆ?
My lords.
ಹ್ಮ್.
Decided in the year 2022, my lords. Ink page number 13, my lords. 13. Para number 12.
ಬೇರೆ ಯಾವ್ದಾರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆಯಾ?
My lords.
ಅಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಬೇರೆ ಯಾವ್ದಾರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆಯಾ?
My lords, the next one also.
ಅದು ಇಂಡಿಯಾನೇ? ಎಸ್.
My lords. Para number 12, my lords, ink page number 13. A counterclaim should be treated as a plaint and governed by the rules applicable to the plaints, my lords.
Yes, sir.
And such being the case, my
Counter
lords.
claim is definitely a separate plaint, separate
Yes.
suit.
Yes.
No problem.
My lords, such being the case, my lords, Ashok Kumar Kalra versus Surendra.
The delay mele.
Delay mele, my lords, when the delay is there, if he's filed an application to condone the delay, my lords, it could have been considered. Even the application that is filed under Order 8, Rule 6A, my lords, in the update also, it does not mention why there's a delay. ಏನು mention ಮಾಡೋದಿಲ್ಲ. He files an application stating that ಈ ತರ allow ಮಾಡಿ ಅನ್ನೋದು ಮಾತ್ರ ಕೇಳ್ತಾರೆ. It does not say anything.
ಈಗ ಅವ್ರೇನು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರ?
No, it does
ಪೇಪರ್
not say anything
ಪಬ್ಲಿಕೇಶನ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಅದು ಎಲ್ಲ ಗೊತ್ತಾಯ್ತಾ ನಿಮ್ಗೆ?
My lord, I am aware of the.
ಯು ಆರ್ ಅವೇರ್? ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ನೋಡಿ, ಹ್ಯಾಪಿ ದಟ್ ಯು ಆರ್ ಅವೇರ್.
On 22/10/2014, my IA Order 9 Rule 7 petition is allowed. And seeking 4/11, the case is posted for that. On 22
He is ready.
4/11 filed written statement filed with counter claim and court fee also deposit. You are not can see page
That's
number
counter
60.
claim with the written statement. If he had filed, this problem wouldn't have been there, my lords. He filed
Page number
subsequent
61
application.
ಆಯ್ತು, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
It
ಈಗ
is-
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಹಾಕಿದ್ರೆ ಆಗ್ತಾಯ್ತಾ?
My lords, that the court had to adjudicate the
ಆಗ್ತಾ
matter, my
ಇತ್ತಾ?
lords. My lord, that the court
ಅದಕ್ಕೆ
has to
ಸಪರೇಟ್
decide.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಕ್ಕೆ ಈ ಪ್ರಾಬ್ಲಮ್.
Separate application, my lord, delay application ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅನ್ನೋದು.
ಯಾಕೆ ಬೇಕಾಗಿತ್ತು?
No need.
There is a delay, my
It is
lord.
the right
No
of the
need.
defendant. It is the right of the defendant to file a counter
No
claim.
need.
Counter, my lords, after the evidence is come, all.
Yes, sir. Anything
almost
else?
Complete, my lords.
Hyper technicality alla bidal. Yes. Written statement kodade iddidre, there is some meaning. Written statement will counterclaim idre, there was no claim for you.
My lords, that the court.
It is only for declaration.
I cannot make that.
Yes, please.
I cannot.
ಅವರು my right ಅಂತ ಹೇಳ್ತಾನೆ ಇದ್ದಾರೆ ನಿಮಗೆ. And you are saying he is not right? Yes. The petitioner is before this court calling in question an order dated 11/7/2025 passed by the concerned court rejecting an application under Order 8 Rule 6A of the CPC in IA 13 seeking permission to file a counterclaim. Facts in heard so and so. Facts in brief, Germain, are as follows. The respondent plaintiff institutes a suit in OS 7107 of 2015 seeking declaration and delivery of suit schedule property against the defendants. The ninth defendant enters appearance on 4/10/2016 and files his written statement. Defendants 2 to 5 had been placed ex parte, as the learned counsel for the petitioner submits that no notice was ever served upon them. They come to know of the pending suit only when the commissioner comes to visit the property for measurements. The learned counsel measurements. It is then the petitioners file application before the concerned court to seeking permission to file written statement. The permission so sought in IA 11 is allowed on its merit, permitting written statement to be filed by these petitioners, defendants 2 to 5. Later, the second defendant files a written statement along with an application seeking permission for filing of a counterclaim. The application comes to be rejected. The rejection of which has driven the petitioner, defendant number 2 to 5, before this court in the subject petition. The learned counsel appearing for the petitioner, taking this court through the documents appended to the petition, would seek to contend that throughout the proceedings, no notice were ever served upon these petitioners. It is only when the court commissioner comes to visit the property on an order passed by the concerned court, they come to know of the subsistence of the suit in OS 7107 of 2015. It is then the petitioners file application IA 11 seeking to file their written statement on the score that they were never served with the notice. The concerned court accepts the application and allows the same, but the concerned court rejects another application seeking filing of a counterclaim. The learned counsel appearing for the respondent submits. The respondent seeks to place reliance upon 2 judgments of the apex court to buttress his submission that the counterclaim ought to have been filed along with the written statement. A separate application being filed will incur delay. The delay is the suit is of the year 2015 and the counterclaim is sought to be filed in the year 2024. Therefore, there is delay of 9 years. He would contend that the order of the concerned court it does not warrant any interference. I have given my therefore narrated I have given my anxious consideration to submissions made by the respective learned counsel and have perused the material on record. The afore narrated facts linked in the chain of events are all a matter of record. They would not require any iteration. The issue that falls for consideration at this juncture is whether delay has taken away the right of the petitioner to file a counterclaim. The petitioner's defendants 2 to 5 were not served with notices. This is an admitted fact, as the concerned court itself allows an application in IA 11 permitting these defendants 2 to 5 to file their written statement on the ground that no notice was served to them. This application is allowed on 21/8/2024. If the petitioners had preferred had indicated the counterclaim along with the written statement, the court written statement, it would have been appropriate, but the petitioners did not do so. They chose to file another application seeking permission to register a counterclaim. that comes to be rejected on the ground that there has been delay of 9 years in filing the counterclaim. If written statement itself is permitted on 21/8/2024, it is ununderstandable as to how the concerned court could reject the counterclaim, which is a right of the defendant in a suit to defendant in a suit, that too on the ground of delay. The order of the concerned court on the face of it is erroneous. In that light, the petition deserves to succeed. The counterclaim so filed before the application so filed before the concerned court in IA 13 stands allowed. The counterclaim is deemed to have been ಮಾಡಿದ್ದೀರಾ ಮಾಡ್ಬೇಕಾ?
ಮಾಡಿದ್ದೀನಿ.
The counterclaim so filed shall be accepted by the concerned court.
We also accept.
Shall be accepted by the concerned court. The concerned court shall now regulate its procedure and take the suit to its logical conclusion.
Yes.
Ordered accordingly.
Yes.
Next.
List number 3, preliminary hearing, seal number 1.
ನೀವಿದ್ದೀರಾ?
36.
36.
List number 3, seal number 1.
List the matter after 2 weeks. Interim order subsisting will continue to the next date. Next.
Number 2.
The petitioners, Your Honor. This is that compounding notice.
List tomorrow. Yes.
3.
Lord, I appeal for the petitioner in this matter. Your Lordship should notice.
Okay.
Not that the writ petition. Not the writ petition has been filed. Not challenging the order of the trial court as well as the first appellate court, where an application for restoration of the suit for non-prosecution filed by the defendant has been taken as not maintainable, and only the plaintiff can file an application for restoration. Both
Partition suit.
Partition suit.
ಯಾರು ಬೇಕಾರ?
ಮಾಡ್ಬೋದು. ಆ ಒಂದು ಸೂಟ್ ಇರುವಾಗ ಎರಡನೇ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ. ಎರಡನೇ ಸೂಟ್ ನ ವಿತ್ಡ್ರಾ ಮಾಡಕ್ಕೆ 23 ರೂಲ್ ಆನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಹಳೆ ಸೂಟ್ ನೇ ನಡೆಸ್ತೀವಿ ಅಂದ್ರೆ ಅದು ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಅದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಅಲ್ಲ, ಕನೆಕ್ಟೆಡ್ ಸಿಆರ್ಪಿ ನಲ್ಲಿ.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ದಿ awaiting the ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಅಪಿಯರ್ ಆಗಿದ್ರು.
awaiting the appearance of the respondent. Stay ಕೇಳಿದ್ದೀರಾ?
ಸ್ಟೇ ಆಗಿದೆ.
Awaiting the appearance of the respondent, list the matter on 22nd, sorry, 19th. Interim order subsisting will continue to the next date.
Please.
My lords, with your lordships, kind leave. My lords, I'm sorry for interjecting.
Madam, the interim order.
My lords, your lordships may give a date, my lords, because that matter can be disposed.
I will say 19th then, yes.
Very well. I'm sorry, my lords, for not being present.
This is the matter which we had filed a memo for withdrawal regarding the extension of time.
Simpliciter withdrawal you can. None of the observations in the withdrawal memo will be taken note of.
But the reason why we filed the writ petition was that there was
Joshi sir.
correction sought on the cause titlement of the arbitration award. That was the.
You withdraw it, no problem.
Please, madam.
And not in terms of the memo.
So we'll,
just like that.
Please, no objection to that.
We'll file a fresh memo, madam. We'll withdraw that.
All right, it's up to you.
Yes.
File a memo, I'll have passed an order, but only.
Yes.
Yes. The petitioner had filed a memo seeking to withdraw the petition. It was objected to by the learned senior counsel, Shri K.G. Raghavan, who had appeared on the said date. Therefore, the learned counsel Ajesh Kumar now submits that he will file a memo of withdrawal a withdrawal simpliciter. In the light of the memo, the petition stands disposed as withdrawn.
I'll file it right.
Number 5.
I was plaintiff writ petition, my lord, last occasion, my lordship directed to serve a copy to the counsel appearing for the respondents before the trial court. I'm served on, also filed the acknowledgement. My application for amendment, which I only sought to insert prior, my lord. I'm sought declaration.
Suit for
declaration, my lord.
suit for declaration.
Declaration.
Again
I failed to
prayer.
sought to cancel the sale deed is, which is alleged sale deed is not binding on me. And it will not change the nature of the suit, and
The
already.
suit is already for declaration. Declaring what?
Declaring I am the owner of the shoe schedule property. A sale deed mark might be already, and also I will undertake, my lord, I will not adduce any further evidence. Already I am.
ಆಯ್ತು ಅವ್ರು ಬರ್ಲಿ. ಸ್ಟೇ ಮಾಡಿದೆ.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು?
ಇವತ್ತೇ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
ಇವತ್ತಾದ್ಮೇಲೆ ಏನಾಗಿದೆ?
ಇನ್ನು ಡೇಟ್ ಗೊತ್ತಾಗಿಲ್ಲ ಸರ್.
Learned counsel, awaiting the representation of the respondent. Sir, ಮಾಡಿದಿರಾ ಕಾಪಿ?
ಸರ್ ಮಾಡಿದ್ದೆ, ಫೈಲ್ ಮಾಡಿದ್ದೆ.
Representation of the respondent lists the matter on 8th. Further proceedings before the concerned court till the next date shall remain stayed. ಅವತ್ತು ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ.
Please.
List and preliminary hearing. Next.
Number 6.
I prefer respondent number 3 in serial number 6, my lord. I prefer a
Respondent number 1 and 2, my lord.
I prefer a short accommodation, my lord.
Trial court, my lord, after hearing the matter, confirmed the order of injunction. Holding the trial court has recorded a finding that.
First appellate court has reversed it.
I mean, the scope of interference in the appellate jurisdiction, my lord.
Avoid.
Particularly in the matter of discretionary relief. So the finding of the trial court is not substituted by the first appellate court.
I prefer a short adjournment, my lord. The matter may be taken up day after tomorrow.
ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಸರ್ ಅದ ಮೊನ್ನೆ ಇದ್ದಿದ್ದು.
Same.
Yes.
It may be taken up day after
tomorrow. ನಾಳೆ ತಗೋ.
Please.
List tomorrow. Second list la. ಇದು ಸೇಮ್ ಅಲ್ಲ? 7 same. Both 6 and 7. Now come to first list admission.
Admission 65.
Vacating stay. ಯಾರು ಸ್ಟೇಟ್ ಹಾಕಿರೋದ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅವರೇನಾ? ಸ್ಟೇಟಾ? ಇಲ್ಲಿ ಜಗದೀಶ್ ಬರಕ್ ಹೇಳಿ. ಇಲ್ಲೇ ಇದ್ರಲ್ಲ, ಪಾಸ್ವರ್ ಆಗಲ್ಲ. ಪೆಟಿಷನರ್ ಇಲ್ಲ ಬಿಡಿ. Now representation behalf the petitioner. List the matter on 19th. Interim order subsisting will continue to the next date.
66.
Lord, I am for the petitioner, Lord.
Yes,
306 of IPC, Lord, for registered sale agreement was executed by the deceased, Lord, in order to sell the.
Respondent served.
Served.
Long back.
Yes. And I place the judgments plot, there is no proximity and sale agreement was executed when we are insisted to execute the sale deed.
Petitioner is before this court. How accused ನೀವು? Sole accused?
No, my lord. Accused number 1.
The petitioners accused 1, 4 and 5. 1, 4, 5, 6 are before this court calling in question proceedings in CC. In CC 516 of 2024 registered for offences punishable under section 306 and 34 of the IPC. Heard so and so. The facts enumerated are as follows. The petition, see the deceased ge hogtiralla adak munche éniದೆ. An agreement of sale is entered into between the first petitioner and who is the complainant?
Is the mother-in-law
and the husband of the second respondent complainant.
No, son-in-law of the second respondent.
Son-in-law.
Please.
Son-in-law of the second respondent complainant. On 17/6/2023, it transpires that the son-in-law had requested the APMC to issue an NOC to sell his products in this shop. The agreement
Sale of these premises.
To sell the shop premises anta ಮಾಡಿ. Sell the shop premises. It transpires that on 27/8/2023, the son-in-law of the complainant commits suicide. On commission of suicide, the complainant registers a crime in crime number 69 of 2023 for offences punishable under section 306, read with 34 of the IPC. The police conduct investigation, and the result of the investigation is filing of the charge sheet and the concerned court registering CC, so and so, CC 516 of 2024. The petitioner had approached this court at the time of registration of the crime, and this court had granted an interim order of stay of further proceedings in criminal petition 4655 of 2024. Before the interim order could be communicated, the charge sheet was filed by the jurisdictional police before the concerned court. Therefore, the petitioner is before this court in the subject petition on the said prayer. The learned counsel B. Latif, appearing for the petitioner, would submit that there is not a titter of titter of ingredient in the case at hand for an offence punishable under section 306 of the IPC. There is neither proximity nor goading nor instigation of the son-in-law of the complainant to commit suicide. An agreement of sale was entered into 2 months prior to the date of death to sell the shop premises in the APMC. The agreement goes wrong, and the petition and the son-in-law of the complainant commits suicide. Therefore, the blame cannot be laid at the petitioner for instigating such suicide. The complainant is served on 21st September 2024 itself, and has not represented even as on date. The learned additional SPP Jagdish would refute the submissions of the respondent petitioner to contend that the police, after investigation, have filed a charge sheet. In the light of the charge sheet filed by the police, it is for the petitioner to come out clean in a full-blown trial. He would submit that the ingredients necessary for an offence under section 306 of the IPC is undoubtedly present in the case at hand. He would seek dismissal of the petition. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The afore narrated facts linked in the chain of events are all a matter of record. An agreement of sale entered into in the month of June 2023 goes wrong, and the agreement our ಹೆಸರೇನು?
NP Manjunath. Deceased is Mahadev Swami.
The executant of the agreement, one Mahadev Swami, commits suicide on the score that the agreement had gone wrong. The blame is now laid at the doors of these petitioners who are said to have instigated the abetment of suicide. Since the entire issue triggered from the registration of the complaint, I deem it appropriate to notice the complaint. It reads as follows, page 22 to 24. The concerned court, the jurisdictional police conduct investigation and file a charge sheet against these petitioners and others for offences punishable under section 306, read with 34 of the IPC. Summary of the charge sheet as obtaining in column number 17 reads as follows. If the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is that the allegation against these petitioners for offence punishable under section 306 of the IPC is loosely laid against these petitioners. Loosely laid against the petitioners. For an offence to become punishable under section 306 of the IPC, what is necessary is the ingredients of abetment to be present. Abetment is defined under section 107 of the IPC. Section 107 of the IPC reads as follows. If the complaint and the summary of the charge sheet is juxtaposed and read, the ingredients of abetment are completely absent in the case at hand. The issue whether such acts would become abetment to suicide need not detain this court for long or delve deep into the matter. The apex court in plethora of judgments has considered the issue as to what would become an offence under section 306. 306, it would be only if the ingredients under section 107 of the IPC are present. The apex court in the case of 2024 SCC online SC page 3541 Kamaruddin versus State of Bihar. The apex court has held as follows. The apex court again in the cases of 2025 SCC online SC page 107 and 2025 SCC online SC page 120 has clearly held that the complaint should not be registered only for the purpose, only to assuage the family of the deceased. There should be some ingredient present in the ingredient for the offence under section 306 to be present in the complaints so registered. If the facts obtaining in the case at hand is considered on the elucidation of the apex court as quoted herein above, what would the unmistakable inference would be that the complaint and the complaint registered against the petitioners could not have been on the score that there was neither abetment nor goading nor proximity to the incident of suicide of the son-in-law of the complainant. The agreement that is entered into 2 months ago has become the instigation for suicide, and the blame is laid to the doors of the petitioner. This is sans countenance in the light of the judgments rendered by the apex court. Therefore, the petition deserves to succeed and the crime and the proceedings to be obliterated. For the aforesaid reasons, the following order allowed, quashed, the petitioners. Yes, next.
Great.
67.
Jagdish Ilva. All right.
Sorry, he's end up in some other
ಆಯ್ತು
court.
just take on the no representation on behalf of the petitioner. List the matter on 12th.
68.
Pay for the petitioner, my lord.
Promise?
68 serial number.
ಅದು ಗೊತ್ತು ಮ್ಯಾಟ್ರಿ.
My lord, 2B reports.
2-3?
No, 2B reports has been filed.
Oh, 2B reports.
Please, my lord, because he has taken the instruction.
All right.
Some
But
other
the
time,
land
my lord,
cons-
I'll pass over.
complainant yaru? Saruda?
Yes, my lord, it has been served.
The complainant is served and madam? 25/8/2025 but remains unrepresented. Therefore, to afford another opportunity, list the matter on 19th. Interim order subsisting will continue till the next date of hearing.
What's up, yes.
69.
For petitioner, my lord. For second respondent, my lord, matter is settled before the mediation center.
Settled, ah?
Settle agida.
Very good.
There is a submission. There is a submission.
Settlemental submission, na?
Oh. Your lordship may kindly see, the matter was settled on 29/4/2025. And there was a clause that the Madam, Lord, it's part of petition, my lord, section page 34.
ಅಲ್ಲ ಅದೇನೋ there was a clause ಅಂತ ಇದಾರಲ್ಲ ಅದೇನು ಅಂತ ಹೇಳಿಲ್ಲ.
He has
ಏನ್ clause?
He has to approach the Honorable High Court immediately after the mediation report, my lords. But after lapse of 3 months,
ಅಯ್ಯೋ ಅಷ್ಟೇನಾ?
approach. And one more thing.
ಇಲ್ಲಿ ಮ್ಯಾಟ್ರ್ ಲಿಸ್ಟ್ ಆಗಕ್ಕೆ 6 ತಿಂಗಳಾಗುತ್ತೆ ಸರ್.
ಅಲ್ಲ ಇದರಲ್ಲಿ the agreement is between the first petitioner and the second respondent. And your lordship may remember that the petitioner. There was a case before your lordship. And the serious allegations were there. Now, The second respondent and third respondent were not parties before the mediation center. They have to file an affidavit before this honorable court. They should not exhibit the videos which they have under the.
matter. Yes, sir.
And 5 lakhs due ಇದೆ. 5 lakhs due ಇರೋದು
ಮತ್ತೆ ಇವರು ಎಕ್ಸಿಬಿಟ್ ಮಾಡಿದಾರ ಆಮೇಲೆ
ಅಲ್ಲ ಈಗ ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಅಂಡ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಅಗ್ರಿಮೆಂಟ್ ಇರೋದು. Now the second and third respondent are also before this honorable court. Let them undertake before this honorable court that they will not exhibit any videos.
I will give an undertaking, my lord. I have.
Let them file an affidavit. And your lordship, there is 5 lakhs due is there.
5 lakhs ಕೊಡ್ಬೇಕಾ?
ಡಿಡಿ ಇಟ್ಕೊಂಡು 3 months ನಮಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ
3 months ಡಿಡಿ ಇಟ್ಕೊಂಡು ಓಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು.
The undertaking given before the mediation center was to give DD before this honorable court while questionment.
When they made misuse of the particular clause, immediately they have to file it. When they showed the DD was within 3 months, they have to give it and file it before the court.
Expire ಆಗಿದೆ DD?
DD expire ಆಗಲ್ಲ.
Revalidate ಮಾಡಿದ್ದೀರಾ?
It's not cancelled. Bank ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ
ವ್ಯಾಲಿಡಿಟಿ ನೋಡಿ ಎಷ್ಟಿದೆ?
3 months ಅಷ್ಟೇ.
Validity, there is no validity written on this.
Validity ilva?
I specifically checked with my client. He went and checked in the bank. Bank said until unless DD is cancelled, it will be honored. There is no problem.
According to my knowledge, my lord, it is only for a period of 3 months.
By my client.
It is only for 3 months. Let them file an affidavit to that effect as well as. And there was a delay of 5 lakhs 3 months.
ಅದು 5 lakhs ಒಂದ್ ನಿಮಿಷ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ. ಈಗ ಯಾರ್ಯಾರು
ಅವರು ಸಾಲ ಮಾಡಿ
ಅಯ್ಯೋ ಸರ್ ಈಗ which person has to file an affidavit ಹೇಳಿ first?
Second and third respondent.
R2 and R3.
R2 and R3 need to file affidavit.
Correct. ಈಗ settlement ಆಗಿರೋದು
between petitioner and first petitioner and second respondent.
R2, that is complainant.
Complainant, yes.
ನೀವು ಮತ್ತೆ ಎಕ್ಸಿಬಿಟ್ ಮಾಡಿಲ್ವಾ ವಿಡಿಯೋಸ್ ಏನು?
ಮಾಡಿಲ್ಲ.
ಇನ್ನಿಬ್ಬರದ್ದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಡಿ.
3 ಹಾಕ್ಬಿಡ್ಲಿ ಸರ್.
ಅವ್ರು ಹಾಕಿದಾರಲ್ಲ?
ಅಲ್ಲ ಇದು ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಆಗಿದೆ ಅದು.
ಅದನ್ನೇ ವಿಲ್ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಹಿಯರ್. ನಾಟ್ ಎ ಪ್ರಾಬ್ಲಮ್. ದಿ ಅದರ್ ಟು ಹಾಕ್ಬಿಡಿ. ಹಾಕ್ಬಿಟ್ಟು 5 lakhs ಡಿಡಿ ನಾಳೆ ರಿವ್ಯಾಲಿಡೇಟ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಅದೇನ್ ಕ್ಯಾನ್ಸಲ್ ಆದಗೋರ್ದು ಕ್ಯಾನ್ಸಲ್ ಅಲ್ವೇ ಅಲ್ಲ.
Please. Yes. I'll get it revalidated.
The petitioner is before this court seeking quashment of the proceedings on this score that the parties to the list have settled the dispute before the mediation. The learned counsel appearing for the respondent submits that the mediation was entered into in the month of April 2024 and the condition in mediation was that the respondent should stop exhibiting all or any of the videos concerning the two and has to pay rupees 5 lakhs. The petitioner is holding the demand draft with him and has not paid the respondent is the submission of the learned counsel for the respondent. In that light, the learned counsel would further submit that respondents 2 and 3 are also required to file an affidavit of undertaking that they would not exhibit the videos as is undertaken by the petitioner before the mediation. Counsel for the petitioner submits that if a week's time is granted, the mediation, the R2 and R3 also would file an affidavit of undertaking as is undertaken by the petitioner, and the demand draft would be revalidated and paid to the respondent on the next date. 12th Akla?
Day after tomorrow.
Day after tomorrow, I will not be in the station.
Why, sir?
ನಮ್ಮ brother-in-law expire ಆಗಿದ್ದಾರೆ.
Oh, sorry. Yes. Monday, 8.
And let them pay along with the interest, my lord, because she has borrowed money
I have
to perform their marriage.
Keeping quiet.
Still
My
she is
learned
paying.
friend is going on. Now I will have to make a certain.
You will have to go on now.
Now I will have to make a certain submissions.
Yes, sir.
Not in the good interest of bar, my lord. My lord, I specifically requested him.
Stop it.
There is delay of 3 months, my lord.
Parallel. Let bygones be bygones. Don't worry. List on day after tomorrow ಆಗಲ್ಲ 8
9 ಬೇಡ, ನೆಕ್ಸ್ಟ್ ಎನಿ ಅದರ್ ಡೇಟ್ ಅಥವಾ ನಾಳೆ.
List on 8.
ನಾಳೆ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ.
ನಾಳೆ ಆಗ್ಬೋದಾ?
My lord, at 2:30, my lord, because
tomorrow 2:30.
Revalidation may take.
ನಾಳೆ 2:30 ಮುಗಿಸ್ಬಿಡೋಣ.
Please.
Respond 2, madam. Respond 3 ಯಾರು? Counsel.
3.
Respond 2 ಮಾತ್ರ ಇದ್ದಾರೆ ಇಲ್ಲಿ.
Respondent 2.
Respond 2 is the complainant.
Complainant.
ಮತ್ತೆ R2 and R3 ಯಾರು? ಅಲ್ಲಿ ಇನ್ನಿಬ್ರು ಯಾರೋ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು ಅಂದ್ರಲ್ಲ.
Petitioner 2 and petitioner 3 need to file.
Petitioner 2 and 3.
Petitioner 2 and 3 need to file.
Petitioners 2 and 3. Jai.
70.
Petitioners, 498A. Why not
Husband?
4 finance? Husband,
Ah.
petition number 1. Father-in-law, mother-in-law and brothers.
ಏನಿದ?
Father-in-law.
Mother-in-law.
Mother-in-law and brothers and relatives of the.
Father-in-law, mother-in-law, other-in-law and husband. All right, yes.
Yes, my lords.
Complainant? First time ಬರ್ತಾ ಇರೋದು?
First time ಬರ್ತಾರೆ. ಮೊದಲು withdraw ಮಾಡಿದ್ವಿ. Second successive complaint.
Second successive complaint ಇರಲಿ.
ಅದು ಕೊಟ್ಟಿದ್ದು.
Come to page 47. The petitioners are, one ನಿಮಿಷ. The husband, ಇದು second petitioner ಯಾರು?
Mother-in-law.
Mill, third father-in-law.
Brother-in-law.
Third brother-in-law na?
Yes.
Accused number 3.
Accused number 3.
ಯಾಕೋ ಮಿಸ್ ಆಗ್ತಾ ಇದೆ ನೋಡಿ.
No, no. Mother-in-law.
ಹಾ.
Husband.
Husband 1.
2 mother-in-law.
ಹಾ.
3 father-in-law.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
4 and
3
5
Phil. 4
and 5 brother-in-laws.
Bill. 6 and 7.
Relatives.
Distant relatives.
Distant.
6, 7 and 8. The petitioners accused 1 to 8 are before this court, calling in question proceedings in CC
27913 of
27913 of 2024, registered for offences punishable under section 498A, 504 and 506 of the IPC.
34.
And read with 34. Adille crime iralla, but read with 34 of the IPC. The allegations against the petitioners on investigation leads to filing of the charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. A perusal at the summary of the charge sheet would clearly indicate that the allegations against all, including the husband, are all omnibus. There is no indication, even there is no indication in the complaint or in the summary of the charge sheet with regard to independent overt acts committed by the petitioners over the complainant. The petitioners, the allegations does not stop at only the members of the family, but even distant relatives who have nothing to do with the petitioners. In that light, further proceedings are required to be stayed, in failing which it would run foul of the judgment of the apex court in the case of Achin Gupta versus so and so 2024 SSC online SC page 759 insofar as the husband is concerned, and 2024 SSC online SC page 3473 insofar as the other members of the family are concerned. Additional SPP B and Jagdish is directed to accept notice for the respondent, the emergent notice to the second respondent complainant returnable by the 26th of September. Yes, next.
71.
I appear for petitioner Waqf matter, my lord. That section 56, the grant approval of lease by the
Yes, sir.
state government. 53.47 lakh revenue loss again.
53.47
crores, sorry. 53.47 crores revenue loss because of the application filed by the respondent number 1 and 2.
Why that such an expensive application?
Without locus standi.
Peter Blood, unfortunately.
You are caught in the crossfire.
Caught in the. And blood at the instance of a complete stranger, blood who has nothing to do with this.
Yaar yura?
That is answered by the tribunal, my lord.
Complete stranger.
That is what they claim.
They are not bidders, they are not participants, they did not make any application for a grant of lease.
My lord, this matter.
They have no
Yen,
locus
your
standi.
Mutawalina?
My lord, covered
Illa.
by your lordship's judgment. My
Strangers.
lord.
Why?
My lord, the only question is whether the administrator appointed the board, my lord, whether he has a power to
Alla,
sanction.
again, why are you before CRP ಯಾಕೆ?
ಇದು CRP ನೇ ಆಗುತ್ತೆ. 83 two petition they had filed before Waqf tribunal. Section
Oh, Waqf
83.
tribunal ಮೇಲೆ.
Therefore, section 83(9) ನಲ್ಲಿ CRP.
It's revisable order, yes.
Yes. May I make submission?
ಹಾ.
My lord,
ತುಂಬಾ ಹೊತ್ತಾಗತ್ತಾ?
ಇಲ್ಲ, just only few points.
ನಾನು ಪಾಯಿಂಟ್ಸ್ ಕೇಳಲಿಲ್ಲ, ಟೈಮು.
Time 3-4 minutes, not more.
3-4 minutes. ಸ್ಟಾರ್ಟ್ ಸರ್, ಎಸ್.
My lord, ink page annexure E for a.
ಅಲ್ಲ 53 ಕೋಟಿ ಲಾಸ್ಗೆ ಬರೀ 3 ನಿಮಿಷನಾ?
ಇಲ್ಲ, ಇದು ಒಂದೇ ಆರ್ಡರ್, ಅದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್. My lord, under section 56 of the Waqf Act 1995, read with Waqf Amendment 2013. It is the state government who is empowered to approve the lease in respect of the for 30 years period. So there was an publication for grant of lease of the land belonging to the petitioner work. 5 bidders came forward. Among them, the 6th respondent was the highest bidder. The government approved sanctioned the lease. As against that order, my lord, they went before tribunal and they started the proceeding saying that the order passed.
So the lease itself is without authority.
Authority and but section 56 is very clear. If your lordship permits, may I read?
That was the only ground?
That is the only ground. And second.
But one ನಿಮಿಷ, ನೀವು ಯಾರು?
My lord, I am, my lord, the person who is beneficiaries of the trust, my lord, the WAF petitioner number 2. I have, my lord, in 83, any interested person in the WAF which is defined under the act, my lord, can file an application, my lord. That has been answered by the tribunal. And also, my lord, this high court, my lord, in various judgments held that I have a locus standi, my lord, whoever is an interested party, and that is precisely answered.
So ಅದು locus ದಾಯ್ತು.
Locus, my lord.
Lease.
Lease, my lord, under section 32. What is the tribunal said, my lord? It is the power of the tribunal. 2/3 majority ಬೇಕು to sanction 30 years lease. That has been done by the administrator appointed. And the administrator is only appointed to look into day-to-day affairs of the world. Precisely, my lord.
Oh, administrator has entered into a lease.
Entered into, my lord, that, and he acts as a head of the department, my lord. ಅವರೇ sanction ಕೊಡೋದು, government ಗೆ approval ಅವರೇ ಕೊಡೋದು. That is, I can point out all those documents are produced.
The board term had come to an end. The state government, as a stopgap arrangement, appointed the administrator. All functions of the board, the administrator have to be done under section 99, subsection 2.
I'll also go through the papers tomorrow at 2:30.
May I make one submission, my lord? One further submission in respect of interested person. I have done some homework. If your lordship.
Homework? You want me to do that homework?
No. I just for the kind perusal.
Go through the homework.
Copy ತಗೊಳ್ಳಿ. Who is a person interested as per section 3K of the Waqf Act? It is not his pleading that he is an interested person.
Raghavan sir, ನಿಮ್ದೇನಿಲ್ಲಲ್ಲ?
There is not a single.
If the crossfire is doused, then you will spring into action.
In fact, my lord, now the board is there. They can go
Whole
before the
process
board.
was taken. Public notice, bidders, I have made a deposit also. And then, my lord, a third party, in fact, I may just point out, in his whole petition, there is not a single government that is interested in the Waqf. Not a single. Not a single the petition which he filed.
Paragraph.
Not a single government. that
ಇದು
is
22 ಇಂದ ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಮತ್ತೆ?
ಇದು
ಅಲ್ಲ ನೀವು
ಅವರು ಪ್ರಾಸೆಸ್ ಅವಾಯ್ಡ್ ಮಾಡ್ತಾ ಇದ್ರು. ಏನಾಗಿದೆ, the first respondent, which is a self-styled body treating itself as a Waqf Protection Joint Action Committee, the person who filed the petition, he died. Thereafter, my lord, for taking steps and for the process, the time went on.
ಆಯ್ತು ಸರ್, ನಾಳೆ
2 applicants, my lord.
And
I am appearing for
we
one
have
application.
lost 53.47.
ಅದು ಹೇಳಿದ್ರಿ ಫಸ್ಟ್ ಹೇಳಿ.
Para number 22, your lordship may, paragraph number 22 of my CRP papers, I have answered to the question what my learned friend is raising.
We'll see, yes. Tomorrow 2:30.
Please, my lord.
Day after tomorrow.
ಅಲ್ಲ, ನಾಳೆ ಮುಗಿಸ್ಬೇಡ. ರೆಂಟ್ ರೆವೆನ್ಯೂ ಲಾಸ್ ಆಗ್ತಾ ಇದೆ ನಮ್ಗೆ.
ಅವರು ಡೇ ಟು ಡೇ ಅಂತ.
ಆಮೇಲೆ ವಕ್ಫ್ ಬೋರ್ಡಿಗೆ
ಬೋರ್ಡಿಗೆ ಹೋದ್ರೆ ಇಷ್ಟರಲ್ಲಿ ಜಾಸ್ತಿ ಬರುತ್ತೆ.
10%
ಬೋರ್ಡ್ ಇತ್ತು 2020 ಇಂದ ಬೋರ್ಡ್ ಇದೆ.
7% ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಟು ದಿ ವಕ್ಫ್ ಬೋರ್ಡ್ 1.7 crore ಲಾಸ್ ಆಗಿದೆ. ನಮ್ಗೆ 54.43 crores ಲಾಸ್ ಆಗಿದೆ.
ಈ ರಾಘವನ್ ಸರ್ಗೆ ಎಷ್ಟಾಗಿದೆ?
ಅದೇ ಅವ್ರ ಕಡೆಯಿಂದ ನಮ್ಗೆ ಅವ್ರು ಕೊಡ್ಬೇಕಾಗಿತ್ತು ದುಡ್ಡು, ನಮ್ಗೆ ಬರ್ತಾ ಈಗ.
All right, tomorrow we'll see.
Please,
If you have any difficulty, you tell tomorrow.
Much obliged.
Tomorrow at 2:30. Yes. Next.
72.
The petitioner must suit for partition order 7 rule 11A.
Partition Suit 7 rule 11.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, earlier this they have challenged the will which was earlier decided by this court as well as
RFA.
apex court.
ಹಾ,
Apex court allೂ ಇತ್ಯರ್ಥ ಆಗಿದೆ ಅದು. ಆ will
ನೀವು ಇದ್ದೀರಾ ಇದರಲ್ಲಿ? That will continues. ನೀವು ಓಡ್ ಬಂದಿದ್ ನೋಡಿದ್ರೆ ಇದರಲ್ಲಿ ಎಷ್ಟು ಲಾಸ್ ಆಗಿದೆಯೋ ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ. Yes.
This will, which is challenged in the present suit, was earlier tried in earlier suit and it was held in the affirmative in favor of the defendant, right from this court up to the apex court.
Correct, sir. 1991 suit.
1990,
OS 877 of 91.
91.
Ah.
And once again, they have agitated the very same will in this suit also.
What was that suit for?
That suit was for partition and separate position.
What happened to that?
That suit was dismissed in respect of the will, holding that it is the exclusive property of Narsimaya, my father.
Self-acquired property.
Self-acquired property.
So that property is now put to partition here.
That property is put to partition once again.
Heard the learned counsel appearing for the petitioner. The petitioners are defendants 2A to E. Are before this court calling in question an order dated 21st September 2024 rejecting an application Order 7 Rule 11A and D of the CPC. The learned counsel appearing for the petitioner submits that the plaintiffs or the predecessors in title had instituted suit for partition in OS 877 of 1991. The said suit comes to be rejected, holding that the properties, the suit schedule property was the self-acquired property of one Narsimaya. The said finding goes up to the apex court only to be affirmed. Long after suffering an order, the legal heirs matrada.
Legal heirs of.
The legal heirs of the earlier plaintiff have instituted the suit again in OS 844 of 2018. The petitioner, after issuance of notice and appearance, had filed the application. In the light of the aforesaid facts, the further proceedings before the concerned court shall remain stayed. Yes, next. In the light of the aforesaid reasons.
73.
The petitioner, I'm representing the petitioner. Since
Party in person.
3-4 times, the court has directed the office to show my name.
ಮತ್ತೆ ತೋರಿಸಿಲ್ವಾ?
It is missing. Therefore.
ಅಲ್ಲೇನಾಗಿದೆ ಅವಾಗ ಅವ್ರ ಹೆಸರೇನು ಹೇಳಿದ್ದಾನೆ ಕೇಶವ ಅಗ್ನಿಹೋತ್ರಿ ಅಂತ.
ಹೌದು, ಅವ್ರ ಹೆಸರು ಅದೇನೆ.
ಬೇರೆ ಅವ್ರು ಬೇರೆ ಕಡೆ ಬೇರೆ ತೋರಿಸ್ತಾ ಇದೆ ಅವ್ರ ಹೆಸರು.
ಬೇರೆ ಹೆಸರು ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ತಿರುಮುರಿ ಹೆಸರಿನಲ್ಲಿ.
ಇಲ್ಲ.
Because it shows something else.
No, I have filed the.
The registry is directed to print the name of Keshav R. Agnihotri as appearing for the petitioner who is said to have entered appearance. The matter is coming up for the third time, and all the 3 times, the learned counsel for the petitioner submits that he has entered appearance and his name is not being shown. Therefore, the office is directed to explain as to why the name of the petitioner in person appears despite the matter appearing thrice and a direction being issued to show the name of the petitioner. List the matter. Any the matter. ಏನಿಲ್ವಾ?
ಅಲ್ಲ ಎಜೆಕ್ಟ್ಮೆಂಟ್
ನಿಮ್ಗೇನಿಲ್ವಾ ಅವ್ರಿಗೇನಿಲ್ವಾ?
ಅವ್ರಿಗೂ ಏನಿಲ್ಲ. ಎಜೆಕ್ಟ್ಮೆಂಟ್ ಸೂಟ್ನಲ್ಲಿ ಡೆಲಿವರ್ಡ್ ದಿ ಪೊಸಿಷನ್ ಆನ್.
ಈಗ ಮನಿ ರಿಕವರಿನಾ?
ಮನಿ ಅದರಲ್ಲಿ 23,000 ರೂಪಾಯಿ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಇದೆ. ಅದನ್ನ ಕೊಡ್ಲಿಕ್ಕೋಸ್ಕರ ಸ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅರಿಯರ್ಸ್ ಇಸ್ ದೇರ್ ಅಪ್ ಟು 1,75,000.
23,000 ಕೊಡ್ಬೇಕಾ ಈಗ?
23,000 ಟಿಲ್ ದಿ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ದಿಸ್ ಸೂಟ್.
ಆಯ್ತು, ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Next date.
The learned counsel appearing for the respondent submits that the arrears in due is 23,000, to which the learned counsel of the petitioner would submit. He would seek instructions and clear the arrears by the next date. List the matter on 12th.
By next month, because he is in difficulty.
Next month, October, sir. ಇವತ್ತು ಸೆಪ್ಟೆಂಬರ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Because he is in.
List the matter on 22nd September.
Please, no, stay maybe.
Interim order subsisting will continue till the next date of hearing.
24 dispose, 74 dispose, 75.
For petitioner, my lord. The application filed by the defendants petitioner only partly allowed, my lord.
711 na?
711, A and D. Kindly page number 19, operative portion.
Coffee powder.
Please. My lord, suit for damages, 50 lakhs.
ಅದ್ರಲ್ಲಿ ಪಾರ್ಷಲ್ ಏನೇ ಅಲೋ ಆಗದು.
Suit is returned with jurisdictional court, but cause of action in the year 2014.
Notice.
Please.
Next.
26.
So on the last date, my lords referred to my lord's judgment passed on 5th of August. In fact, that judgment supports my case.
What judgment, sir?
Because there was a judgment passed on defamation as to where the defamation actually occurs.
It supports your cases.
In fact, yes,
Very good. Yes.
there are certain, may I kindly come to page 33 for a moment.
Oh, CRP was directed to be filed. Ada idu?
Yes, Milos. So,
Yes. Manu?
page 33, Milos, may kindly see. Milos, the distinguishing feature, Milos, in this case is that copies were marked to all whom.
That's
holding
exactly what I
offices.
asked on the last occasion.
In our case, Milos, no copy was marked. And
This
Milos,
is that
kindly see page
United
34.
States.
Please.
Ah.
United States, page 34, the only email is an internal email between the parent company and themselves, Milos. So nothing happened in Bangalore, Milos. And in fact, Milos, may kindly come to their plaint para 8, categorical admission to the effect, Milos. It says, however, on 9th of November 23, the plaintiffs were shocked to learn from the parent entity, Array US, that defendant number 1 has been issuing emails to Array US and various third parties such as such and such, making absolutely false. So they themselves say that it has been issued in other jurisdiction. And the judgments referred to by my lords in the judgment which I have just handed over, all of them says that the defamation has to happen when a third party receives it. So there's no third party in Bengaluru happened, was nothing.
My lord, your lordship's decision, my lords, as I see it, has two parts. One is where it is received. Two is where is a company defamed. My registered office is here. I have pleaded in my plaint that I have been defamed here. My business is here. I have received phone calls here. Therefore, my lords, it's on the second part that the suit will lie here. Your lordship may just see two paragraphs of my plaint, para 33 at page 39. This honorable court has necessary territorial jurisdiction under 19 of CPC as plaintiff number 1 received the email dated so and so at its registered office and became aware of the defamatory statements made by defendant number 1. The plaintiff has also received several phone calls and inquiries from customers, vendors and third parties regarding the defamatory statements made against it at its registered office.
How do you substantiate that? All parent company bitter nimag gottittu. How did everybody come to know defamatory?
My learned friend has not produced those emails. They are not just written to the parent company. They are written to all and sundry.
Ashte kelid nan. Whether it is to all and sundry or.
It is, my lords.
May also come to para
1
32.
minute. Let me finish. He is the plaintiff.
Yes.
The email, my lords, this is a part of the plaint papers. The email starts at page 2. The first email on top is what was sent by my parent to me. The email in the second half is what was sent by one Siddharth Chu. He is the petitioner defendant. He sent it. Your lordship may kindly see who all he has sent it to.
Seen Fang, so and so, so
That
and
is
so.
part of my parent. Then your lordship may see, my lords, from the second line onwards. In the second line there, some Lisa Lau at kpmg.com.taiwan.
BB Thomas, KPMG.
KPMG, Deloitte. They have sent it to all auditors.
Yes, none of them in Bangalore.
They may not be in Bangalore. I don't know where they are, but my lords, my case is, and I've pleaded this in para 23 also of the plaint, that because of this today there are rumors in the market here that I am involved in some international fraud, and the allegations are fairly grave. Page 3 in bold, my lords, 4th paragraph from top, 3rd paragraph from top, the second plaintiff is named. 3rd paragraph from top, considering the above, is further evident that CEO Mr. So and so are hands in glove with Manish Kumar Gautam, Shibu Paul. Shibu Paul is the second plaintiff. So he is repeatedly personally named in this email. Then your lordship may kindly see the next paragraph in bold. Your email under reply has left me with no other alternative but to write and take this matter forward to federal investigating agencies, economic, etc. Last 4 lines may be seen, my lords. Service tax in India and numerous other authorities to investigate how Array Networks Incorporated and Array Networks India Private Limited, in connivance with each other, have perpetuated several large-scale financial frauds in multiple jurisdictions by systematically, willfully cooking of books of account, inflating sales, threatening people, cheating with thousands of shareholders, etc.
That's the email.
This is the email. It is sent, my lords, to various auditors, KPMG and Deloitte.
Yes, they have not shown any single person receiving any mail in Bengaluru. One. The judgments my lords have relied upon, whether it's Indian Potash, even if it is Escort.
There is one judgment which I did not rely in that.
Please, Milos.
The Delhi High Court says that anywhere it can be filed.
In that case, what Delhi High Court actually says is
No, I have not relied on
Deepak
that.
Kumar's case. My lords are correct. So in Deepak Kumar, it says only where the third party receives. And in this case, what has happened, every single email what he is referring to is only either in US or in Taiwan, not in India at all. I am making a categorical statement here.
So what?
So as far as Bengaluru is concerned, it doesn't get jurisdiction because
His company is here.
the company only be this is under section 20 only because he has a company.
No, that is the judgment I've rendered is under 19.
Correct, and 19 refers to where there is damages. In this case, there is no prayer for damages at all. No prayer for compensation. So 19 will not apply. It is only section 20 that will apply.
Lords, there is a decision of this honorable court where this honorable court considered the relationship inter se between 19 and 20, and this honorable court says, my lords, that section 19, which incorporates, as your lordship has held, the effect doctrine, is really nothing but 20 subclause C. That is, my lords, the third decision.
Gokul Das.
Please, my lords. Gokul Das. In that, the two specific sentences, my lords, are para 8. Please. Only one last thing, my lords. In the memo that I have placed, in the email at page 35, he says, I will now go to the media. He explicitly says so. Therefore, my lords, if there is a reputational damage, it will happen to me here. He says, I'll go to the media. That's why, my lords.
So whatever he is arguing.
You're a company in the United States, is it?
They have the company in the United
No,
States.
you.
I'm in Delhi,
Delhi.
I'm only in Delhi. No, may kindly see para 8 of their own plaint. What is he arguing is completely contrary to para 8 itself. Para 8 in the plaint says that all these emails were sent to KPMG, Deloitte and government authorities in other jurisdiction, not in Bengaluru.
Difficult.
May kindly appreciate. Let me just show the judgments, whatever my lords have referred to.
Escorts.
Even escorts, my lords, even Indian Potash, all of them say the defamation, it is not the plaintiff, it is where the defendant, it is either where the defendant or where the defamation occurs. It is their own admission at para 8 that defamation occurs in US or in Taiwan, not in Bengaluru. May kindly come to my lord's judgment.
No, is it not that the email is communicated to all and sundry?
No, my lords. It was not sent.
Who are those from KPMG then?
Because the persons in KPMG were the auditors of the parent company situated in Taiwan and US, not in India. Not even a single person in India, not even a single email says it was registered. It was marked to anybody in India. In fact, their plaint itself says so.
So he has to institute a suit for libel in US.
Because that is, of course, in case whatever the law is, the law has to be abided. He cannot just simply take a benefit of that he has to go to US or anywhere
Libel
else.
there, slander here.
And the judgment passed by the lower court says that because the plaintiff number 2 is residing here. That is not even a pleading. That has not even been pleaded, my lords. Now, may kindly come to my lord's own judgment. May I just refer to a few
My judgment, one in my judgment.
My lord's judgment.
Yes.
My lords have referred to a few minutes, paragraphs of the other judgments. For example, Indian Potash.
Yes, Indian Potash and escorts both.
Indian Potash. May I just read the?
I did not refer to Deepak Kumar. It was not necessary there.
Deepak
Kumar straight away says anywhere you can file it.
No, I'll show Deepak Kumar's judgment also. May kindly permit me. May kindly see para 7.
Deepak Kumar is also by Delhi High Court.
That is also Delhi High Court. Indian Potash is Delhi High Court, as well as escorts.
Yes.
The Indian Potash says the publication. I'm reading only the relevant portion. The publication of defamatory material against a person gives rise to a cause of action only when it is made known to the third party. the place of the third party and the place where it is known to a third party gains importance. The plaintiff may be living at any place. Now, Mlos, may kindly come to escort's judgment. Running page 24, Mlos, it says, wrong to the person of the plaintiff by libel would be done not by mechanical act of tweeting by the defendant of the content defamatory to the plaintiff, but by communication thereof to at least one person other than the plaintiff or the defendant, and knowing the plaintiff and in whose esteem the plaintiff would fall by reading the defamatory tweets. Wrong would be done only at the place where the said tweets are accessed and read by someone other than the plaintiff. So here's a case where the plaintiff, apart from plaintiff, the internal mail comes to plaintiff. Nobody else gets this emails. That email has been internal mail that the plaintiff circulate. And now the most important part, what the plaintiff says that the customers have read this. The email is dated 9th November 23. 9th November 23.
That's your defense.
No, not only defense.
That's your defense.
Not only defense.
What else? Beyond defense?
9th November 23 email received at 8:47 p.m. in the night. They filed the suit on the next day morning. Where is the question of anybody else getting anything?
Now, 711 is rejected.
There is no pleading for the same.
710 rejection.
710. There is no pleading for the same. Not even a single pleading as to who are the persons. My lords have already also passed judgment to the effect stating that it is only in case if they have to say that other persons also received email in particular jurisdiction, they have to say it in so many words. They have to name the person, they have to give the details. None of them are there. None of them are present. On the contrary, at para 8 of their own pleading, plaintiff, they say to the contrary. They say it was received in some other jurisdiction, not in Bengaluru. So, as per the judgments my lords have relied upon in other cases, none of them, all of them applies in my favor, saying that the Bengaluru court will not have jurisdiction.
It has to be presented where?
It has to be presented as per Indian Potash and as per escorts. My lord have already relied on those judgments on 5th of August. As per them, my lord, it has to be filed at a place where the email has been read by a third party. My email being read by a third party.
Email here is read by a third party in United States.
Wherever, but not Bengaluru. Of course, not Bengaluru, because email were never sent to anybody in Bengaluru. Not even read by even a single person in Bengaluru.
We'll answer it. Yes.
Only one fact that my learned friend says not correct is the original email was sent on 13th of October. I started receiving calls saying, hey, what is this? Some rumors are going on. I asked.
None of them pleaded. I'm sorry. None of them pleaded.
My parents sends it to me on 9th of November and I pleaded this in para 23. So it's not as if 9th of November was the original defamatory email. Original defamatory email is of October. I got it on 9th November. I filed my suit on 10th.
So he has to show that any of the
plaint averments.
Yes. Even of the plaint averments, I agree. Plaint averments has to be read. He has to show that there in the plaint he has mentioned that even a single.
He will demonstrate in evidence.
Not about evidence. At 710, the plaint has to be read. My lord,
plaint has to be read. Nothing.
Plaint has to be read, but in the plaint he mentions to the contrary. He says it was read in the other jurisdiction, not in Bengaluru.
We'll see. Yes.
So not even a single mail. He has to show which mail is he referring to that was sent to anybody in Bengaluru.
All right. Heard reserved. Yes.
Great. My lord, please.
Great.
Dispose 78.
Lord, I appear for the petitioner. My lord, I am defendant number 1 before the trial court, my lord. My limited
suit for?
My lord, it was a suit for permanent injunction filed by the plaintiff, seeking for
711 rejected.
No, my lord. This is with respect to suit is disposed, my lord.
Disposed by?
Suit is dismissed.
Dismissed.
Please, my lord. There is a finding, my lord, with respect to issue number 1, which is against me. Limited to that aspect, my lord, I filed the present civil division petition.
Issue number 1 is cause of action?
No, my lord. It is with respect to I set up a will, my lord. 2 wills are set up, my lord. 1 is by me.
Anyway, suit is dismissed. You serve on the respondent.
Please.
The petitioner to serve on. Alle notice agilva? Al notice agitta? Petitioner to serve on the counsel who represents the represented the respondent in the trial proceedings. Put up immediately after service of notice. Next.
Great.
79.
Revision petitioner, my lord.
RP.
Revision petition.
ಅದೇ RP.
ಇದರಲ್ಲಿ objections ಹಾಕಿದೆ,
It's a special
delay
order.
condemnation ಆಗಿದೆ ಸ್ವಾಮಿ.
Review ಏನು?
Review, the order passed by this honorable court was allowed by
Senior
misrepresentation of facts. Therefore, the pendency of title suit itself was not brought before the court. And when the proceedings under section 30, my lord, and land tribunal is still pending, under 18, they have already taken the amount and gone 1.9 crores. So therefore.
Compensation.
Therefore, I prayed before this court and I had to come in the form of this revision petition. And delay has been condoned, my lord. There was a direction to donate the books.
Donate the books,
for delay condonation. Adagide.
Not my order.
No.
It's a special order matter, my lordship. Earlier.
List the matter on 19th. Interim order subsisting will continue to the next. Yes, next.
80 and 81 appearing for petitioners in both 80 and 81.
My lords. I appear for the respondent, my lords.
80 and 81. ಏನು?
My lords,
ಅದು ನಿಮಗೆ
this is
ಗೊತ್ತು,
the
ಅದೇ
PG
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ ಅಂತ. 230 ಮೂಡ್ ಬಂದಿದೆಯಾ? 230 ಮೂಡ್ ಮ್ಯಾಟರ್ ತಗೊಂಡ್ಬಿಟ್ಟ ಆಮೇಲೆ.
Seeking time.
My lords, we have to file our objections. This is that PG-CET matter, my lords.
CET matter.
Please, my lords.
PGET
PGET matter. In fact, the
Doctors,
lordships had dismissed
entrance
all of
exam.
the petitions which was filed by the other accused, my lords. Idu co-accused they have filed now, challenging the very same order.
Hence the dismissal of discharge.
Discharge permit.
RGHUS to, in fact, your lordships have passed an order on that.
RGHS, PGET.
Oh, PGET scam, yes.
Malpractice.
Alleged. Malpractice.
Malpractice.
Why are you back here?
Alla,
First
these
time.
accused have not.
Oh, ಇವ್ರು ಹಾಕಿರ್ಲಿಲ್ವಾ?
Against discharge, dismissal of discharge.
Then objections ಬೇಕಾಗುತ್ತೆ. Like how Prasanna Kumar had prepared chart
Please,
of these, ಇವ್ರ ಮೇಲೆ ಏನಿದೆ, facts ಏನಿದೆ. In those cases, he had done it. ಅದನ್ನ as you should do that and get back. The learned counsel appearing for the respondent seeks 2 weeks time to file statement of objections or written submissions as the case would be. List on 19th. Both 80, 81.
30 more matters. Orders.
In terms of learned counsel of the petitioner has moved the matter seeking to withdraw the petition in the light of the said submission. The petition is disposed as withdrawn.
Seal number 2, KBS Manian.
Who may not appearing for petitioner in the writ petition and respondent in CRP. He is Boring Institute. matter.
Respondent in writ petition and ಅವರೆಲ್ಲಿದ್ದಾರೆ? ಇದ್ಯಾಕೆ ಮೂವ್ ಮಾಡಲಿಲ್ಲ? ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲಿಲ್ವಾ?
ಮೂವ್ ಮಾಡಿದ್ವಿ, ಏನು ಅಂತ ಇನ್ಕ್ಲಿನೇಷನ್ ತೋರಿಸ್ಲಿ. ಒಳ್ಳೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದಿದ್ದಾರೆ ಅಂತ ಕೂಡ ನೋಡ್ಲಿಲ್ಲ. Painfully I came out that day.
ಆಯ್ತು ಸರಿ. ಎಸ್ ಮಣಿಯನ್ ಸರ್. ಟುಮಾರೋ ಬೇಕಾ? ಯಾಕೆ?
We were served with something this afternoon.
Then don't take any steps till tomorrow.
Tomorrow morning.
What happened to that, you said meeting?
General body.
General body.
They have taken general body.
General body meeting was held yesterday, my lord. I was not been informed of it. It appears that the resolution carried. Today, this afternoon, they filed an application. They seem to know more about it. They have asserted many factual things. I need only this evening to consult and get back to the court tomorrow.
We'll take it tomorrow, not a problem. But
absolutely,
don't precipitate
until
with regard
tomorrow.
to the resolution of the general body till
Absolutely.
tomorrow.
It only happened yesterday. Even I'm not informed. Nothing will happen until tomorrow. And I'm with the court on that, and I will not allow it to be precipitated by tomorrow.
His submission may kindly be recorded.
Tomorrow.
Gentleman's submission, compliment him. Say it as a gentleman's
No, if it is gentleman's submission, it need not be recorded.
Yes, I stand by it, and I hope my client stands by me. Right. I'll ensure that.
Yes, Manian sir. We'll take it tomorrow.
Please.
But don't precipitate.
Absolutely.
Yes.
Absolutely.
Then don't come and
If
say,
anything were to happen, I will be the first to submit.
yes.
That didn't
And
get
don't,
resolved
and
over.
tomorrow it should not be
My
submitted.
assurance to the court
Yes,
that anything goes wrong there, I will ensure that it's reversed.
yes.
I'm grateful.
No problem.
Can I,
So it should not be told that it has become fait accompli tomorrow.
No,
That's
not
what
at all, my lord. I
Can
think
I
my lord's
file an
powers are wide and
Yeah,
large.
of course, yes.
permit me to file an application
ಏನದು?
saying that, my lord, we.
Oh, that's what he was telling. They appear to be no.
This afternoon, a lot of factual amendments have been made. I'll just reply formally for that.
Yes.
Further proceedings.
Learned
pursuant-
Senior Counsel seeks to file an application, bringing certain facts to the notice of the court. List tomorrow. Same is taken on record. List tomorrow.
Tomorrow in which category?
Preliminary hearing tomorrow.
Great.
As an interim order in the connected matter to tomorrow.
Interim order, any of these cases subsisting will continue to the next year.
Bill number 3, Sri Ram.
Shri Rama. Pending matter. In terms of memo idea, learned counsel with the petitioners moved first ಹೇಳಿದ್ನಲ್ಲ same. Next. Who is MD Madhukar?
4,
Madhukar.
Petitioner, my lords.
ನೀವು MD Madhukar ರಾ?
Please, my lords. I'm his junior, my lords. Yes, IPF for Madhukar.
Move ಮಾಡಿದ್ದೀರಾ?
Please, my lords, I moved the matter.
Withdraw ಮಾಡ್ತಿದ್ದೀರಾ?
No, my lords.
But why did you move the matter?
It is a fresh matter, my lords.
So argue.
It is a suit for eviction, my lords. I am the defendant before the trial court. My lords, the respondent claimed that they are the owners of the social property, and my lords, they're and as per oral agreement, my lords, they've leased out the social property in the year 2012, my lords. And thereafter, my lords, they've filed a suit for eviction, and suit was allowed, my lords. So thereafter, my lords, we have filed a regular appeal. And thereafter, my lords, we have specifically in the regular appeal, my lords, we have filed an application.
Now thereafter, what should be done ಹೇಳಿ?
Now, my lords, regular appeal is dismissed, my lords. On 1/7/2025, my lords, the regular appeal is dismissed. And thereafter, my lords, the decree holders have initiated execution proceedings, and they have, my lords, without giving any chance
Petitioner
of
to
hearing, my
serve
lords,
on the counsel who
now,
represents
my
the
lords, the
respondent.
delivery warrant has been
Wait,
issued.
sir.
Please.
The petitioner, ನೀವು ಓದ್ಕೊಂಬಂದಿದ್ದೆಲ್ಲ ಹೇಳ್ಬಿಡ್ಬೇಕು ಅಂತ ಸ್ವಲ್ಪ
ಇಲ್ಲ, please,
ಮಧ್ಯದಲ್ಲಿ ಪಾಸ್ ಕೊಡಿ.
Yes,
Yes. A petitioner to serve on the counsel who represents the respondents in the trial proceedings and file an acknowledgement of such service by the 8th of September. List the matter on 15th September. Further proceedings before the executing court in execution 144 of 2024 shall remain stayed till the next date.
Grateful.
Yes. Next.
5, Shri Manjunath.
Okay, for the petitioner in this case, my lord, the instant petition for quashing up the impugn order dated 14/8/2025, wherein, my lord, my application for recalling and reopening up the further
Application for
recall and reopen, my lord.
1817.
Please, my lord, issue number 3.
Suit is of 2012, sir. When did you file the application?
My lord, I have filed the application on 26/8, my lord.
26/8.
Please, my lord,
Day
sorry.
before yesterday.
No, my lord,
ಅವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಲ್ಲಿಂದಾನೆ. ಅವ್ರು ಯಾರು ಗೊತ್ತಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ sir.
ನನಗೂ ಗೊತ್ತಿಲ್ಲ, ಹೇಳಿ. ಎಸ್.
No, my lord, the issue number 2 is on me in order to prove that whether I have derived the property by virtue of registered will. My lord, I have 23/7/2025 trial was closed, my lord. Immediately 6 days after, I have filed an application requesting the court that I'm a senior citizen, I could not be produced that original Xerox copy. However, Xerox copy of the same has been produced before the honorable court. Suit for declaration and permanent injunction as against the respondents.
ಆಯ್ತು, one opportunity will grant.
Please.
But ಅವ್ರು ಬರ್ಲಿ.
Lord, what happened, my lord? The direction has been given by this honorable court in order to complete the
Page. No, you appear to have taken so many adjournments, sir.
No,
ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ತುಂಬಾ ಇದೆ.
no, it is from last 2012. Lord, Annex 252, page number 254.
Respondent ಯಾರು? Contesting respondent ಯಾರು?
Lord, respondent number 1 to 18. 1 to 17 are the dependents before the honorable court, and respondent 18 to 23 are the plaintiffs.
Serve on the counsel.
I'll serve.
Petitioner to serve, next date ಏನು?
Lord, 4/9. And today I have filed an application for adjournment that was rejected and
Correctly rejected. Yes, because I'll reject the petition also next time.
one opportunity may be given only for the purpose of marking up the original bill.
Correct, sir. Yes. List the matter on third in preliminary hearing. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such, file acknowledgement, serve so and so, day after tomorrow. Fourth and third preliminary hearing.
Please.
Preliminary hearing, still number 6. P.N. Rajeshwara.
Petitioner, my lords. Clubbing application is allowed without considering my objections. Suit for one is suit for declaration and based on confirmation deed. The present suit is for partition among the family members. The brother-in-law sets up his brother-in-law to file this present.
Brother-in-law, brother-in-law.
Our henty ganda tammandru.
Sets up brother-in-law. Other-in-law
Other-in-law.
Yes.
Now their suit is clubbed with this suit and the delay is there.
Delay ashtena.
Suit is for declaration and.
My suit is for partition, my lords. It is the same schedule property.
Partition and injunction,
Partition and declaration suit.
Declaration on the basis of a confirmation deed executed by a
their
third
case,
person. No, man, it's not like that. Kindly see, my lords.
Let it not be clubbed, but jote agli.
It's between the same court.
Onde nimisham.
The
May I
same
make one submission? Synopsis at page number 3, may kindly see. Third point, the second point, there is another suit.
ಇನ್ನೂ ಒಂದಿದೆಯಾ?
ಇದರಲ್ಲಿ ಒಂದು ಸೂಟ್ ಅವರೇ ಕ್ಲಬ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದಾರೆ ಅದನ್ನ.
ತಂದೆ declaration on the basis of confirmation deed. Son declaration based on will. ಅದೆರಡು ಕ್ಲಬ್ ಆಗ್ಲಿ ಅಂತ ನಾವೇ ಒಪ್ಕೊಂಡು ನಾವೇ ಕ್ಲಬ್
ಅದು ಕ್ಲಬ್
ಒಪ್ಕೊಂಡ್ಬಿಡಿ ಏನೀಗ?
different.
This is partition suit between the family members.
So the plaintiff in OS number 500 is not our family member. He is asking for declaration of title in respect of the property.
Adral plaintiff has said no objection, but the defendant, they being the defendant.
That plaintiff in OS 500 sets up these people who are none other than his brothers-in-law.
Oh, correct. In-law versus in-law.
Yes. Therefore,
my lords, it is before the same court. Survey numbers are one and the same.
What can adile bide?
And joint family properties. We are
again clubbing ಆಗಿದೆಯಾ ಈಗ?
And the order is passed for clubbing without considering my objections, my lords, on the ground that the
ಆಯ್ತು, will declub it and direct to be taken together ಅಷ್ಟೇ. ಎಲ್ಲ ಒಂದೇ.
ಅಲ್ಲ ಏನಕ್ಕೆ ಅಂತಂದ್ರೆ my problem is that, my lords,
common evidence is to be led and the OS 500 is treated as the main matter.
If any adverse order is passed in 500, then once again a separate suit has to be filed. ಅದರಲ್ಲಿ ಯಾಕಂದ್ರೆ ಅದು ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಆಗಿದೆ ಅದು. ಇದರಲ್ಲಿ ನಾವು ಪಾರ್ಟಿಷನ್ ಕೈತೀವಿ. If it goes together, nothing will harm them.
Declaration and partition, think about it. Anyway, ಈಗ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
Allow ಆಗಿದೆ without considering our objections.
ಯಾಕೆ ಏನು?
It has been considered. That's what the order says.
Kindly see, my lords, the order at page 29. It's not even adverted to. My objections are not even adverted. The only thing there, the grounds objection is not sustainable. Page 29.
ಆಯ್ತು, ಕನ್ಸಿಡರ್ ಮಾಡಿ, ರೀಕನ್ಸಿಡರ್ ಮಾಡಲಿ ಅಷ್ಟೇ.
Let the order may be reconsidered.
ಅಷ್ಟೇ.
Because
notice to other respondents may be dispensed with.
On the other hand, my lords, it has also stated that they have considered the earlier order passed by this Amba court.
We'll see. I'm not disposing tomorrow.
Please.
2:30 ಗೆ ಬಂದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ tomorrow. Yes.
Please.
7.
Girish.
The respondent herein had filed a original suit against the petitioner.
You are judgment debtor.
I am a judgment debtor.
Yes. Delivery warrant.
Page 60. No, direct arrest warrant, my lord.
Direct arrest.
Please, my lord. Because my miscellaneous petition was dismissed for non-prosecution. I filed an application for staying the execution proceedings. Execution petition was pending. Unfortunately, miscellaneous dismissed. Immediately, the DHR brought the dismissal of the order. Suit for recovery of money, that is damages. Suit decreed for 7,25,000. Execution filed for 8 lakhs. My advance amount of more than 5 lakhs was with the DHR. So we tried to negotiate and settle it in the Lok Adalat. Somehow my amount is with them. I left the property. I was a tenant actually. So my 5 lakhs is with them only. So my lord, now my lord, page 67 warrant, my lord, issue arrest warrant.
Petitioner to serve on the counsel who represented the decree holders before the concerned court. List on 8th. Warrant of any kind hanging on the head of the petitioner shall remain state till the next date.
Grateful.
Next, yes. Sadanand.
Till number 8.
ನೀವೇ ಸರ್ ಸದಾನಂದ್ ಬನ್ನಿ. 10 ಈಗ ಇಲ್ಲ 8 ಸಾರಿ ಇರದೇ 8. Sadananda Ji Shastri andre yaru?
Honest.
Yes.
To appear for the petitioner in this matter, my lord. The CRP have filed, my lord, challenging an order, Annexure A, my lord, under Order 7, Rule 11, Subclause B. Suit is one for partition and separate possession, my lord. In fact, if your lordship recollects, your lordship had passed an interim order not to alienate the suit scheduled properties.
Page? No, it's not mine. Justice Shyam Prasad. Amala.
Page number 86, my lord. It's the order. And thereafter, your lordship had extended the interim orders.
That's
my lord.
okay.
Now, my lord, what happens is that, my lord, in the interregnum, your lordship passes an order, my lord, to try this matter before the trial court. The applications has to be considered. The trial court, my lord,
711 application.
Order 39, Rule 1 and 2, my lord.
1 and 2. Why the revision then?
My lord, what happens is, suit for partition and separate possession, initially the petitioner's file. Only emergent notice came to be issued. Thereafter, I filed GMCPC, my lord, WP. In that, my lord, I secure an interim order. My lord, thereafter, your lordship directs me to go before the trial court and get the applications adjudicated. In the interregnum, my lord, the respondent number 6 files an application under Order 7, Rule 11B, saying that in a suit for partition, my lord, I've undervalued the suit. Saying that I've asked for certain consequential reliefs of cancellation of certain sale deeds. That is incorrect, my lord. The trial court has considered that application first and has rejected by the entire plaint now, my lord.
Yes.
Under 35 subclause 1.
The petitioner shall serve on the council. Yaar, ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
15 ಜನ.
Council ಇದ್ರಾ?
Council for respondent number 10 and 6 are the contesting respondents.
Petitioner to serve on the council representing the contesting respondents who, according to the learned counsel of the petitioner, are respondents?
10 and 6.
10 and 6. They list the matter on 19th. Again, dismiss ಆಗಿದೆಯಲ್ಲ ಇನ್ನೇ?
ಹೌದು ಸ್ವಾಮಿ. Now, I have paid a fixed court fee, my lord, accordingly at 35 subclause 2. What the trial court...
12th, list on 12th. We'll
No, my
decide
lord, what is hurting me is that, my lord, I had the
Again
benefit...
problem.
I had the benefit of an interim order. Now the suit is dismissed, my lord.
Suit dismiss ಆಗಿಲ್ಲ, I will restore it. Unless I restore it, how is it? What interim order have you sought?
Now, my lord, kindly come to the order portion. Running page number 51.
35 will dismiss ಮಾಡಿರೋದಾ?
35 subclause 1 ನಲ್ಲಿ ನಾನು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಕ್ಕೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ಬಿಟ್ಟು
there shall be an interim order spread for till the next date. Yes.
Great.
Madam, ಇನ್ನೊಂದಿದೆಯಾ? ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇದೆ. Yes, ಕರೀರಿ ಮೇಡಮ್.
HP Leela, withdrawal.
Memo for withdrawal, Leeladhar.
Seal number 2.
Naveen Kumar.
M.
For petitioner, a suit for permanent injunction, my lord. By virtue of lease agreement, I am in the possession. But now the defendants are, my lord, whatever the crops which I have grown, my lord, they are destroying and unnecessarily they are interfering, my lord.
Injunction ಕೊಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ. They have issued emergent notice. At page number 53. Sorry, ma'am. 50.
Petitioner to serve on the respondents by way of hand summons and file an acknowledgement of such service, respond/defendants.
My lord, one thing.
List the matter on 18th, list the matter on 15th in preliminary hearing. There shall be an injunction as was sought for before the concerned court till the next date of hearing.
My lord, there was 2 IAVs filed. One not to alienate and not to interfere, my lord. But court did not.
Not to alienate ಯಾರಿಗೆ sir? Defendants ga?
Defendants. By virtue of lease,
ಹಾಗಾದ್ರೆ not to alienate ಕೊಡೋಣ.
Please, yes. But not to interfere. I mean, growing the crops, my lord.
So,
as and when they are interfering.
This defendant shall not alienate the property. If alienate ಯಾಕೆ ಬೇಕು? If you are in possession of the property, you are growing the crops. Why are you seeking not to alienate?
Well, now they want to create the revenue records and they want to save.
They want to create.
They have approached the revenue authority, my lord. For that, I have already filed an objection.
Yes.
But release deed is in existence.
Injunction. Yes.
Until and unless
First order matra. List on 15th and preliminary hearing.
And deliverable.
ಯಾಕೆ ಹ್ಯಾಂಡಲ್?
ಅದು 3ನೇ ತಾರೀಕು ಇದೆ. ಅಲ್ಲಿ they want to change the revenue records. That's why, my lord.
Next.
Please.
Preliminary hearing, seal number 3, PN Nanja Reddy.
Suit for?
Not suit.
Not suit.
Arbitration proceedings.
Non-suit. Yes.
That the arrest warrant has been issued.
Arrest?
Yes, madam.
JDR?
Yes, madam. page
ಎಷ್ಟು
11.
ಅಮೌಂಟ್?
ಅಲ್ಲ ಇದರಲ್ಲಿ arbitration petition is pending not before Bombay High Court. But there they are taking time. Here they have filed
Execution petition
Yes.
can be filed, sir.
There, my lord, they are taking time.
Can be filed.
That's true, my lord.
You should not permit them to take time.
Annexure D, my lord, proceedings before the Bombay High Court. Now, my lord, the notice was served on, my lord, 28th.
Where is the award of arbitrator?
Annexure B, my lord, award.
Page, what is the award?
Award payment of 15 crores. Plus interest.
Yes, sir. Yes.
Annexure D, my lord, is
ಈಗ ಏನಾದ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ you last may kindly say arrest warrant issue ಮಾಡಿ
Correct. ಈಗ
calling
stay-
up ಅಲ್ಲಲ್ಲ calling up on the opportunity ಕೊಡೋದು ಬೇಡ.
ಅಲ್ಲ ಈಗ ಕೊಡೋಣ.
ಅಲ್ಲಲ್ಲ.
ಸ್ವಲ್ಪ ಏನೋ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
ಅಲ್ಲ ಮಿಲಾಡ್ you last
15 ಕೋಟಿ ತಾನೆ.
let to milad whether milad the notice
ಏನದು? ಯಾವುದು ವಾಟ್ಸ್ಆಪ್
court
ಕಾಪಿ?
milad arrest warrant notice was issued calling upon the milad petitioner to appear.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಆಯ್ತು, ಈಗ ಏನಾದ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
ಅದಕ್ಕೆ otherwise application will be disposed of. The application I have not filed objections. On the first day itself milad the arrest warrant has been issued.
Will state subject to ಎಷ್ಟು ಒಂದು 1.5 ಕೋಟಿನಾ?
Last may kindly say
ಏನು ಕೊಡೋದೇ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ
ನಾನು.
ಕೊಡೋದು ಬೇಕಿಲ್ಲ.
ಬೇಕಿಲ್ವಾ?
Because of the milad proceedings, different proceedings. Annexure A.
Emergent notice to the respondent.
Milad, otherwise milad.
ಅಲ್ಲ ಕೊಡೋದ್ ಬೇಕಿಲ್ಲ ಅಂದ್ರಲ್ಲ.
Correct. 1310 ಗೆ appear
ನೀವೇ
again.
ಕೊಡೋದ್ ಬೇಕಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ನೀವು ದುಡ್ಡು ಕೊಡೋದ್ ಬೇಕಿಲ್ಲ ಅಂದ್ರೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡೋದ್ ಬೇಕಿಲ್ಲ.
Annexure D, you last may kindly see. Proceedings before they are taking time. They are milad the application for stay. When it is
List on 8th petitioner to serve on the council representing the decree holders before the concerned court and file an acknowledgement by day after tomorrow. A warrant of any kind hanging on the head of the petitioner shall remain state till the next date. ಅವತ್ತೆ ಅಲ್ಲಿವರೆಗೆ ಅಷ್ಟೇ. ಅದು ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು.
milad entry mart handle
ಕೊಡಿ.
court of.
Next.
4, Rakesh P. Bhatt.
Yes, Rakesh.
Suit for bare injunction, my lord, ex parte temporary injunction is not granted. Petitioner is the owner of the property, my lord. Annexure F, my lord, is photograph, building is there, my lord, page 75.
It will protect you till the next
Please,
date. Petitioner to serve on the respondent defendants by way of hand summons and file an acknowledgement of such service by 4th. Lest the matter on 8th in preliminary hearing. The respondents defendant shall not interfere with the possession of the property of the petitioner till the next date.
Hand summons by 6th.
ಎಲ್ಲ ನಾಳೆ.
Hand summons by 6th, my lord.
And 6th, all right, 6th. Hand summons by 6th, list on 10th ಅಂತ ಮಾಡಿದ್ದೇವೆ ಬೈ 8th ಬೇಡ. Next. ಅಮರ್ ಅಲೆಕ್ಸಾಂಡರ್. ಅಯ್ಯೋ ಏನ್ ಫುಲ್ ನೇಮ್ ಎಲ್ಲ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ನಾನು ಇದ್ಯಾರು ಹೊಸ ಅಡ್ವೊಕೇಟ್.
Requirement. Charge sheet for the offence under 364A and related offences. In fact, even at the FIR stage, Millards may approach this honorable court. Yeah, even producing the CCTV photographs that no such incident has taken place. And subsequently, Millards, we had withdrawn the petition. The check bounce case.
364 a life.
Life is there. Even death is there.
Death also, correct.
Even death is there. Otherwise maybe there was no need for me to approach this.
ಏನಿದೆ?
Not the allegation is, I have filed a check bounce case against the complainant. I know him since very long time. The check bounce case was filed in 2022. On the date of the incident, he had come to my house on his own and he has left my house on his own. Everything is captured in CCTV. And at the FIR stage itself, when they had filed the FIR, they had approached this honorable court along with the photographs as well, Millards. And the CCTV was available even at that stage. Now they filed a charge sheet saying that without even seizing the CCTV nor looking into the records, they filed, Millards, a charge sheet with the allegation that I had detained him in the house after kidnapping him and thereafter demanded the check amount.
Yes.
It has come to a stage I may not even know press for the check bounce case itself.
Let Jagdish look into it.
It's not for a stay of the.
No.
In fact,
364, yes.
May now submit this. The purpose for them filing this, Millards, the case itself is to initiate a rowdy sheet against me. Immediately thereon, now they.
Rowdy sheet initiate
Now
ಮಾಡಿದಾರಾ?
immediately they initiate the notice. You are even challenging this also, we filed a petition now.
ಅಲ್ಲ
Even challenging this.
ರೌಡಿ ಶೀಟರ್ಗೆ ನಾನ್ ಕಾಗ್ನೈಸಬಲ್ ಇದ್ರೆ ಸಾಕು. 364 ಬೇಕಾಗಿರ್ಲಿಲ್ಲ.
Even for that matter, Millards, ಅವರು ಥ್ರೆಟ್ ಕೊಟ್ಟು
ನೀವು ಅದರ್ ವೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು, ಇದರಿಂದ ಅದು ಬಂದಿದೆ ಅಂತ.
ಅಲ್ಲ, ಇನ್ಫ್ಯಾಕ್ಟ್ ನನ್ನ ಮೇಲೆ
ರೌಡಿ ಶೀಟ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಕ್ 364.
ರೌಡಿ ಶೀಟ್ 2 ಕ್ವಾಶ್ ಆಗಿದೆ, ಎಕ್ಸ್ಟರ್ನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕ್ವಾಶ್ ಆಗಿದೆ. Even at that stage, they had told me that we are going to initiate such proceedings against you even in future.
We'll take it, let him go through it.
Stay until then. For this reason, my lords, we have challenged even the notice issued to initiate rowdy sheet as well
That
against.
we will stay, not a problem, but not these proceedings.
Adu my lords separately, my lords, for a moment, my lords, to kindly.
No,
come.
let him, I'm not saying I will not
Next week,
consider.
any date. my lords, please.
List the matter on 12th. The learned counsel Amar Alexander Korea would submit that the petitioner is implicated in a case which does not have any ingredient of section 364A. All for the reason that a rowdy sheeter, the name of the petitioner is to be dragged into the sheet of rowdies maintained before the jurisdictional, register of rowdies maintained before the jurisdictional police. The learned additional SPP B.N. Jagdish is directed to accept notice for the respondent. But copy the respondent, complainant Amal Norna, learned additional SPP to go through the papers and make his submissions. No proceeding with regard to drawing the name of the petitioner in the register of rowdies shall be undertaken till the next date.
Please.
Yes. Huh? If not already printed.
Notice, I would as well have to submit, my lords. I have
No
not
notice
prayed
kottidare. Yes.
I have not prayed for stay of that notice.
No problem.
Please. Bye.
Till the next date. Yes.
Date was
12th. So Friday ಆಗತ್ತಲ್ಲ? ನಿಮ್ಗಲ್ಲ ಅವ್ರು ನೀವು ಇರ್ತೀರಾ ಇಲ್ಲಿ? Yes.
Hearing on IA, Seal number 1.
ಯಾವ್ದು ಮೇಡಮ್?
Pre-hearing, sir.
Requesting for extension of parole, my lords.
Offense.
Third on Mr. Rahul.
ರಾಹುಲ್ ಕರಿಯಪ್ಪ ಇದ್ದಾರೆ. Offense.
138, my lords.
ಇದು ನೀವು 6 ತಿಂಗಳಾಗಿರೋದು.
6 ತಿಂಗಳಾಗಿದೆ ಈಗ.
6 ತಿಂಗಳ ಆಚೆನೆ ಆಯ್ತು ಈಗ. ಏನು ಉಪಯೋಗ ಆಯ್ತು? ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ, ಇದು ಆಗ್ಲಿಲ್ಲ.
2 years punishment ಇದೆ.
6 months, 8 months ಇಂದ ಆಚೆನೆ ಇದ್ದೀರಾ? ಡಯಾಲಿಸಿಸ್ ಏನು?
Dialysis, chronic kidney disease with both lungs.
CKD dialysis.
Yes, my lords.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ವಿ ಲಾಸ್ಟ್ ಟೈಮ್? 60 days.
60 days, my lords.
ಈಗ ಒಂದು 30 days ಕೊಡೋಣ.
90 days.
ಎರಡು ಸೇರಿಸಿ.
Plus 8 weeks.
60 and 30. Yes. 60 days, same. Same order. Who is Nagesh sir waiting?
May I request?
Criminal appeals ಇದೆಯಲ್ಲ,
Short request.
ಟೈಮ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅವತ್ತು ಮುಗಿಸ್ಬಿಡ್ಬೇಕು. ಪೇಪರ್ ಬುಕ್ಸ್ ಎಲ್ಲ ಬಂದಿದೆ. ಐ ವಿಲ್ ಆಲ್ಸೋ ಲುಕ್ ಇನ್ ಟು ಇಟ್ ಬಿಕಾಸ್ ನೌ ಇಟ್ಸ್ ಆಲ್ರೆಡಿ 5 o'clock. ಸೊ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹಾಕೊಳ್ಳ 2:30ಗೆ ಆರ್ ಟ್ಯೂಸ್ಡೇ? ನಿಮಗೆ ಯಾವತ್ತು ಕನ್ವೀನಿಯಂಟ್ ಹೇಳಿ. ಅವರು ಇದ್ದಾರೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಮೇಡಮ್. 2 weeks ಇದೆ. ಪೇಪರ್ ಬುಕ್ ಎಲ್ಲ ಬಂದಾಗಿದೆ. ಅಪೀಲ್ ಅವ್ರ ಕೆಲಸ. ಎಸ್, ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ 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 ನೀವೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಅದೇನು ಒಂದಿನಕ್ಕೆ ಮುಗಿಯಲ್ಲ. ಎಸ್, ನೀವು ಡೇಟ್ ಆಫ್ ಯುವರ್ ಚಾಯ್ಸ್ ಸರ್. ಐ ಆಮ್ ಹಿಯರ್ ಸರ್ ಎನಿ ಡೇ. ಪ್ರಾಬ್ಲಮ್ ಇಸ್ 15th ಹಾಕೊಳ್ಳ? As we did on those cases, we'll start at 4 o'clock and end at 7 o'clock, provided it's not inconvenient to you. Yes, ತಮಗ್ ತೊಂದರೆ ಇಲ್ಲ ಅಂದ್ರೆ we'll start on 15th. All those criminal appeals. 4 ಗಂಟೆಗೆ ಸ್ಟಾರ್ಟ್ ಮಾಡುವ. We should, sir. Okay. Make a beginning. But he was telling we need not go into the merit of the matter if clubbing is considered ಅಂತ. ತಮ್ದು ಅದೇನ ಅಲ್ಲ, ಅದೇ ಸಬ್ಮಿಷನ್ ತಮ್ದು, ಇಲ್ಲಿ ಬೇರೆ ಆನ್ ಮೆರಿಟ್ಸ್ ಇದೆ?
ನಂದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅಲ್ವಾ?
ನಾನು ಮೆರಿಟ್ಸ್
ಮೇಲೆ. That's what. Yes.
Kindly recall your lordship memory when my lord has stayed the judgment of.
Yes, stayed, and also I said his name should not be removed from the constituency should not be notified for elections.
Even for admission also.
Yes.
This is a case under section 379 and 420.
Yes. No, I passed a detailed order in that.
Yes, detailed order. In fact, placing reliance on my lord's judgment, staying the judgment of conviction, the Andhra Pradesh High Court
mechanically reproduced a carbon copy of my lord judgment and stayed the judgment of conviction imposed upon Janardhan Reddy in Andhra Pradesh.
ಓ ಆ ಡೇಂಜರ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ ಅದು.
Like carbon copy, my lord's judgment came to be copied.
ಸರಿ ಸರಿ.
Avaga, my lord has heard me.
ಕರೆಕ್ಟ್. ಇದು ಲೈಟರ್ ವೇ ಸರ್ 5 o'clock ಅಂತ.
379 or 420.
Yes, yes. No, I remember having passed a detailed order staying the conviction and not notifying the constituency for elections. Yes, 15th, 4 PM, Nagendra Nayak.
But if my learned friend Mr. Nagendra Nayak were to satisfy your lordship that it, without even hearing this appeal.
That is
on
what he
merits,
says.
The matter needs to be remitted back, my lord, I have no objection.
That is what he says.
I have no objection.
That's why I asked that.
But I am not on that point.
But last 2 times in the, he has been telling that
Body,
only.
if my learned friend Nayak were to persuade your lordship to his line of thinking that the matter warrants remand, I have no objection for remand.
That's what I asked.
I have no objection. But if I am required to argue on the merits also, I am ready
Correct,
to
no
argue.
problem. Then should we hear Nagendra Nayak
I think
first?
it is better, my lord, because what is sauce to goose should be sauce to gander.
Yeah, correct.
ಅದು common judgment ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. If he persuades your lordship, I am happy.
ಆಯ್ತು 15th ತಗೊಂಡಿದ್ದೀನಿ, ಇವತ್ತು 1st September, ಇನ್ನು ನೀವು ಕೇಳಿದ 2 ವಾರ ಕೊಟ್ಟಾಯ್ತು. No, if that is the case, if you need not hear the petition whole hog
Yes.
and restrict it to that, we will see, we'll consider that. We don't know.
Two of the accused are common in our six.
ಅದರಲ್ಲಿ ಇನ್ನೊಂದು basic thing is that the principal case is still pending trial.
Yes.
It's still pending trial.
Yes, my lord, for 379, where a charge is there, ಇಲ್ಲಿ conviction.
Conviction.
ಹೇಗೆ?
One more thing, in COD, for the same material, they filed a charge sheet saying that it is a legal material. Here the finding is recorded that it is a stolen.
Probably Mr. Nagendra Nayak.
And the main matter 317 is still pending.
Pending trial.
He has filed another charge sheet saying that it is a valid material.
The court has not looked into all that.
Unless and until that.
The court has not looked into all that.
No, unless and until that case is heard and decided upon
Then how
conclusion
could
of trial.
convictions flow like this?
Presumption.
Of
Not beyond- not
of
beyond
innocence I had seen.
Not beyond all. ಅದು 106 ಮೇಲೆ 106 ಯಾವಾಗ ಆಗುತ್ತೆ ಅಂದ್ರೆ what the Supreme Court and your lordships have been termed again like first they have to establish the case, the offense against the accused, then my lord 106 could be pressed into service,
We'll see.
provided it is well within my knowledge as the accused, otherwise no.
We'll see, we'll hear.
Finding is given saying that it is a forest area, without stating from which forest area it is.
ಅಲ್ಲ ಅದೇ 379 ಪೆಂಡಿಂಗ್ ಇರೋದು.
The main case is still pending.
Right. Let's see. We'll start on 15th then. Then I'll begin to hear Nagendra Nayak.
Please, I'll also be here.
Of course, yes, sir.
Great pleasure.
Your presence is important.
In fact, last time my absence came to be noted, that is why.
ಬರ್ಕೊಂಡಿದ್ದೀನಿ, ಇಲ್ಲ ಆ ತರ.
ಅಲ್ಲ noted ಅಂದ್ರೆ your lordship noted.
Yes, where is sir ಅಂತ ಕೇಳಿದೆ.
ಕೇಳಿದೆ, ಅದಕ್ಕೋಸ್ಕರ.
Yes.
One small request, my lords. The registry may be directed to communicate by email to the central prison in the parole matter, my lords.
Parole ಅಲ್ವಾ? We'll get it uploaded itself.
Please.
ಇಲ್ಲೇ ಮಾಡ್ತೀನಿ. Extension of parole. ಇಲ್ಲೇ sign ಮಾಡ್ತೀನಿ.
I'm obliged.
ಚಂದ್ರಮೌಳಿ ಸರ್, ನೀವು ಯಾರಿಗೆ?
Number
41.
41, my lord.
39, 40 and 41.
In which list?
In list 2, my lords.
Why, did I call them? Then? It's time
Day
now.
after tomorrow is the hearing date.
Day after tomorrow?
Another co-accused, there is a stay.
Court is already like
482 na?
Court is already granted interim order.
1 minute,
for
1
of the
minute.
accused, my lord.
40?
39, 40, 41.
Court is
For
already
the
granted.
accused out of
39
the same
vacating
crime.
interim order. 40? Second list.
List 2, my lords.
Special order. 40, 41. What are these matters?
It's a matter of causing loss of 11,000 rupees to the government by providing stamp duty. This court has already heard the matter and the interim order has been passed as per A1 is concerned. Could you go up, sir?
ಜಗದೀಶ್ ಸರ್ ನೋಡಿದ್ದೀರಿ?
Okay.
ಲೋಕಾಯುಕ್ತದ?
Lokaಯುಕ್ತ.
ಯಾವುದು ಇದೆಯಾ ಮೇಡಮ್ ಫೈಲ್?
Next corporator, my lord, filed a complaint, resulted in a B report, my lord. Private complaint has been filed, fixing all the, my lord, chairman, IAS officers.
Where is my order?
It's produced. Is this produced?
Interim orders.
Interim order. How?
I will continue the interim order. What's the problem?
No, my lord. So far as the
Other
accused are concerned, they have come for the first time today before my lords.
Which one?
39, 40 and 41, my lords. A1.
Which are these matters?
They are the co-accused. The interim order produced is, my lords, of the accused number 1.
You are the co-accused here.
Accused number 2, my lords, 3, 4 and 5.
I think Lokayucta is not present or sir, first time bartara?
First time bartara.
We are 80 years old, petitioner.
The first petition, my lords. Number 39, he's 80 years old. He was the landowner. And we have a.
The petitioner shall serve on the council who represents the civil court. The learned additional SPP, Lokayucta, council Shri BB Patil is directed to accept notice for the first respondent, emergent notice to the second respondent. Adal sarvagidya?
Not yet.
Returnable by the 19th of September. List on 19th. The learned counsel for the petitioner submits that there is an interim order in granted by this court, que the co-accused. The interim order is as reads as follows: in the light of the interim order subsisting, que co-accused, these petitions also shall the said observation will inure to the benefit of these petitioners as well. In that light, there shall be an interim order as is obtaining in the aforesaid case. List them, tag these petitions and list them all on 19th. ಇನ್ಯಾವ್ದು ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋ ಮ್ಯಾಟರ್ ಇದೆ 480 ಯಾವ್ದಾರು
serial number 43 my lord
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು ಅಂಡ್ ಅರ್ಜೆನ್ಸಿ ಇರೋದು
covered by judgment my lord.
ಕವರ್ಡ್ ಬೈ ವಿಲ್ ಡೂ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಅರ್ಜೆನ್ಸಿ ಇರೋದು ಯಾವ್ದಾರು ಇದ್ರೆ ಹೇಳಿ.
42 my lords.
42
it is a fresh matter my lord listed in admissions.
What is the matter?
Matter 498A against the in-laws.
Against the in-laws.
In-laws.
ಕೊಡಿ ಮೇಡಮ್. The petitioners accused 2 to 5 are 2 to
2, 3 and 5.
2, 3 and 5 are before this court calling in question proceedings in CC 158 of 2024 registered for offences punishable under section 498A, 506, 323 read with 34 of the IPC. The police, a crime comes to be registered in crime number 116 of 2023 pursuant to which the police conduct investigation. The result of the investigation is drawing up of a charge sheet, summary of which reads as obtaining in column number 17 reads as follows, page 41. A perusal at the summary of the charge sheet would indicate that the allegations against these petitioners are omnibus, vague, and no allegation with regard to performance of any overt act against these petitioners. If further proceedings are permitted to continue in the said in CC so and so, it would run foul of the judgment of the apex court in the case of Kashkhan Kaushar versus State of Bihar, 2022 SCC online SC page 162. In that light, further proceedings shall remain stayed till the next date of hearing. 1 BN Jagdish, additional SPP. Emergent notice to the complainant returnable by 26th list on 26th September.
Lord, serial number 38 my lord.
50?
38 my lord. Second list serial number 38.
Idral stay ilva?
Illa my lord. And it's covered by your lordship's judgment my lord. My lord, based upon confession statement my lord, I have been implicated my lord in this case.
Yes, Jagdish sir.
Karnataka Education Act is involved.
Education Act. Next Friday. Learned additional SPP is directed to accept notice for the respondent. Copy the so and so list on 12th.
Serial number 87, list number 2, my lord. They have filed a memo for withdrawal.
Memo for withdrawal. 87, na?
Yes, my list number
87 withdrawn in terms of the memo. Now all other matters only dates.
Serial number 97, Your Honor.
Page wise, correct.
Your Honor, serial number.
I'll call page wise. I'll call page wise. Yes. Now first list in the Bunny madam.
This one.
Orders ಅಷ್ಟೇ ಉಳ್ತಿರೋದು. Serial number ಎಲ್ಲಿಂದ 80 ಕರ್ದೇ ಬಿಡ್ತೀರಾ? Yes.
82.
14%. 82 first list on ನಿಮಿಷ ಮಾಡಿ. ಮಿಥುನ್ PF name sir, name SK Venkatachalapati, learned counsel so and so undertakes to enter appearance for respondent 1 and 3 na 1, 2 and 3 2 and 3 registry to print the name of so and so as appearing for respondents 2 and 3. 1 yaru? Yes, Mithun served. The first respondent is served. Therefore, the steps, the issuance of services notice stands complete. List the matter for admission. Interim order idea? The learned counsel for the parties submits the talks of settlement between the parties are on. Therefore, list the matter on 19th. Yes, sir. In the light of the said circumstance, the respondent shall not precipitate the matter before the concerned court. Yes. 83 withdrawal.
84.
Allah, furnishing FPF. Memo hakidira? Oh, memo, madam. The learned counsel for the petitioners submits that the averment in the petition itself is to dispense issuance of notice to respondents 2 to 10. In that light, responds to notice to 2 to 10 dispensed with. One serve madidira. Counsel for the petitioner submits the counsel for respondent number 1 has been served. Office to verify. List the matter. Interim order idea? List the matter on 22nd. Interim order subsisting will continue to the next date of hearing.
The defendant petitioner, Lord.
This I have heard.
Hearing is
Reserve
already
it.
complete.
Yes. Diligent client.
Lord, it was our case that they've obtained orders before the trial court on false pleadings and have committed
All right,
forgery. Their only grievance was that we have not paid court fee. I'm providing evidence to show that on the date of filing itself, court fee was paid.
paid.
The only office objection, Lord, which was not complied but was actually overruled by your lordship, was that annexure K legible copy was not given, which we have not relied upon. Not your lordship may overrule.
You still stick on. Yes.
Yeah.
Take kodi.
Court fee, the evidence to show on the same date.
Take it on record. Reserved. Yes.
So grateful.
Yes.
86.
Maintainability. List on 8th. Yes. Big group ಎಲ್ಲ interim order ಇದೆಲ್ಲ. Big group ಎಲ್ಲ 2 weeks date ಕೊಡ್ತೀನಿ. Tax 1 minute. LA interim order will continue, sir.
87. 87.
One ನಿಮಿಷ. 87.
I appear for the petition of my lord.
There's an interim order.
Yes, my lord.
Yes, list after 2 weeks, interim order subsisting will continue to the next date of hearing. 88, list on 9th in preliminary hearing, mandamus disposed matter. Yes.
89.
Your lordship, in 89 appearing
Tax
for the
matter list on 18th. Yes.
interim
18th.
order to be extended, interim order to be extended. Your
Alva? Yes, list on 18th, interim order subsisting will continue to the next date of hearing.
Obliged.
Notice. 27 jana delay.
Date is on 9th, my lord. The trial court is already posted the matter for.
Delay.
I have served the copy to the other side who is already appearing in the.
Barli, list the matter. Yavat next?
9th ಗೆ ಇದೆ.
Al adjournment ತೊಗೊಳ್ಳಿ.
ಅಲ್ಲ,
trial court has taken the cross-examination, examination in chief, everything as in nil and posted the matter for arguments on.
List the matter on 8th. Yes. ಅಷ್ಟಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ ಕರ್ಕೊಂಬನ್ನಿ, ಇಲ್ದಾರೆ ಕೊಡಲ್ಲ.
Your Honor, serial number 15, list 2.
Wait,
Interim
madam.
order.
ಇದಕ್ಕೆ VC ಬೇಡ. Wait, madam. Yes. GMCP 8th Monday. Yes. Yes. Interlocutory ಬರುತ್ತೆ, preliminary hearing ಎಲ್ಲಿಂದ ಬರುತ್ತೆ. Yes. Interim order ಇದೆಯಾ? ಅವ್ರಿಗಿದೆ. Vacating stay ಹಾಕಿದ್ದೀರಾ? ಅದಕ್ಕೆ vacating ಅಲ್ಲಿ ಬರುತ್ತೆ. Wait. Yes. Today, but next time first vacating irutte. Yes.
92.
Petitioner, my lord, the respondent counsel is here, my lord. He's agreed not to push for the vacating of stay, my lord, maybe heard.
ಯಾರದು? ಹೌದಾ? ದಿ ಲರ್ನಡ್ ಕೌನ್ ಹಂಗಾರೆ ಯಾಕೆ ಇರ್ಬೇಕದು? Oh, sorry. The learned counsel appearing for the respondent who has filed his application seeking vacation of the interim order submits that he wants to soft pedal the application. Therefore, list this matter after 2 weeks. Interim order subsisting will continue till the next date of hearing. Ego ಹಾಕಿದ್ದ? Ego ಹರ್ಟ್ ಆಗೋಯ್ತು. ಇರ್ಲಿ ಬಿಡಿ, ಅಜ್ಜನ ಆಯ್ತು ಅಂದ್ರೆ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್. Further hearing dates ಕೊಡ್ತೇನೆ. 1 minute.
Number 2.
Fakirappa? Yes.
97.
He's in prison, is it? That's ಸ್ವಲ್ಪ.
96.
We'll take it. Madam, ಆಯ್ತು, ನಾಳೆ ತಗೊಂತೀನಿ. ನಾಳೆ ಆಗಲ್ಲ? ನಾಳೆ
List number 297.
ನಾಳೆ ಆಗಲ್ಲ.
List number 297.
ಒಂದು ಯಾರು ಲಿಸ್ಟ್ ನಂಬರ್ 297? 1 ನಿಮಿಷ ಸರ್, ಅದನ್ನ ಮುಗಿಸ್ತೀನಿ. ನಾಳೆ ಆಗಲ್ಲ ಮೇಡಮ್, ನಾಡಿದ್ದ ಆಗ್ಬೋದಾ? ಒಂದೊಂದಾಗ ಮಾಡಿ. 93 ಯಾರಿಲ್ವಾ? ನೇಗ್ಲೂರ್ ಅವ್ರಿಗೆ
93.
ಎಂಟ್ರಿ ಮಾಡಿದೆ ಮೇಡಮ್. ಓ, ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಪಾಲಜಿ ಆಕ್ಸೆಪ್ಟೆಡ್. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 93, 94 ಆಯ್ತು ಮೇಡಮ್, ಅದು ರೆಡಿ ಆಗಿರಿ, ನಾಡಿದ್ದು ಮುಗಿಸ್ಕೊಂಡು. ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು? ಇದಿರಲ್ಲ.
95.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇರಲ್ವಾ? ಮುಗಿಸ್ಬೋಣ. 95 ವಿಶ್ವನಾಥ್ ಸರ್ ಗೊತ್ತಾಯ್ತು. ಎಸ್. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇಲ್ಲಿ? ವೈ? ವೇರ್ ಇಸ್ ಪ್ರಸನ್ನ ಕುಮಾರ್? He was here ಅಂದ್ರೆ 1 ವಾರ ಇರಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವಿಲ್ ಟೇಕ್ ಇಟ್. ಅದ್ ನೋಡ್, ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿರ್ತೀನಿ. ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್ ಟು ಮಂಡೇ. ಎಸ್. ಥರ್ಸ್ಡೇ ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಥರ್ಸ್ಡೇ ಟ್ಯಾಕ್ಸ್ ಡೇ ತುಂಬಾ ಇದೆ, ಆಗಲ್ಲ. ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿರ್ತೀನಿ. ವಿಲ್ ಸಿ. Those will continue. Yes.
96.
96 also. 96 will take it on 8th. 8th at 2:30 ತಗೊಂತೀನಿ. Yes.
97, Your Honor, this third party execution, in execution petition, third parties are being added there and their properties are being confiscated. So
now 97 ಅಲ್ಲ.
List number 2, list number 2 will be 97.
GM slum. Yes.
Sorry, second list.
ವೆಂಕಟೇಶ್ ದಳ್ವಾಯ್. ಹಾಕ್ಬಿಡಿ ಮತ್ತೆ ಜಲ್ದಿ. ಅದು 12th ತಗೊಂತೀನಿ. ಲಿಸ್ಟ್ ಆನ್ 12th 97. ಶಾಂತಿ ಭೂಷಣ್ ಇದ್ರಲ್ಲ ಈಗ? ಎಸ್, ಅದನ್ನು 12th ಹಾಕಿ. ಸಾರಿ, 8th ಹಾಕಿ. ಅದು ಬೇರೆನ್ ಸಿಟಿಸನ್ ಅಲ್ವಾ? ಎಸ್.
That's number 2. Admission. 36.
ಡೇ ಅದನ್ನ ಹೇಳಿದ್ರೆ ಮತ್ತೆ 2 ವಾರ ಹಾಕ್ತೀನಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ Yes.
37, my lord. 37, I appear for the petitioner, my lord. The NDPS, my lord.
ಯಾವ್ದು covered ಅದು?
Covered.
ಅಲ್ಲಿ ಶ್ರೀದೇವಿ ಮೇಡಮ್ ಇಲ್ಲೇ ಇದ್ರಲ್ಲ ಯಾವ್ದು? She had appeared in that.
Please, ma'am.
Anyway, yes. Day after tomorrow.
Day after.
98 adjourn, 98 to 40, sorry, 38 to 42 adjourn, 43.
43, my lord, KP Act, my lord, your lordships have passed the proceedings in so far
KP
as-
Act?
Please, KP Act proceedings.
ಅದೇ ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ನು?
First time ಬಂದಿತ್ತು ಟ್ಯಾಗ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರೆ.
Notice ಆಗಿಲ್ಲ. List day after tomorrow.
In the fresh matter list.
Admissions.
Yes.
44.
44 ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. List on all CRPs on 19th. ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರೋದೇ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಮೇಡಮ್. All CRPs on 19th. And ಮೇಡಮ್ ನಾನು ಇಲ್ಲಿ ಡೇಟ್ ಕೊಡೋದು
73, my lord. I have served the hands on this.
ಆಯ್ತು, ರಿಜಿಸ್ಟ್ರಿಲ್ ಫೈಲ್ ಮಾಡಿ. ಎಸ್
67 and
Order
68.
All
65.
60.
5, sir.
14% received so and so. ಇದು ಮತ್ತೆ ಮಂಡೇ ಹಾಕಿರಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹಾಕಿ.
66.
ರಾಜಶೇಖರ್ 12th
67.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
67 and
12th ಆಗ್ಬೋದಾ? 12th, yes.
67.
67 and 67 and 68, my lord.
Ah.
I'm appearing for the petitioner, my lord. Murga Mata case, my lord. ಇದು already
ಇದು ಸ್ಟೇ ಆಗಿದ್ಯಾ?
victim
ಡೈರೆಕ್ಷನ್ ಇದೆಯಲ್ಲ ಮತ್ತೆ? ಮತ್ತೆ
my lord. 311 application.
ಎಲ್ಲಿ ಇವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್
2 to 4, my lord.
ಎಲ್ಲಿದ್ದಾರೆ? ವೇರ್ ಇಸ್ ಈ? ಸ್ವಾಮಿ ಎಲ್ಲಿ?
Swami is not in station, my lord. Kindly have it on next week, my lord.
My lord, short date anyway.
ಲಿಸ್ಟ್ ಆನ್ 8th.
My lord,
Finally.
on 10th or 11th, my lord, because we have prepared the objection, my lord. I will-
ಅದೇನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಇಂದ ಪ್ರಿಪೇರ್ ಮಾಡ್ತಾನೆ ಇದ್ದೀರಾ?
Ready, I will serve the copy and,
ಸರ್ವ್ ಮಾಡಿ.
tomorrow, my lord. Kindly have it on.
ಲಿಸ್ಟ್ ಆನ್ 10th ಫೈನಲಿ. Yes.
230, my lord.
both ಇದು ಮೆನ್ಷನ್ ಮಾಡಿ ನಜೀರ್. Yes.
69.
60 CRP ಅಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲ 19th. Furnishing of PF. 2 weeks time is granted to do the needful. Learned counsel for the petitioner submit needful has been done, office to verify. 70.
Appear for petitioner, my lord. Trial court counsel ಗೆ
ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ಮೇಡಮ್?
ಕಾಪಿ
Copy
ಸರ್ವ್ ಮಾಡಲಿಕ್ಕೆ
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಪರ್ಮಿಷನ್ ಬೇಕು ಮೇಡಮ್.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಪರ್ಮಿಷನ್ ಬೇಕು ಸರ್.
Permission ಬೇಕಾ? Learned counsel for the petitioner to serve on the counsel who represents the unserved respondents before the concerned court. Permission granted. ಈಗ ಸರ್ವ್ ಮಾಡಿ.
71, my lord, I am appearing for the petitioner. My name is not shown in that.
We will show it, sir.
I have
Yes.
served the one more submission, my lord.
Ah.
The lordship has granted the interim order.
We'll continue it, sir.
No, there is one problematic situation. my lord.
Problematic.
Yes, your lord, because execution proceedings are parallelly going on, my lord.
Oh.
They have, upon the ex parte judgment and decree, they have filed execution petition. Simultaneously, I prepared a miscellaneous petition for restoration of the original suit, my lord. It was a lot that is appealed before this honorable court in this instant CRP.
ಯಾರು petitioner ಯಾರು?
CRP.
There is a 4.5 delay in filing the
Restoration is-
certificate. There is no continuation of delay
My
application.
lord, I have
The
evidence
evidence is
of
late.
the Supreme Court.
3.5 years delay.
No, my lord, I have, what they say, the learned civil judge.
ಆಯ್ತು ಬನ್ನಿ. List on 12th, yes. In, huh? There is no fresh admission CRP, fresh element.
No,
Yes.
execution is pending, my lord. That is
No problem, yes. Registry to print the name of
Mashkoor Hashmi.
Imran Hashmi.
No, my lord.
Mashhoor Hashmi. Oh, yes. Print the name of Mashhoor Hashmi as appearing for the respondent. List the matter on 12th. Yes. Interim order subsisting will continue till the next date of hearing.
72.
ಎಲ್ಲ 12th. List the matter on 12th. Yes. Furnishing of PF ಅಂತ ಇದೆ? All right. ಮೆಮೊ ಹಾಕ್ಬೇಕಲ್ಲಪ್ಪ, ಆಮೇಲೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ. A week's time is granted to do the needful. List on 12th. Next.
73.
Serve the copy.
Learned counsel submits needful has been done. Office to verify list on 19th. Interim order idre continue. Yes.
74,
Same order.
75,
Rectification so and so. A week's time is granted to do the needful.
76,
For the petitioner, my lord. This is the case where 1/3 compensation was withheld by KIDB on the ground that my stepsister had filed a partition.
Oh, correct. Yes, 76 list.
It's ready, my lord.
List tomorrow agalla. List on 9th.
Much obliged.
Yes. 9th list on 9th in preliminary hearing anta. Close ಮಾಡೋಣ. Yes.
77, dispose 78,
ಯಾವುದಕ್ಕೆ ಸರ್? 77 ಡಿಸ್ಪೋಸ್ ಆಗೋಯ್ತು, ವಿಡ್ರಾ ಮಾಡಾಯ್ತು. ಎಸ್. ವಿಡ್ರಾ ಆದ್ಮೇಲೆ ರೆಸ್ಪಾಂಡ್. ಎಸ್. ಎಸ್. In terms of the memo dispensed with. Interim order idea. List after 2 weeks. IO next. 79. A week's time is granted. Do the needful.
80,
Same order. Memo ಹಾಕಿ ಹಂಗೆಲ್ಲ ಆಗಲ್ಲ. Yes. ಕೊಡಿ memo. 3 to 8 dispense with in terms of the memo. Serial number 80. Interim order continued for list after 2 weeks. Next.
81,
Post immediately after service of notice upon the third respondent. Interim order continue ಮಾಡಿ.
82,
A week's time is granted to do the needful. Next.
83,
Same order.
1 to 3, my lord.
Same order. Yes.
ಇದರಲ್ಲಿ R4 to 40 notice dispense ಮಾಡಬೇಕು.
Registry. Yes. 84.
84,
A week's time to do the needful. Next.
85,
Earlier roster. Interim model change ಆಗ್ಬೇಕಾ? List day after tomorrow in day after tomorrow ಮಾಡಂಗ್ ನೆನ್ಪು ಮಾಡಿ. Day after tomorrow we'll close it.
86,
ಏನಾಗಿದೆ? Interim order is not maintainable. So correction is not maintainable. Correct. ಏನು ಸೀರಿಯಸ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ರಿ? Interim order maintainable ಅಲ್ಲ, correction ಹೆಂಗ್ ಸಾಧ್ಯ? There shall be interim order of stay subject to condition. Subject property. Why did you get him, madam? 93 years. Love and affection ಇರ್ಲಿಲ್ವಾ? Then see, love and affection ಇದೆ, 10,000 ಕೊಡ್ತಾ ಇದ್ದಾರೆ. Yes, madam. ಆ ಕಡೆ ನೋಡಂಗೆ ಇಲ್ಲ, ಈ ಕಡೆ ನೋಡ್ಬೇಕು ಅಂತ. ಹೇಳಿ. ಆಯ್ತು. ಆಯ್ತಾಯ್ತು. Yes. All right. We'll send it back to the roster. ಆಯ್ತು. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಈಗ ನೋಡಿದ್ರಲ್ಲ, ಚೇಂಜ್ ಮಾಡಕ್ ಆಗತ್ತಾ? ಆನ್ಸೇ ಇಲ್ಲ. List the matter for being spoken to day after tomorrow. ನೀವು ಅವತ್ತು ಮಾತಾಡೋಣ. Yes. Being spoken to. Yes. Learned counsel submits needful has been done, office to verify. No, sir. Interim order idea? List after 2 weeks. Next. 87 in terms of the memo withdrawn.
88,
Post immediately. 88 memo for document. needful to be done in the next 1 week. Yes, 89 post immediately after service of notice. ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್ ಅದು ರಿಜಿಸ್ಟ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಈಗ ಎಲ್ಲಿದೆ ಟೈಮ್? ಎಸ್ ಎಂಟ್ರಿ ಮಾಡಲ್ ಕಂಟಿನ್ಯೂಸ್. ಎಸ್ 90 kindly give a memo, madam. Yes, in terms of the memo. Yes, interim order idea list after 2 weeks. Interim order subsisting will continue to the next date of hearing. Next.
91.
Yes, 2 weeks to do the needful. 92, same order.
53.
Same order.
94.
Post immediately after service of notice upon respondent 1 to 3. Interim order idea, Vagesh? Continue. Yes.
95.
Weeks time to do the needful. Interim order will continue. Continue. 96, same, yes. 97. Non-compliance of office objections. First time barta irada? List day after tomorrow in preliminary hearing. Yes, next.
98.
Post immediately after service of notice upon respondent 1 to 4. Weeks time to do the needful.
100.
Same.
101.
Yan ishtondide madam? B group. Interim orders will continue wherever it is.
I did 8 months.
No interim order. Will continue that also. Yes.
101.
101. Learned counsel submits needful has been done. 8th in preliminary hearing. Next.
102.
No 8th. Yes.
103.
ಹಂಗಾರೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅರ್ಥ ಇದ್ರಲ್ಲೆಲ್ಲ ಹಂಗ್ ಕೊಡುವಂತ ಕೇಸ್ ಅಲ್ಲ ಬಿಡಿ. List on 8th. Yes.
104.
A week's time is granted to do the needful.
105.
Learned counsel submits needful has been done. Office to verify. Interim order will list after 2 weeks. IO. Yes, next.
106. 107.
2 weeks. Start ಮಾಡ್ಬಿಟ್ಟಿದಾರ? ಮುಗಿಲಿ ಬಿಡಿ. List on interim vacating stay ಇದೆಯಾ ಮೇಡಮ್? ಇಲ್ಲ. List the matter on 10th.
108.
For the petitioner matters, office objections have been complied with.
List the matter on 12th.
I only be extended.
Interim order ಇದೆಯಾ? Yes. You are a tenant? Yes. List the matter on 12th. Office objections? In? Learned counsel submits office objections has been complied with. Office to verify. Yes. B group karibedi. B group ella will give date.
One submission, 132 elections. It is posted on 38 euros.
It will come.
It is posted on 38.
I also can take ಎಷ್ಟು ಮ್ಯಾಟರ್ ಆಗುತ್ತೆ ಅಷ್ಟು ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ.
ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಡೇಟ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ರಿಕ್ವೆಸ್ಟ್ ಓನ್ಲಿ ಫಾರ್ ಡೇಟ್. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವೆಕೇಟಿಂಗ್.
ಎಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಅವತ್ತು ಬರುತ್ತೆ.
May I make one submission, my
Serial
lords?
number 118, my lord.
Serial number 141, my lords.
Serial number 118, my lord.
Number 241.
There's a written objections we have been trying to file.
File it.
Direction is required.
But written objection file ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಯಾಕೆ ಬೇಕು? ರಿಟರ್ನ್ ರಿಸರ್ವ್ ಆಗಿದೆಯಾ? Then
They are suggesting that. Otherwise,
file 38 counsel for the petitioner respondent. Counsel for the first respondent seeks to file written submission. Same is taken on record. ತಗೊಂಬಿಡಿ ಮೇಡಮ್.
serial number 33.
ಮಿಕ್ಕಿದೆಲ್ಲ ಡೇಟ್ಸ್.
Serial number 33.
May I make one submission, my lord? Serial number 141.
ಎಲ್ಲ all of this interim orders will continue. Please don't panic about it.
One submission, please.
My lord, third list, my lord. Third list, serial number 8, my lord.
All of you silence. He is here for some purpose. ಅಷ್ಟೇನಾ? That is why you are here. So be here.
My lord, serial number 118.
ಆಗುತ್ತೆ ಬಿಡಿ ಸರ್.
Serial number
My
33.
lord, further hearing matter 141, serial number, my lord.
I mean, the complaint.
The complaint filed against my advocate, my
One
lord.
matter, my lord, with CBI.
Oh, that steel hypermart.
Yes,
ಅದಿದೆಯಾ
my lord.
ಇವತ್ತು?
Yes, my lord. Serial number 33, my lord.
Which is that, sir?
List 3, serial number 33.
Madam, ಆ ಸ್ಟೀಲ್ ಹೈಪರ್ ಮಾರ್ಟ್ Post it on, we'll take it on 8th, remind at 2:30.
8th senior counsel, 9th.
9th,
9th or 10th.
9th at 2:30 ಹಾಕಿರ್ತೀನಿ, make a mention. Yes, because Supreme Court,
number 118
Supreme Court ಇಂದ ವಾಪಸ್ ಬಂದಿರೋ matter ಮಾಡ್ಬೇಕು.
Serial number 118.
My lord, list number 3, my lord.
Madam, 132, madam.
Madam.
What I see?
Court officer, she's there, no?
1 minute.
Court officer?
Court officer has disappeared already.
Okay, give me a call. Is she logged off or something?
Court hall is disconnected.